Beautiful.
All right. Are we on the record? We are? Yes. Okay. Excellent. Good morning, everyone. We are back for day 2 of the presentation of evidence for shorthand, Lavone versus Floshea. All our jurors are here and are ready to come in. Mr. Sterling, we are still in the presentation of plaintiff's case. Do you have anything we need to talk about before the jurors come in?
No, Your Honor.
Okay, and if Commissioner Abdur-Rahman's not right outside, you've got another witness.
She's here. Your
She's
Honor.
here,
Yes.
so that's who you're gonna start with.
Yes, Your Honor.
Okay, Mr. Williams, anything we need to talk about before the jurors come in?
No, Your Honor.
Let's bring them in, please. Don't you have some other things to be doing today? Just a little bit? Just a little bit? You got word, I hope, maybe through Ms. Kirby, that the 31st is the groundbreaking.
So it is the 31st.
It is the 31st. It's gonna be around lunchtime. I need to be there. Thank you, Deputy Gordon. Good morning, ladies and gentlemen. You all can be seated. Look at that. That's very perky. Welcome back. Happy Wednesday. Thank you for being on time. We were on time as well. Had to talk about a couple things, and we're getting started before 9:10, which is phenomenal. Hopefully MARTA worked, and the shuttles and the magnetometers are the magnetometers. I don't control that, unfortunately. But I guess it means fewer forks and knives get in the building that shouldn't come in the building. We are continuing with plaintiff's case. So Mr. Sterling, I will ask you to call your next witness.
Yes, Your Honor. Plaintiffs will call Commissioner Khadija Abdul-Rahman at this time.
Great. Come on up, please.
Yes. My name is Commissioner Khadija Abdul-Rahman, Khadijah Abdur-Rahman.
When you're ready.
Thank you. Can you tell us what you're a commissioner of?
I'm Fulton County Commissioner of the Mighty 6th District. It's a district in Southwest Atlanta and South Fulton.
Not the 6th, the mighty 6th.
And Commissioner, how long have you held that position?
Since 2021.
And what parts of your district does that include?
That includes Southwest Atlanta, City of South Fulton, Cascade area, coming up into Southwest Atlanta, going up all the way to, I want to say a little bit past Georgia Tech.
And as a part of your duties as commissioner, do you regularly interact with business constituents within the district that you represent?
Yes, I do.
Are you familiar with Floshea at the Point?
Yes, I am.
And are you familiar with Lavone LLC?
Yes, I am.
Did there come a time where you interacted with both of these parties?
Yes.
Can you tell us about that? What happened?
What happened was I received a phone call from a constituent. They had an issue with, they had saw some movement on their actual system, their camera system in the business. And so they called me because they said when they went up to see what was going on, that they were barred from coming in. They saw that someone was there keeping them from getting their stuff. And so the concern was that it was the APD officer, okay?
I'm sorry, I just want to set the time frame.
Okay.
Was this in 2022?
Yes.
And was the constituent who contacted you, was that Thomas Lavone LLC? Mr.
Yes.
Woodard and John Wesley City, am I right?
Yes. And I'm sorry, go ahead. So that was Friday. And so they had explained that they didn't know anything about an eviction. They didn't know what was going on, but there was an APD officer there. And so that barred them, and I immediately had a concern with that because the APD officers are only supposed to be there just to make sure everyone's safe, not to bar a person or whatever. So the initial conversation I had with them was to give me the APD officer's name, let me see what I can find out, and to also see if there was an eviction, anything in the court record to see if there was anything going on. That was Friday. Over the weekend, Monday morning comes up and they called me before I could get here to see if anything was going on. And they said, hey, we're here. A bunch of APD officers are here. They're being rude. We can't get our stuff. We see them getting our stuff. Can you please come and, let us, tell us what's going on? So I immediately come to the location to try to see what's going on. When I get to the location, they're on the outside of the location. Locks have been changed and some of their stuff has been taken out. I actually saw it in the wagon. And so as I began to ask the APD officer, what's going on? The APD officer said, well, we're not here to get in the middle of this. We're here just to make sure that, nobody gets hurt. I said, well, is there eviction? Can you tell me what's going on? So by that time, one of the, I can't remember which one it was, but he started kind of being overcome. He needed water, so I gave him assistance. I sent my chief of staff to try to see if they could get the owner so we could see what was going on.
I'm sorry. And when you say get the owner, are you referring to Ms. Shay Embry?
Yes. And so at this point, I'm trying to make sure, the constituent is okay and everything. And so what I'm asking the officers is this an eviction? What's going on? I'm here trying to figure out what's going on for them because they were highly upset. One was almost, to the point that he was about to pass out. And so at some point, my chief of staff goes in and talks with Miss Shay and try to see what's going on. I'm talking to the police officers outside and I'm trying to see what's going on. And so what's said to me and the police officers is that the lease allows them to do what they just did. So at this point, I'm trying to, mitigate. I'm trying to say, well, just let them get their stuff. And so we're waiting. And so the police officer, I can't think of the deputy chief that came out eventually, because you're talking about 2 hours that I stayed out there with them. So there was an understanding that they would be able to get their stuff. And so I'm waiting on scene for them to be able to get their stuff that I physically saw being carted away. And there was a conversation that, okay, we're going to let you get your stuff. So I said, well, I'll wait with you to make sure you get your items. The police officer comes out. He says, just hold up. They're going to let you get your stuff. Okay. So at some point, 1 hour becomes 2 hours. So we call the police again. I personally call the zone, the zone captain at that time, just to kind of figure out, are they going to be able to get their stuff? Because I don't want to leave them, but I got another event that I got to get to. So trying to figure out what's going on. I'm standing there with them, waiting for them to get their stuff. So at some point, nobody comes to bring them their stuff. So then I asked for another officer to come out. Another officer comes out. I said, okay, not sure what's going on here. Not a police officer, but I am the county commissioner. I said, these individuals were told they were going to get their stuff. I was led to believe that they were going to get their stuff. Doesn't look like they're going to get their stuff. So they want to take a police report because at this point, it's a theft. At least that's what we're looking at and assuming that it is. And so the police officer says, well, I'm going to need you to come to the precinct to fill out the police report. And so we're waiting. Finally, somebody in the upper brass comes out. He states to me, and I'm sorry, his name escapes me right now, but he states to me that there has been an eviction. They can't get in the middle of it. He was told that the gentleman was going to be able to get their stuff. But at this point, I think we're on maybe even hour 3. Their stuff has not been given to them. So they were directed to go to the precinct, fill out a police report, and find whatever their legal remedies are.
No further questions, Your Honor.
Mr. Williams, any questions for Commissioner Abdur-Rahman?
No questions, Your Honor.
Mr. Brickman, okay. I've got one. Commissioner, how often, I know your job has many roles and responsibilities, and I'm learning about a new one today. How often would you say you are called to the scene of a crisis like this? I mean, there was a dispute, and I wouldn't think to call my county commissioner. I would call the police, or if I felt law enforcement was necessary. How often do you find yourself getting pulled into the middle of a domestic dispute or a business dispute while you're trying to go about doing the rest of your job?
Well, ironically, I get called quite often. And even though my district is on the south side, I get calls from Johns Creek all the way to Palmetto. And so, I'm an elected official for one district judge, but as a Fulton County taxpaying citizen, I serve all the citizens.
Sure you do.
And so whenever there's a need and someone calls, I try to see if I can resolve it or get them to where it can be resolved. So for me, I get quite a few calls.
Okay. So this wasn't out of the ordinary.
No, it wasn't.
This happened to be a constituent, a direct constituent.
Exactly.
But it's not out of the ordinary that your staff is, hey, we need Commissioner Khadijah, cat's in the tree, there's a dispute about property, whatever the issue is.
Yes, sir.
Okay. All right. Jurors, do you have any questions? Okay. Deputy Gordon, if you could collect those. Yeah, I saw that. That's why I said Deputy Gordon's going to come collect them. Thank you. Counsel? Not right now. All right, a couple more questions, then we'll get you on your way. The timeline, you mentioned a Friday. How many times do you recall going out to the location where the store was? One time, two times?
One time.
One time.
Mhm.
And your recollection is that you came out on a Friday or a Monday?
I came out Monday.
Monday, okay. And when you were out there, that was when you could see property from inside the store being removed, not by the tenants of the store?
Yes, that's
Okay.
correct, Judge.
Got it. And so the hours that you were there interacting and waiting, that was all Monday?
That was all Monday.
Okay. Do you know if either of the tenants ever filed a police report?
I don't know. They were instructed to, but I don't know if they did.
Great. Any follow-up, Mr. Sterling?
Just briefly, Commissioner, you received a call on Friday about the issue, is that right?
Correct.
But you didn't go out until the actual Monday when the items were being removed.
Exactly.
Okay, thank you. I just wanted to clarify that, Your Honor.
Sure. Mr. Williams or Mr. Brickman?
None, Your Honor.
All right. Thank you, ma'am, for your time and your service. You are
Thank
free to go. Good luck today.
All right. Have a good day.
Mr. Sterling, next witness.
Plaintiffs will call Donovan Dodds to the stand, Your Honor.
Raise your hand. You swear affirm that testimony you will be able to be true, the whole truth, and nothing but truth and office. Still on the hand. State and spell your name for the record.
My name is Donovan Dodds, Donovan. Last name Dodds, Dodds.
Mr. Dodds, what do you currently do for your professional occupation?
I'm a freelancer.
Freelancer of what? That's a big topic. Freelance writer, freelance assassin, freelance, but hopefully not assassin. That would be awkward.
Community engagement.
Community engagement.
Yes.
And without giving me your exact address, what part of town do you live in?
Southwest Atlanta.
Do you play a role in community leadership in Southwest Atlanta?
Yes, I am currently the chair of Neighborhood Planning Unit R in PUR.
All right, tell us a little bit about what a neighborhood planning unit is.
Yeah, so a neighborhood planning unit is kind of under city council. Each city council district has about 3 or 4 NPUs, and those are neighborhood planning units. Those are kind of constructed to do business on behalf of the city and to represent constituents. So it's kind of that liaison piece between government entity and community.
As a part of your role in community leadership, do you ordinarily interact with business constituents within your community?
Yes.
Are you familiar with Floshea at the Point?
Yes.
Are you familiar with Lavone LLC?
Yes.
Did there come a time where you got involved in your role with those two organizations?
Yes.
Can you tell us a little bit about what happened?
Yeah, absolutely. So I was notified that Thomas Lavone was having some issues. And so I was called to help kind of mediate those issues and try to see if we could come to some type of resolution on what was going on. And so I came in hopes to assist, to stop. I saw that their things were being taken out of their store. And so I got a little bit of background information on exactly kind of what was going on. And yeah, I tried to be there to help. At that point in time, I started contacting people that I knew through the NPU and through the proper ranks in the city in order to get some assistance.
How many times did you go out? Do you remember how many times you actually went out to or let me ask you this, did you ever go out to the location itself?
Yes, absolutely.
Do you remember how many times you went out?
Twice.
When was the first time, if you can recall, when you actually went to the physical location?
You mean during the incident, or are you talking about just in
No, I'm sorry. Yeah, during the incident between that you were trying to mediate between Thomas Lavone LLC and Miss Embry Floshea at the Point.
Yeah. So the first time that I went out there, that morning, or I heard that obviously that they were given this piece of information about having to be out by a certain time. And so I was called and notified that, okay, their stuff was being removed from the building. And at that point that I got dressed and went up there.
Do you recall being involved in a meeting with Ms. Embry, Mr. Flournoy, my client seated to my right, and police officer regarding how much time they would have to remove their things?
Absolutely.
Do you recall what time frame or what timeline they were given for when they would have the ability to remove their things before everything was changed?
Yes, yeah, they were told that they were going to be able to, I think it was 4 o'clock, that they said that they would be able to come in and remove their things by then.
And were you there? I think you said, were you there on the day when things were being physically taken out?
Absolutely.
And
And you got there because someone reached out to you, or you just happened to be at the point and saw what was going on, or how did you know to be there?
Oh, yeah,
That-
they reached out to me.
They meaning the tenant, either Mr. Woodward or Mr. West.
Yes.
and so my clients reached out to you hoping for some mediation or some help.
Right, some assistance, exactly.
And what did you do, if anything, what did you do when you were there seeing the stuff being removed to try to help?
Yes, I was talking and I was trying to get an understanding for exactly what was going on, because to my knowledge, things shouldn't happen in that manner. Cascade and Cascade Heights in that area is generally a very loving community. And so I was really distraught to see kind of what was happening. And so really my thing was just trying to mediate, okay, well, let's see, is there a time frame? Is there a way that things can be removed? Is there a way that they can get their belongings? Kind of what could happen? And then when I saw that wasn't happening, that's when I reached out to some of my contacts at APD and started kind of leaning on my own knowledge of city process and how I could better assist.
And at that point, was the objective simply for them to try to get their things back? Or-
Yeah, absolutely.
No further questions, Joe.
Mr. Brickman?
Yes. Morning, Mr. Dodds.
Morning.
Thank you for your patience. I know you were here yesterday and
Absolutely.
we appreciate it. Just a few questions for you. So you're not a party to this suit, correct?
No.
And you're not a party to the lease agreement between Floshea and Thomas Lavone, correct?
Correct.
So you haven't studied the contents of that lease.
I did receive a copy of the lease.
And you were able to look through it?
Yes.
Okay. Do you mind pulling up the lease, please? I think you've got the exhibit finder in front of you. Could you please go to D1? It's the first tab. Thank you.
Okay.
And if you could please turn to page 15.
Okay.
So you did have an opportunity to read over this lease, Mr. Dodds,
Yes.
and you recognize then this page 15 of the lease about default.
Yes.
Okay, so I'm going to direct your attention to section 10.1, labeled default by tenant. So I'm going to read this out loud. Each of the following acts or omissions of tenant or occurrences shall constitute an event of default. Do you see that?
Yes.
And could you please read for me subsection A?
A failure or refusal by tenant to pay base rent, additional rent, or any other payments here under when due.
Okay, so as a basis or event of default would be failure or refusal to pay base rent, additional rent, and other payments, correct?
Correct.
Okay, and could you please look down at section 10.2? And that's labeled landlord's rights on default. So following one of these events of default, as you know, since you've read through this, there's landlord's rights based on that default. Do you see that?
Yes.
Okay, and could you please read that first paragraph as well as, actually just the first paragraph, please.
Upon the occurrence of an event of default, landlord may be at landlord's option without any notice or demand whatsoever. Any such notice and demand being expressly waived by tenant in addition to any other remedy or right given hereunder or by law or equity, do any or more of the following.
Okay, so landlord's rights based off of an event of default are listed in subsections A, B, and C. And those sections include language saying terminating the lease, entering and taking possession, and altering locks and other security devices. Is that correct?
Yes.
And could you please go to the next page, page 16? And I'm going to direct you, I know it's small print, in the middle of this first paragraph on page 16, where it says, tenant hereby consents.
It's also on the screen if it's easier to use. I don't know if you can read the small print in the binder, Mr. Dodds, that's great. But that screen in front of you, you can make those two things go away and you'll see it on the screen if you'd rather read it on the screen.
You're
good with
Yeah,
the
I'm good with
hard copy? Okay.
You see where it says that, Mr. Dodds? Tenant hereby consents, comma.
I don't actually.
Okay, it's preceded by the sentence, no such alteration of security devices and no removal or other exercise of dominion by landlord over the property of tenant or others at the demised property or premises shall be deemed unauthorized or constitute a conversion. Could you just read that sentence for me right after that? And if you can't find it, it's okay.
Yeah, I'm sorry.
Okay, well, just for the record, same subsection that you've reviewed already says tenant hereby consents after an event of default, which we've discussed, to the exercise of dominion over tenant's property within the demised premises.
Okay.
Nothing further.
No redirect, Your Honor.
All right. Any questions from the jurors for Mr. Dodds? Seeing none. Thank you, Mr. Dodds, for your time. Appreciate it.
Thank you.
Next witness.
Call Dana Dodd at this time, Your Honor.
Not an S on the end or also?
Also an S.
Also an S.
Dana Dodd.
Okay.
I apologize.
This will require that testimony will be able to be true, the whole truth, and nothing but truth so help.
My name is Dana Davis Dodds, D-A-N-A, D-A-V-I-S, D-O-D-D-S.
Ms. Dodds, can you move the microphone a little closer to you, please? There you go. Great. Thank you.
Yes.
Ms. Dodds, what do you currently do for professional occupation?
I work at the city of Atlanta for city council,
And how long have you done that?
10 years.
As a part of your duties, do you, are you related to Donovan Dodds?
No,
Oh, okay. Is yours D-O-D-D?
I'm D-D, not B-B.
Oh, okay. All right. So I had it wrong, Your Honor.
He was B-B, no S.
She's D-O-D-D.
Mhm.
So you're D Delta or B Bravo?
D's in Delta, D-O-D-D.
Okay. And then that gentleman was D-O bubble S? Okay. I didn't hear it that way. All right. The record will need to be corrected by Madam Court Reporter that it was Donovan D-O Bravo S. And here we have Dana D-O Delta S. Excellent. Hence no relation.
As a part of your duties, working with City Council for Atlanta, do you interact with business constituents within the city of Atlanta?
Within the districts of my council person, yes.
Who is your council person?
Michael Julian Vaughn.
Can you speak louder, please, and more slowly?
Okay, Michael Julian Bond.
Thank you.
And does that include Southwest Atlanta to include the Cascade area?
It does.
There come a time where you interacted with my clients, John Wesley, Thomas Woodard, and their business, Thomas Lavone LLC.
Yes.
Did there come a time where you interacted with Floshea at the Point and Miss Shay Embry and Mr. Flournoy?
Yes.
Can you tell us a little bit about what happened?
On the particular day that you're talking about here, I was going down to the Family Dollar. I saw a lot of stuff going on across the street. I walked over there. That's a store that I've gone into and purchased before, a
When you say
boutique.
the store you've gone into, you're referring to Thomas Lavone.
Yes, a boutique. And they started, the police were there and there was just a whole bit commotion, and they started telling the story. Several different people were talking, and the police and argument, and just very chaotic. So that was the beginning of the interaction for that. I later realized that they had been kicked out of the shop and that it was locked, and that someone was locked in the store, and that apparently Atlanta, from what my understanding was, Atlanta police had instructed them to leave the shop, and that the lady, Shay, was inside the shop, and they were asking for their things. Could they please get their things? There's a cop there, and after a while, and continuing to go back for like an hour, he said that she was going to allow them to come in and get their things. And
Was there a time, I didn't mean to interrupt you, but was there a time frame placed on when they would be allowed to come and get their things?
yes, he did say a time. I think it was before 4 o'clock or something. I don't actually, I can't quite remember what the time, but I knew that I was just thinking, I had something I wanted to purchase there. So I was thinking, okay, please go back and get my item definitely out of the store. And so I was happy that they were going to be able to go back and get this, very expensive suit out of there. And I left, went home, came back. People are still standing there. They were still waiting.
Just how long between you leaving home and coming back? How long?
I will probably say an hour and a half.
And is this on a Friday or on a Monday?
That's going to be hard for me to say.
Okay, no problem.
I'm sorry.
But well, let me ask it this way. When you were there, things were not being taken out of the store.
No, not at that time. The first time I was there.
They were, so how many times did you go?
When I went home for a while, I came back, I saw it was still going on. I saw her then walking out of the store with a wagon and a whole lot of different stuff, papers, materials, and my suit. And they were walking out on a wagon. I was like, wait, what are you guys doing? And I asked the policeman, I said, what are you doing? And he said, stay back, don't touch anything. I said, but that's their items. And she was just proudly walking by with it. And he was on it. It was horrible just watching them walk out with all their stuff right in front of the police, right out the door. And I don't, that's what I saw.
Nothing further, Judge.
Mr. Brickman, this is Ms. Dodds.
Thank you. Good morning, Ms. Dodds.
Good morning.
Very briefly, what day are you referring to when you went down to the property?
As I previously stated, I don't know what day. Monday and Friday are I just don't remember what it was that day.
Okay, but it was just one of the two?
It was whatever day that she walked the stuff out.
Okay, and before this interaction, when you went to the property, had you received any complaints regarding the property from Mr. Woodard or Mr. Wesley?
Yes, I think they had reached out to several council members. Not several, I think I only know about one, possibly two, Andrea Boone and maybe Marcy Overstreet.
I'm sorry, you finished your answer.
And I'm not sure exactly how their offices did anything or not.
Okay, and do you know the time frame around when those complaints were made?
It was probably within the last 6 months.
Okay, nothing further.
Any redirect?
I'll redirect you.
Any questions for Ms. Dodds from the jurors? None? All right. Thank you, ma'am. Appreciate it. Next witness.
Our last witness, Your Honor, would be Cheryl Brown.
And raise your hand. Do you swear affirm that testimony you will be able to be true, the whole truth, and nothing but the truth, sir? Please go ahead and have a seat. State and spell your name for the record.
Cheryl Brown,
Spell, please.
SHERYLBROWN.
Thank you.
Ms. Brown, can you tell us what your current professional occupation is?
I am a publicist and I own Thrive PR Atlanta, and I am a community engagement leader for Southwest Atlanta.
And how long, well, let's start with the first one. How long have you been a publicist?
For 2 years.
And how long have you been community engagement? I'm sorry, you say community engagement leader for Southwest Atlanta?
Yes.
Can you tell me exactly what you do?
So I've been doing it for 10 years, and what I do is bring people together for engagement in our community. So I started by creating the Adams Park Cultural Arts Festival.
Slow down just a little bit for me.
Okay.
What about creating?
The Adams Park Cultural Arts Festival. And I joined my NPU and became the secretary, and I moved up to vice chair. I left there and created the Cascade Business Consortium, and brought people together to create the Court Watch team.
What
I-
NPU do you live in?
NPR. And from there, just gathering people for conversation and engagement on any level that they need to make their community stronger.
And in your capacity, are you familiar with my clients, John Wesley and Thomas Woodard?
Absolutely, I am. They designed for me.
Okay. And you're familiar with their company, Thomas Lavone LLC?
Absolutely.
And what about Ms. Shay Embry, Mr. Bobby Flournoy, and Floshea at the point? Are you familiar with them?
Yes.
Did there come a time where you were in your role, your capacity, you were engaged in a situation involving my clients and the defendants?
Absolutely. The day of the illegal eviction,
You call it an illegal eviction. Tell me why you use the word illegal.
because an Atlanta Police Department officer evicted them, not a sheriff, and that's the sheriff's job.
Are you a lawyer in this field?
No, I'm not a lawyer in this field, but any evictions that I've ever heard of or known of have always been completed or done by the sheriff's department, never a police officer.
And you believe that that distinction, sheriff versus maybe a marshal or a police officer, would make it an illegal eviction as opposed to a different eviction?
For Atlanta Police Department to do it, it would be an illegal eviction because that's not their job. That's not their purview.
And you know this how, given that you're a publicist and a community engagement leader,
Because they've never done it before and it's always been done by the sheriff's department.
which would make it in your mind illegal as opposed to different.
It wouldn't make it illegal.
Okay. Mr. Sterling?
Can you tell us what it was exactly that you witnessed, just sort of the facts of what you witnessed?
I pulled into the parking lot of the Cascade Heights Shopping Plaza and I positioned my car directly across the street from Thomas Lavone's boutique.
And how did you get involved? How were you contacted by someone?
I was contacted by Mr. Lavone and he asked me to come down. He
When you
wanted
say
to-
Mr. Lavon, there's actually not a Mr.
I'm
Lavon.
sorry. I'm
That's
sorry.
okay.
Mr. Woodard. I often forget that that's his true last name. So I was contacted by Thomas Woodard and he asked me to come down, no doubt for some support, but I was also prepared to help him move his things out. And I think a couple of us were, if that was what was needed.
Do you remember if you came on a Friday or a Monday?
I came on both days.
Right. So let's talk about Friday. Do you recall what you witnessed happen on Friday?
When I got there, what I remember most is that there was a tall, slender gentleman who walked out of the front door of the boutique and started walking towards me. And I saw that there was a policeman inside, and I saw there was some commotion. And I didn't realize that I had pulled up next to his truck, his welding truck, because he was from the Ben Hill Welding Company. And I have seen the truck around the community a lot. And so I wanted to elicit a response from him. And so I did say that somebody is going to jail today. And he mumbled something and got in his truck and drove off.
And with regards to what was happening to Mr. Wesley and Mr. Woodard, what did you see?
I saw Miss Embry in the boutique, looked like she was speaking to him. And I saw another gentleman who was dealing with the lock. And I saw the police officer inside.
You weren't involved in the conversation that they were having with Miss Embry and Mr. Flournoy?
No, I was outside and I was on the sidewalk at that time, looking into the window.
Now let's fast forward to Monday. What did you see, if anything, on Monday when you were there? Well, let me back up a little bit. Do you remember around what time you got there Monday?
There, maybe a little bit before 9, a little bit before 11, probably about 10:40, something. I'm not really sure.
That's fine.
Yeah.
That's fine. Okay. And when you got there around that time, that approximate time, what did you witness?
Is this on Friday or Monday?
I'm sorry, Monday. We're on Monday now.
I witnessed just a lot of commotion between Mr. Woodard, Miss Embry, and the police. And I'd even called the police that morning and asked them to come to the scene. And by the time it finished, there were like 5 police cars there. And I do remember seeing Bobby Flournoy standing against the building. And just I felt like Mr. Woodard's rights were being.
So I'm going to ask you to stop, and you need to have this witness stop saying things were illegal. We're talking about people's rights. That's not her role, not her expertise, and certainly not the decision she's to make in this proceeding. So you need to control the witness.
Yes, sir.
Okay? Thank you.
Just kind of give us, we just want to know the facts of what you actually saw without classifying it. Did you see any items being moved out of the building?
Absolutely.
And who did you see moving those items?
Looked like I saw Shay take a wagon out, but I also saw a gentleman with a wagon of things in a plastic garbage bag. And there was another young lady there.
And were those items being taken out of the Thomas Lavone LLC shop?
They were.
And did you witness any efforts by my clients to try and plead to get their stuff back?
Absolutely.
And with respect to that, what did you see?
I saw them, well, I saw them. I can't say I heard the conversation, but I saw them. It looked as if they were asking for their stuff to be
So
returned.
if you didn't hear what they were saying,
Okay.
don't speculate as to what was said.
I didn't hear what they said. I only saw what was going on. And there were several police on the scene. And Mr. Woodard and Mr. Wesley were there. And Shay Embry was there. And I saw Bobby Flournoy later.
And this was around that 11 o'clock, maybe slightly before time.
Mhm.
No further questions, Judge.
Mr. Brickman, any questions for Ms. Brown?
Briefly, thank you. Morning, Ms. Brown.
Morning.
Thank you for your patience, and you've been waiting around as well. Very briefly, you stated that Thomas Lavone, the company, designs for you.
Yes.
And how many items have they designed for you?
They have designed 1, and they had 2 in their possession that they were creating for me. I came in for a fitting. No, 1 that I came in for a fitting for, and then 1 we discussed.
Okay, that's it. Thank you.
Mr. Sterling, any follow-up?
No redirect, Your Honor.
All right. Jurors, any questions for Ms. Brown? No? Ms. Brown, thank you for your time. I don't know if you had to be here yesterday as well. We appreciate your time.
Thank you so much.
Take care.
All right.
Mr. Sterling, anyone else?
No, Your Honor, the plaintiffs will rest at this time, Judge.
All right, ladies and gentlemen, we are going to take an early morning break. I told you, and I don't blame you if you don't remember, but during my presentation to you as to how a trial flows, mentioned that when one side rests, we usually have to take a break because there's some legal things we need to talk about. That's this time. So you're going to get an early morning break. We'll try to get you back in here as close to 10 as possible, but I'm going to need to get some things on the record from both sides. Don't talk about the case. The fact that Mr. Sterling has rested doesn't mean that Mr. Williams and Mr. Brickman aren't going to present evidence. They have brought some claims, and so they have a burden of proof as well. So it's not yet deliberation time. We've taken a step closer to that. But for right now, talk about other things, enjoy the snacks. Do they have smart food? All right, I'm gonna get one of those. But enjoy your break, and we will get you back here as close to 10 as possible. Thank you. All right, you all can be seated. Plaintiffs have rested. Mr. Williams, anything we need to work through before we pivot to your presentation? And before you answer that question, I should get on the record. Oh, I printed it out. I'm gonna have trouble finding it. Nope. I'm not having trouble finding it. Mr. Sterling, at my request, and thank you for doing it, 25 minutes late, 8:25 last night, but I actually hadn't gotten to things yet. Kids were more high maintenance than I expected.
My 3-year-old was sick, Judge. Same problem.
Okay, mine are a lot older than that, but they're still high maintenance. Mr. Sterling sent an email to me, counsel for defendants, Ms. Niles, indicating that they were withdrawing the fraud claim. I'm not going to use the numbers because the numbers in the complaint weren't quite right. I'll use the topic. So fraud, breach of fiduciary duty, tortious interference, the temporary restraining order, the injunctive relief is already moot, and then attorney's fees. So no more fraud, breach of fiduciary duty, tortious interference, or attorney's fees. Is that correct, Mr. Sterling?
That is, Your Honor.
Okay, but the plaintiffs are persisting with conversion and their 2 negligence per se allegations, which are theft by deception and theft by taking. So those are the 3 that I kept in the jury charge as plaintiff's claims. Those are the 3 that if you have any motions at this point, Mr. Williams, you ought to focus on. You don't need to spend any time talking about fraud.
Your Honor, I'm going to be very brief and respectfully with respect to the conversion, the torts and negligence per se, theft by taking and theft by deception. We move for directed verdict. The evidence is undisputed. The lease is not in dispute. This is a commercial lease, as the court has already taken notice of. A commercial lease is different than a residential lease. There's a valid contract here that was freely negotiated, that was entered into, that was signed by the party, and case law and longstanding Georgia law recognizes that if there's self-help remedies and provisions in a commercial lease, that the landlord is entitled to rely upon those to perfect those remedies and go through that process. The evidence is also clear from the plaintiff's own testimony that they were late paying rent, that they received the notice of default, that they withheld rent, that they had not paid April rent, and that the lease was terminated through that. The emails, the documentations show that the landlords went through the process of the self-help remedies under the law, under their lease, and they should be allowed to rely on that. Mr. Sterling has done a good job of trying to evoke sympathy That's not what the law recognizes in this situation. So we'll be brief. We're happy to talk more on this, but we move for directed verdict on plaintiff's claims.
Before you sit, what is your response to an argument that I foresee because of one of the jury charge requests that maybe rent wasn't late because terms had been modified through course of conduct, and your clients had not just repeatedly, but it sounds like I haven't heard any evidence to the contrary. They had always accepted rent at some later date than the first of the month, such that an argument could be made that there really wasn't a rent due date. Rent had to be paid, and presumably rent was paid in the same month it was due. But I haven't seen evidence yet. I have to rely on the record that's been made so far that there was anything contrary to a course of conduct reliance on rent is due when we can get it to you, because we've always paid. We're a good tenant, even through the troubles of the pandemic. We paid our rent, never on day one.
Your Honor, you can look at the lease itself and you can look at the notice of default and the notice of termination. The lease itself, which is undisputed in the record, has provisions that's section 11.15. This is the entire binding agreement. No representations, no oral agreements, no conduct changes that. Section 10.3,
Let me stop with 11.5. 11.5 is entitled damage to property or person.
11.15.
11.15. I may have misheard you.
And I may have misspoken, I'm sorry.
Well, there was a 5 in it.
And 11.
Yeah. Okay, so the first sentence of 11.15 says, the second clause, the lease may not be modified in any manner other than by agreement in writing signed by all parties hereto. So that's the defense against modification through course of conduct.
Correct. There's no signed amendment. There's no emails back and forth. There's nothing more than the testimony of the plaintiffs themselves. If the court were also.
Well, but I mean, I assume there's more than I don't know this, but if Ms. Embry or Mr. Flournoy testified, I'm assuming they'd say, yes, in fact, we accepted rent on a date later than the first. I mean,
But they're also testified that at a certain point, even before all of this, that stopped.
Okay.
And they said, look, you've got to start paying these late payments. You can't keep slow paying and no paying.
Okay, and that's not in the record yet. I don't want to rely on that, but you weren't suggesting that, in fact, rent hadn't been paid late. It had, but your observation is that 11.15 says, that's interesting that it happened. That didn't create a new provision to the lease.
It didn't create a new lease. And if we put ourselves back into when this is 2020, this is COVID. There were clearly situations where allowances were made.
Okay.
The other provision I would draw your attention to is 10.3.
Non-waiver provisions.
The failure of landlord to insist upon strict performance of any of the terms, conditions, and covenants herein shall not be deemed to be a waiver of any rights or remedies that landlord may have.
Okay. Tell me what in the lease you rely on, and send me to a specific sentence or part of a sentence, or maybe it's multiple sentences, that authorized your clients to remove the property as opposed to the people. Because the other argument, I'm not doing Mr. Sterling's job for him. I just have been listening to the case. And so I want to make sure I understand your perspective before I give Mr. Sterling a chance to respond. The self-help provisions, to me, aren't so clear that property could be removed. And so I'd like you to show me the language upon which you rely. The self-help provisions are clear in that locks can be changed, lease can be terminated, and there can be what is in effect an eviction, a legal eviction, by way of the landlords exercising the rights under a contract to which the tenants knowingly, voluntarily, and freely sign. So I'm not troubled by that. It's the property piece, which of course is the focus of conversion. It's not a wrongful eviction claim anymore. It's, wait a minute, but what about our stuff? So what's the language under which you travel that says not only could we remove you through the self-help, but we could remove and effectively throw away what we're learning wasn't just their property, but might have been a garment that Ms. Dodds already paid for and was hoping to get her hands on.
Sure, Your Honor, section 10.2, page 16. This is also in the self-help provision following what the landlord can do in an event of default. About midway through that first paragraph.
So it's the incomplete, it's a partial paragraph. It's the paragraph that carries over. Okay. Yep.
Tenant hereby consents after any event of default to the exercise of dominion over tenant's property within the demised premise.
Okay. And you highlighted that before, I think, in your examination of Mr. Wesley, who responded, those words are there.
Correct.
Okay.
In my redirect, I also talk about 11.7. Surrender of the premises. At the expiration of the tenancy hereby created, tenant shall surrender the demised premise. Tenant shall surrender, let me see. I think it's, I'm not looking at my highlighted copy, I'm sorry. No.
Bottom of the second paragraph.
The bottom of that paragraph, if tenant shall fail to remove. That last sentence in that last full paragraph in 11.7.
Okay.
And then section 11.8. That second paragraph in 11.8. If tenant fails to surrender the demised premises upon the termination of this lease. This is specifically in line with what happened here. Tenant shall bear the responsibilities for any of the failure arising out of that. So it's those three provisions, Your Honor.
And they're prohibited from bringing a claim.
Conversion.
Which section is that?
That first paragraph on page 16, 10.2. Such alteration should be deemed or constitute conversion.
It was a long pause. Conversion has three elements that here it's plaintiffs had a right to possession of the property, that your client's possession of it, the defendant's possession of it was wrongful, and plaintiffs demanded possession, but defendants wrongfully refused to surrender it. I guess your argument, Mr. Williams, is that there's no way, based on the language of the lease, for a jury to find at least element 2, that defendant's possession of the property was wrongful because of the language of the lease. I think there's lots of evidence that plaintiffs had demanded possession, and there could be I think there's a factual dispute, in particular if you are relying only on, which you're not, that language in 11.7, because I don't know that the evidence is clear that the tenants failed to remove their property. I think the evidence is conflicting, but I think there is evidence that the jury could rely on that they tried to, but they weren't able to because of police, of sketchy man, of whatever the situation was. Could we please have our stuff? And they weren't able to get it. But element 2 seems like a problem for the plaintiffs. Anything else you want to add before I hear from Mr. Sterling?
Your Honor, they've sued Ms. Embry in her individual capacity or personal capacity. We would move for directed verdict on that. There are specific provisions under the lease that says no individual member, no officer, no owner of the LLC can bear any personal responsibility or liability here. And we would respectfully ask that she be dismissed on directed verdict. There is also the provision.
Which is you shared that with the jury and me. I don't remember the provision. What's that provision that says members, stakeholders, et cetera, are not liable, only the corporations?
Give me a minute, Your Honor.
I will.
11.3.
11.3.
All right.
And then there is also a specific provision that speaks to no liability for conversion. Which provision is that?
10.2, top of page 16.
10.2, top of page 16.
The sentence preceding the one that you read. No such alteration.
It is understood that such surrender can be effected. Yeah, the next sentence. No such alteration of security devices and no removal of or exercise of dominion by landlord over the property of tenant or others at the demise premise. So that would include address that someone else bought, shall be deemed unauthorized or constitute a conversion.
Okay.
Thank you, Your Honor.
You're welcome. Mr. Sterling, let's go in reverse order. Tell me your legal theory and what evidence supports it that would keep Ms. Embry as an individual defendant in the case.
Yes, Your Honor. So the specific provisions that Mr. Williams references relates to the tenancy and the occupancy. At the moment in which Ms. Embry participated in the actual destruction of the property, the taking of the property and the destruction of the property, this lease does not speak to that. It does not speak to her acting in a capacity where she's actually the person who's removing the property, and several witnesses have testified they saw her with a wagon removing the property. Mr. Williams represented at our TRO hearing that she destroyed the property, or the property was destroyed or discarded, or however it was destroyed. And so this doesn't speak to, the lease speaks to, it goes to, in all of those provisions Mr. Williams mentioned, it talks about the tenancy and occupancy, but it doesn't talk about the willful, wanton damage to property. That's section 11.5. That talks about with the except of the gross negligence or willful and wanton acts of landlords, its agent and employees. So in terms of, we believe that there's an exception here because the acts of Ms. Embry can be seen to be willful and wanton in that she participated in, she took the property out in a wagon, there's evidence she did that, and there's evidence that she ultimately destroyed the property, despite the fact that my clients and multiple witnesses testified they were asking for it back, requesting it back, with promise to get it back. So I think what Mr. Williams is doing is trying to sort of slice this in a way that says, hey, these items related to the lease absolves her, but what her actions were outside of the lease.
And how were they outside of the lease if, I think this is the defense theory, if the defense theory is there was a default, as a result of the default, we can engage in self-help. Self-help includes changing locks, and removing property, and I think it does. And it was the act of removing property that you are saying was somehow, I'm going to use the phrase ultra vires, like outside the scope of the lease. But it actually arose, 11.3 talks about matters pertaining to or arising out of the tenancy. And the way this business relationship came to a close was the notice of default, followed by the notice of termination, and the application of the self-help provisions that were there in black and white in the lease, which would include removing the property. And so if just walking through the theory, I want you to poke the holes in it that you're trying to do, then the landlord and its agents, that would be Ms. Embry, that would be Mr. Flournoy, the sketchy guy, whoever it was who was removing things, they were agents of the landlord. They, at the time, didn't have wrongful possession of the property because the terms of the lease gave them dominion over that property. And so they were removing it. I'm trying to figure out how, and we're focused on Ms. Embry because that's the only non-corporate defendant that you've listed here. How was she doing anything other than acting as an agent of the landlord, which is the LLC, when she was executing, along with others, the self-help provisions that are authorized by the lease that your client signed?
Well, I'd say this, or I'd say two things. One, my first argument is this does not arise out of the tenancy. That particular provision, 11.3, only is about the tenancy and the use and occupancy of the premises. The tenancy, use, and occupancy of the premises. So it begins by saying tenant agrees the liability of landlord under this lease and all matters pertaining to or arising out of, and it's modified by tenancy and use and occupancy of the demised premises. It doesn't speak specifically to the damage, destruction of property, or conversion. So my argument would be that a reasonable juror could find that that was outside of the scope. So this doesn't arise out of the tenancy and use or occupancy of the building. This arises out of the specific taking and destruction of the property. And I don't want to go sort of in reverse order, but
it's okay.
Sort of go back, Judge, but I think it speaks to the point that Mr. Williams raised, and he would have been right in 2018, but in 2019, the Georgia Supreme Court overruled years of precedent when it said that course of conduct can modify a written agreement and can modify it even when the contract specifically says that all modifications have to be in writing. So in Hannum v. Asset Management, the Supreme Court basically overruled years of precedent in 2019 and said, look, modifications to contracts can be through course of conduct, and those modifications can occur even if the contract expressly said all modifications have to be in writing.
What's the citation for that case?
It's 305 GA 414.
All right. What about the language in 10.2 at the top of page 16 that says no removal or other exercise of dominion by the landlord over the property of the tenant or others, might include garments that have already been purchased, or others, shall be deemed unauthorized or constitute a conversion. You know, words even in there. We don't have to wonder, did they mean conversion here? Because your clients knowingly, voluntarily, and hopefully intelligently signed a lease that says, whatever we do with the property of the tenant in connection with the self-help constitutes a conversion. And now you've got a conversion claim. Those seem to bump into each other a little bit.
Well, I think that is in direct conflict to provision 11.5, which makes an exception and says that except with respect to the gross negligence or willful and wanton acts of the landlord would not be responsible for loss or damage of property to tenants. So I think I think in this particular case, Your Honor, those two provisions are in conflict with one another. Because it does say that if the landlord acts willfully, and I think there's been evidence presented that the landlord did act willfully and wantonly or grossly negligent, then they can be held liable for those acts for damage to property.
Okay. Anything, I will read the Supreme Court case you mentioned. Anything else you want to add?
No, Your Honor, and Your Honor said it exactly right. You even maybe more awfully than I could have said it, but we believe, Your Honor, the course of conduct, we believe there wasn't a default. So to the extent that we're talking about the lease.
Right. If there's not a default, there's no self-help.
Right.
And so then one is acting outside the authority of the lease.
And so we believe that by course of conduct, by the nature of the relationship that was created over 2.5 years, by the manner in which they accepted rent, there was a course of conduct and an agreement, a modification that rent was not in fact due on the first. Although Mr. Williams tried to cure it in one of his letters, you cannot cure 2.5 years of course of conduct through a legal letter, right? If they've been acting this way and my clients have been relying on the manner in which we have conducted our regular business, right? And the testimony from Mr. Wesley was I over communicated. I texted both of them. I let them know it was going to be late, and that from the beginning, this was part of how they operated normally, regularly. We believe there was a modification such that there was no default. I think the jury's got sufficient information where they could come to that conclusion that, hey, look, we believe that because you were accepting late rent, that they didn't default, they paid it late as they usually would, as you normally accept it. There was no default, and that when they raised concerns about the electrical issues, about the plumbing issues, that's when all of a sudden you wanted to go back and say, oh no, we're going to hold you strictly liable to what's on the four corners of the document, and we're going to ignore the 2.5 years of the course of conduct in which we operated. So I think reasonable jurors could come to that conclusion, Judge.
And Your Honor, reasonable jurors may, the law does not. And that's why we're making this motion for directed verdict.
Okay.
It doesn't matter that there's been 2 years of things. We did cure that, and it did change the course of conduct. They can't
Okay,
rely on that.
hold on before you, I wasn't ready for you yet.
Well, you looked up, Your Honor, I'm sorry.
Okay. I'm looking at Hannum.
And we're going to want an opportunity to read that and respond to that.
I had a second part to that argument, Judge, and I'll bring it once you're ready.
Okay. So you should look at footnote 2, Mr. Williams, or Mr. Brickman, in the Hannum case, and be thinking about that. And I'll hear a little bit more from Mr. Sterling. You said you had more you wanted to argue.
Just the second part, Judge, to the argument that there was no default. The second part of my argument that there was in fact no default, and they never had a right to take the premises and the property, is that they gave proper notice under the contract to Ms. Embry about the necessary repairs. They received quotes about the repairs. They did the repairs themselves, and they were entitled under Georgia law. So when you see this contract doesn't state a lot of remedies for the tenant, it states almost exclusively remedies for the landlord. But it does have a provision in there that says this is governed by Georgia law, right? So it allows the tenants to exercise any rights they would have under Georgia law. So my other argument would be, Judge, they had a right to set off the amount of the repairs, even if it exceeded the amount of rent. And even though they didn't exercise it and they ended up ultimately paying rent, they certainly had a right to deduct the cost of what they had paid for the repairs, the rain, the
There's
flooding.
no evidence in the record of what they paid if they engaged in repair. It was a video of someone pushing water out the front door, but that would be pure speculation that the cost was $1 or $1,000 equal to the rent, less than the rent. What would the jury be doing other than speculating as to what expenses, if any, your clients had incurred?
As I recall, Your Honor, maybe I didn't hear it correctly, but I think that my clients testified that they incurred costs upwards of $4,500 to correct the issues that were occurring in the premises.
And what type of corrective efforts did they engage in? I'm trying to, I don't, the fact that that may well have been said. I claim to have complete recall of everything that was said. But I know there were not a whole lot of numbers that were coming out other than the exhibit that gets us to $7 million. So what was the work? What do you recall the testimony being about the work that was done that would have cost $4,000?
If they got in contact with, and maybe it was an invoice or an estimate, I don't call these.
So an estimate would be, that's interesting, it might cost this, but if they haven't spent it yet, I can't imagine you can be preemptively withholding rent because someday we're going to spend something.
Sure, Your Honor, but it was a plumbing company that was hired and electrical company that was hired or contacted. And I don't recall the exact testimony, Judge, but it's my understanding that there was upwards of $4,500 spent on necessary repairs that were made and necessary repairs that were made when they couldn't get any help from this immigrant.
Okay. All right.
I think my first argument is probably the stronger one. I'm gonna stick by that one, Judge.
Okay. So, Mr. Williams, talk to me about course of conduct modification in the face of Hannum.
I mean, Hannon recognizes course of conduct through parole evidence of oral or agreement by the parties with consideration, but it says unless it's prohibited by the law or written contract. And here it is specific in this contract that there should not be any oral modifications.
Right, but footnote 2 says that the course of conduct can also operate to waive an otherwise validly enforceable written requirement that all modifications be in writing. That's as in plain black and white text as the self-help remedies that your clients are relying on.
And Mr. Sterling may have been correct in arguing that prior to when my client put them on notice that they would no longer accept late rent.
And that was?
The notice of default, the notice of termination, the notice of default.
Okay. What's your argument about the fact that the record is a little murky as to when they received the notice of default and understood what that meant? Because you were laboring under the misapprehension, not your fault in any way, shape, or form, that communications needed to go through Mr. Burrows. And I know we heard in this trial, I'm remembering from the TRO as well, Mr. Burrows wasn't doing a great job of communicating with Mr. Wesley or Mr. Woodard.
Job, apparently.
That would be a not great job.
The lease itself has provisions that says who's supposed to receive notice and how those notices are supposed to go. If you look at page 1 or page 2 of the lease summary, I believe it's subsection F and subsection G. There is no provision that the tenants provided as to how or where they were supposed to receive notice. No address, no emails. That's repeated throughout this lease. We relied upon, and the evidence from the plaintiffs themselves is they didn't tell anybody at any time that Mr. Burrows was not authorized to accept communications for.
No, we had that the attorney. I'm not going to tell you who it is. It's the attorney, and it's not Mr. Burrows. It's an attorney to be named later. So I don't know who else you could be communicating with.
And so just like the landlord should be able to reasonably rely upon the self-help provisions in the lease, we should be able to reasonably rely upon the attorney represented as the attorney for the tenants and to accept communications, especially in light that the lease doesn't provide any other way to notify.
But I don't know the law surrounding this, and I'm clearly learning some on the fly here. If course of conduct can modify a contract, even in the face of a provision that says, no, it has to be in writing, how does a unilateral notification from one side saying we're undoing that course of, I mean, both people have to engage in the course of conduct. In other words, your clients would have to have been pushing back from day one on the late payment of rent, saying we're going to do it this one time, but it's not okay. And that's not the evidence. It was okay. And rent was paid late. There's no evidence in the record that they said anything other than, okay, but you're moving for a directed verdict now.
I know, and I'm trying not to argue against my directed verdict, but
tell me what you think the law is around the issue that you're framing, which is, okay, under Hannum, footnote 2, looks like even though there's some pretty clear language in the lease that says there are no course of conduct modifications, that isn't worth a whole lot because there can still be course of conduct modifications. The argument is that's what the evidence shows. I think that's a good argument that ought to get to the jury at this juncture. Your response to it is, oh, but you know what, in April, just a couple of weeks before the self-help, there was this notice of default. And so that meant that course of conduct modification was undone. But you can't unilaterally undo something.
I think what you heard the plaintiff say was not that they were just staying with this course of conduct. They weren't just continuing to pay on the 15th or the 16th or the next month. They withheld rent. They testified to that. They altered that course of conduct too. They didn't keep paying based on whatever course of conduct which we disagree with. They didn't keep that either. And so it is my position that that was not, and I think the evidence, especially when we put Ms. Embry on the stand, if we don't get everything through directed verdict, will show that there wasn't this clear-cut course of conduct that altered the agreement.
Okay. What about the holdback argument? And that we're not paying rent because there are these issues, plumbing, electrical, the wet line, the electrical box, et cetera. And until you fix those, and I've seen the proposed pattern charge. A tenant can try to fix it himself. The tenant could withhold rent. The tenant could seek damages because the tenant notified the landlord of some aspect of disrepair within the demised premises.
There's no evidence in the record beyond the plaintiff saying that they had complaints. There's no notice of default from them. There's no request for repairs. Section 10.5 provides that. The landlord is under no obligation until it's not cured a default. There's no evidence in the record that they were ever notified beyond the one email that we received from Mr. Burrows, and even plaintiffs themselves, when they read that email, said, we weren't complaining about condemnation. We didn't have these issues before the rain event.
Okay. Last question for Mr. Sterling. What's the evidence in the record that the landlord was on notice of the issues that your client said they were having with the electrical and the wiring and that condensation?
I think there's multiple things on the record, Your Honor. One, my clients repeatedly talked about the fact that they emailed and sent text messages to Ms. Embry regarding those issues. Mr. Wesley specifically testified that he went and flagged her down at a restaurant to notify her orally of those issues after he had sent text messages and emails. Mr. Woodard testified they sent text messages and emails as well. So I think they've made it very clear that they sent this in writing. Plus, she was copied on emails that were sent to the city council members, or she was copied on emails that were sent to other entities complaining of the issues. So for for Mr. Williams to say she was not on notice or she wasn't aware, I think that's not accurate.
Okay. All right. So the standard for a directed verdict is a steep one for the party moving for it because it's taking from the jury the ability to decide a question that otherwise would be presented to them. If I find that there is any evidence in the record upon which jurors could reasonably base a verdict, I need to deny the motion for directed verdict, and then the attorneys are free to argue about the weight or lack of weight of the evidence. But if there is some, it's not my job to say, gosh, that's kind of weak compared to the other evidence. It's to focus on whether there is a basis for a jury to rule in a particular way. Put differently, I'd have to find that there is no conflict in the evidence as to a particular issue, and a particular verdict is demanded. I think that it remains sufficiently murky for the jury as to what the default was, when the default happened, and how this course of conduct would work, and the way communications flowed, both from the landlords through lawyers and from the tenants through alleged texts and emails, of which we've seen very, very few, but enough. And frankly, the oral testimony is sufficient. You can produce a text, and jurors have asked for them, but they're not here. So they are going to have to rely on what the witnesses had to say. But I can't say that it is that there are no questions surrounding whether the course of conduct didn't sufficiently modify the lease, whether there was a default, whether they were on notice of default. And I think there's also a question concerning the willful and wanton aspect of the landlord's self-help execution when it got to the point of, we're now removing the property. So we've changed the locks, we're removing the property. And I think the jury's entitled to consider at the point, and they've heard now plenty of testimony about it, Mr. Wesley and Mr. Woodward were outside their former business saying, well, could you just hand us the stuff as you're taking it out? That a jury is entitled to consider whether that fell within what was authorized by the lease, assuming there was a default, because they don't get to that if they don't find a default, or whether that constituted behavior by the landlord or the landlord's agents that would fall into the provision that Mr. Sterling cited, that there's actually, that landlord could be liable because it was willful and wanton. So I think the jury needs to work through that based on what I've heard so far. Haven't heard any testimony from defense witnesses. I am close to granting a directed verdict on getting Ms. Embry out of the case because I think the lease is pretty clear about that. But I'm going to let you put up your side of the case, and then you can renew that motion so that I can get a other side of what was going on May 2, because we've heard a lot about one side of what was going on and not the other side. But if there was no default and there were requests for the return of property, I think we get closer to a conversion and potential individual liability. So I want both sides to understand it's a little bit of a head scratcher why Ms. Embry would be listed as a defendant, given what the allegations are, but I see the theory. And it's stronger in theory than fact right now, but we'll see what the defense evidence is. You focused on conversion. I think we'll have a discussion when both sides have rest about whether there really could be theft by deception and theft by taking and conversion. And you're not required to elect only one, but it may need to be clear to the jurors that there could be only one and not all three. And so they may be in the alternative. We don't need to sort that out quite yet. But as I was working on the jury charge last night, I wondered about how they interact. Okay. This was a long break for the jurors, but I want to give you all a break. It will be a short break. Mr. Sterling, anything else before your short break?
No, Your Honor.
Okay, Mr. Williams,
No, Your Honor, thank you for your time.
you've got it all day. We have a hardish stop at noon because I'm taking some criminal stuff. That'll only be during our lunch break. It's just that our lunch break will start right about noon. We'll see where we are at that point.
And we just need to move everything off of her.
You need to leave. I'm gonna find out from Ms. Nelson. It may be mostly virtual participants. If she thinks that defense attorneys are coming in because they would sit there, then you'll need to at least create one seat's worth of space. But if everyone's gonna be virtual, you can just leave things. Okay?
Thank you, Your Honor.
All right. Let's try to be back in, how much time do you need? 5 minutes? 5 minutes. And Deputy Gordon, if you let the jurors know, 5 minutes.
And update this for the screen. The one you guys will get this. Or just someone here again.
I don't know. Like, no.
I know, I'm just looking for afterwards.
So this should be 150.
The late fee should be one.
Does Shay know that, or do you need to testify to this?
No, Shane knows it. Yeah.
Okay.
And that's in the email that you guys got.
But we've got all of the checks, right?
So you want
Including the hard copy.
Do you want me to pull that one out?
No.
We're sure there's nowhere that can reprint.
Will you ask Ms. Niles if she would print something for you?
Yeah.
Let's see if you can get her.
What do we need to print?
Reprint this.
We print the ledger.
Can we print that?
Just email it to me real quick.
Don't even.
I'm gonna go, there's like a door down for each chambers.
How do I send this now?
Oh,
So it works. The slower the better. And I worked out something like this 2 times, it just doesn't work. So
Yes, okay.
touch. Then I'm gonna go ring your doorbell.
Wait. I'm serious. I'm so freaked out about this now.
Okay, you're good, you're good.
All right, let me close this out. Be sure it's saved correctly. This is V2. Opening. It still says it. Right.
You say that? It's 3, there we go.
Oops. Get rid of this, just start from the beginning.
All right.
Print. Right. Open, so it's got that around.
You're good. Changed?
Yeah.
Okay, send it to me.
Yeah, sent.
I'm gonna ring your doorbell.
All right.
Thank you.
Thank you. So sorry.
Hearing a rooster crowing. Not great, it's almost like somebody's ringtone. It's like, I keep hearing it.
That's funny. Do you have a citation of that case? You gave me? I can't find it.
Georgia 414.
305 Georgia 414. Thank you.
Everyone's here. So let's get back on the record. Mr. Sterling, you good? Mr. Williams?
We're good.
All right, let's bring the jurors in, please.
You're going to go up on the stand first. Yeah.
Yes, why don't you take that? That's the wrong one. Yes, it's the wrong one. Yeah, this number. What's wrong? No, it's listed in the triple heads. How what? Should we tell
I'll do as president.
Thank you, Deputy Gordon. Everyone can be seated. Welcome back. I have to take back something I said yesterday. I said yesterday, boy, the only people who talk more than lawyers are judges. Lawyers talk more than judges. That break took a lot longer than I thought, but we were having a good, important argument as the lawyers for both sides talked a whole lot. So I'm sorry that you had such a long break, but it was all necessary and a natural outgrowth of what happens when one side rests. So plaintiffs have rested. It is now the defense presentation if they're going to present anything. Mr. Williams, if you would call your first witness.
Thank you, Your Honor. We call Shay Embry to stand.
Ms. Embry, come on up, please.
Now, go ahead and have a seat. Spell your name for the record.
My name is Shay Embry, SHEAEMBRY.
Good morning again, Shay.
Hey.
Introduce yourself to the jury. Tell them a little about yourself.
Hi, I'm Shay Embry. I am a resident of the Cascade Heights area, specifically Beecher Hills. I live across street from my business partner and best friend, Bobby Flournoy. We are 4/10 of a mile down to the buildings. The day I bought my house, I got mad at myself for buying in a neighborhood where I had to get in my car to do anything. And I called Bobby and said, get in my car, we got to find some property to buy. And so we drove down to Cascade Heights. There was a property for lease that was mostly vacant. And I called the owners, said, I'd like to buy your buildings because I needed to bring businesses in. And she said, I'll sell it to you, but only if you buy both of them. I said, okay, I'll do it. And I was moving some sales of some properties from New Orleans back into the Atlanta market. And that became my project. And of course, when COVID hit, that stretched that project a little longer than we anticipated. I have, I don't know how much you want to know. I have a master's degree from Oklahoma State University, an undergraduate in fine arts, and my master's in another field that's not related to the arts. I have been doing design work on properties. My first design, I was 19, but then I started doing the work on properties in 1989, and did home renovations, and then graduated into working on land. I was a broker in real estate since 1988. I am a licensed general contractor for residential and light commercial properties for the state of Georgia, and a vendor for the city of Atlanta.
And we've talked a little bit, the property that you're mentioning in your neighborhood, that's the point at Cascade.
Yes, that's what we call it.
And at some point, you and Bobby, y'all formed Floshea at the Point. What is that? What's its purpose? What's it do?
Okay, so I was selling property that I owned in New Orleans and was taking advantage of a tax law that allowed me to what they call a 1031 tax deferral, where I can, instead of paying taxes on that, I can come and buy property. And so I identified these properties and purchased those under a 1031 exchange. So, and then simultaneously, and with the help of Kyle, formed an LLC. And I wanted Bobby to be a part of it because he had been living in the neighborhood for, at that point, I think almost 20 years. And I wanted him to be a part of it because he was already a community leader. And so I brought him into my company, and his last name is Flournoy, and it's FLO, mine's SHEA, so it became Floshea at the Point. And
You heard me confess that it took me how many years
Yes.
to realize that?
yeah, but and our purpose of Floshea at the Point specifically is to purchase those two parcels, to improve the parcels, and to then bring in tenants that will provide services for the existing community. That was our purpose.
What was the condition of those properties when you purchased it? You said you bought two of them. What did they entail?
We had tenants in some of the units, but most of the units were vacant. While the previous owners, as great as they were, had done some improvements to the property because of some code enforcement, there were still a lot of deficiencies on the property.
What's the age of these properties?
They were built at different times and, connected to each other, but essentially in the 50s.
And what work or renovation work did you do once you purchased it?
Well, it was a layering. One of the very first things I did didn't have to do with the physical structure, but I worked with a consultant and the National Park Service and the state Park Service of Georgia, and established the Cascade Heights Commercial Historic District, which put it on the National Register. And I'd never done that before, so I was kind of excited about being a part of leading and making that happen. Then I started off, of course, you've got to do roof repairs. The electrical, we started on one building, which is the 2211. It's not the one where Lavone was in, but the other building was a larger building. Put in 3-phase electrical, all new sewer lines, brand new grease traps for any restaurant that would come in. And then brought in Tremaine Perry, our neighbor. We all lived on the same street. And because he said his dream was to have a coffee shop, coffee and wine house. And I'm a major cheerleader of entrepreneurs. And as soon as he said that, I'm like, don't wait, do it right now. Like, what are you waiting on? He was in the banking industry. And so he became our first new tenant in the building. From there, it was a matter of approaching each tenant or each unit based on the needs. We have Craig Barlow, who has Barlow's Barbershop, which we're told is the longest running Black-owned business in the whole Cascade area. And in fact, his daddy started the barbershop in the 60s, and he grew up in it. And so he is our tenant. He didn't have any money. He didn't have anything inside there. He didn't have hot water. He had a window unit. And so while all of our tenants do their own build out, we chose to spend money and to renovate his space and try to take it back to the historic look. And we're all pretty happy about him being there.
How many tenants do you have now?
We have we're full. We have 13 units, and that's what we have. Yep, that's in both buildings.
And what are some of the other businesses that you have there?
Well, first it was a coffee house. Then second, we brought in the city studio. I don't know if y'all know it, but it's a part of the city planning office, and it's essentially a pop-up planning office to be in the community. And we were their second location that they came into. They were there a few years. They moved out. We brought in Via Eye Care. It's Dr. Williams. Then we brought in, we had an existing tenant of Sound Resort Studios. He was a tenant who struggled making the payment, even though our existing tenants, we left them at $500 each a month for Sound Resort Studios, Barlow's Barbershop, and Cameron's Salon, because they were they're like the base of the community, and we needed to make sure they weren't impacted. But on his business, his last comment a little over a month ago when he gave us notice to vacate was that with the new people recording at home now, that people weren't going to recording studios. And so he wasn't able to keep, even at $500 a month, he wasn't able to keep his business. And then we have, and if you want me to continue, I have Trey Dortch, who is, if y'all know him, Tommy Dortch's son, and he just brought in a wellness center in the building and a good place for training and yoga. I have an ice cream shop that actually is opening soon. They're waiting on the city for the permitting. I have Stretch Theory, that is like a combination of massage and physical therapy. We have More Life Juice Shop. So it's a couple, and all these people are from our neighborhood, which I love. More Life is fresh juices. Then we go around the corner and there is Aretha's at the Point, which is a restaurant. And I actually invested in, and I designed and built the restaurant out and brought on an award-winning chef, Deborah Van Treese. She owns Twisted Soul over on Huff Road. And she is quite an amazing business partner. I don't run restaurants. I'm not going to do that, but she's great. And then another restaurant we decided to open together. And then one other tenant is, again, we haven't built it out, but Deborah's daughter and I are going to, I'm going to design and build a speakeasy that's in the basement area of that building. And those are our tenants.
And the lease that we're here, and we have been here this week, which is Defendant's Exhibit, I believe, 1 in that notebook that should still be on your table. Thomas Lavone,
Uh-huh.
and John Wesley and Thomas Woodward. How'd you get to know them?
They stopped me on the streets and they were excited and they asked me if I own the property. And I said, yeah, Bobby and I own it. And they said they were designers from New Jersey and they wanted to be in our building. And I'm like, I'm a fan of entrepreneurs and I'm certainly a fan of people in the creative industry.
You know when that was?
That would have been likely in October of 2019. And we entered into conversation about them moving in and came to an agreement where they could take possession. I believe it was in December of 2019.
If you look at Defendant's Exhibit 1, which is in your notebook, that's the lease that we talked a lot about yesterday. Is that the agreement that
Yes,
you
it
entered
is.
into?
Yeah.
Yesterday, I believe there's testimony about it being a triple net lease. What the heck does that mean?
Well, triple net is not used in residential contracts. It's only used in commercial contracts. And what it means is that you take the amount of taxes, insurance, and what's called common area maintenance. So any maintenance that happens on the outside of the building, and you split it based on the percent of occupancy. So if a unit is 15% of the occupancy, then they pay on an annual basis 15% of the expenses. And fortunately for us, we had contracted with the tenants, letting them know that we anticipated, I believe it was $5 a square foot. I'd have to go back to my notes on that, but we never hit above $4 a square foot. So we've always been able to keep our costs down. As we know, taxes always go up. So I'm hoping they won't, but that's what happens. The tenant pays it.
And do they pay that annually? You said annually, or do they pay that monthly?
No, their contract allows for the payment to start on January 1, and they pay 15% of their annual payment for 6 months. Okay. And then on the 7th month, there's a partial payment. And after the 7th month, 8 through 12, there's no payment. So it's only their rent. They don't have any more triple net payment at that point.
Were there any common areas in the building that lay people might think of as common areas, like a shared courtyard or a lobby entrance? Or it simply was, look, there's a roof that runs across all these buildings. And so 5%, if you have 5% of the roof, you're going to pay 5% of the upkeep for the overall roof.
Yeah, no, not really. I mean, there's an outdoor seating area for the restaurants and the juice shop. It would not prohibit other tenants from being a part of it, but essentially it goes to them. And then on the other building, I created I put out AstroTurf and put a little putting green out there, which could be used, of course, by any of our tenants and the public. But then there's a space that's specifically for the restaurant that we built there, and then the coffee house. But again, it's the answer is yes, people can use it.
Okay.
Yeah.
And if you look at D1, and I promise we're not going to go through all the provisions like we've done before. We're just going to hit the high points.
Okay.
Page 4, page 3, we see base rent. Page 4, you see operating expenses, real estate taxes. And at the bottom of that, tenant's share means 4%. Is that 4%? Is that what you're talking about in terms
Yes.
of the percentage? And so what does that mean?
That means that their unit is only 4% of the square footage of the total, the point at Cascade. And so if there's $1,000 spent to take care of everything, then theirs is 4% of $1,000. And we have to do it, the way that works for landlords is you have to do an estimate at the beginning of the year of what to anticipate. And so tenants pay based on that. But if we get to the end of the year and they paid too much, which actually is what happened last year, then we pay that money back to the tenant. Okay.
So
And
with,
vice versa, if they don't pay enough, they have to pay us back.
so with respect to this space, you said you came to an agreement or written lease. Did you, and you talked about doing build out for restaurants or other places there. Did you do a build out of this space?
No, the only thing that we did, on the building, the whole building, not just their unit, I brought in, a three-phase electrical unit. So the whole building, we took down the electrical on the whole building, brought in all new three-phase electrical with new panels in each one of the units. In most of the units, because they were occupied, we required the tenant have their electrician come in and transfer the interior units to the panel box. But in this situation, I don't know why I did it, but I had my guys, I paid them to connect the old electrical in the building to the new panel box. It was permitted, had a licensed electrician, and inspected.
We heard testimony yesterday, and I believe it was this electrical box that there was allegations that it did not comply with OSHA standards, that there was violations about a wet line, which I'll admit I don't understand.
So when the inspection happened and the city inspector comes in and they look at the panel box, you can't have water running across the top of an electric, but you just can't do it, right? There was the condensate line on your HVAC, that's that clear line that goes out and it pumps out and does the whole thing. That's the line that they were speaking of. And there's not a possibility that the city approved that panel box with that line in front of that panel box. Okay. How it got put in front of the panel box, I can't speak to. I just know when I got a word that there was a problem, I went into the property with my electrician and we stood in front of the panel box and the line was clearly running right across the front of it. I don't know how it got there. And we went like this and moved it out from underneath the panel box. There's no way for water to drip down on the panel because it was underneath it. And that's where it stayed. That's where it is now. And it is code.
Was there any other issues during that time that you heard about with that space or that
Yes.
you complained about? What?
They had been asking me,
And let me know, this is after they moved in,
after they took possession.
which was December 1,
Yes.
2019.
And
And they were focused expressly on Mr. Wesley and Mr. Woodward, not other tenants of
yes,
yours.
exactly.
Okay.
Yeah. So they started doing work to the unit. And as a general contractor, I have to follow guidelines and rules and permits. I mean, if it's done on my job, it's permitted, it's inspected, we do that. And after watching the people go in and out, I was pretty certain that, and I didn't see a permit, that I didn't know what was going on, but they kept asking me, Thomas kept saying, come and see what we're doing, come see. And I'm kind of given a distance and I was busy on other things. And finally one day I had just been talking with the tenant 2 doors down from there, Nakia, and I said, hey, listen, they wanted me to come and see the work. You want to come over? And he said, yeah. So we go over and knock on the door, and John opened the door, and he was incoherent and he kind of wild-eyed, and then he kind of just walked away. And then Thomas came up and smiled and said, you can come in. I said, and both of us were like, no, it's okay. So we left. That raised some concern, like serious concerns for me. 2 days later, I saw him on the street, and John looked at me and said, Shay, I understand you came by the store the other day, 2 days ago. I'm sorry I missed you. We'll have to see you next time. And I was like, okay, From that point, I went back again later to see the work that was being done. The men that they had hired, who I can't speak to whether they were licensed or not licensed, but they were working on the bathroom, and the work that they were doing to the bathroom was not ADA compliant. Okay. And that is it should be a pet peeve of anyone in construction, but it certainly is of the city. I spoke to them about it, to the contractor, who was not, didn't seem pleased that I would bring up what needed to happen. I was very specific on what needed to happen, the spacing and the 5-foot turnaround and the whole thing. And that became a concern for me in terms of condition. We also put in a new heat and air system for them. While they were there, I got a frantic call that there's flooding, it's horrible. And when I went in to see it, I hired my HVAC person. He came out, and someone, I'm assuming their contractor, had unplugged the condensate pump. And so the system was running and the water was flooding the unit and creating water on the floor. And that's an unfortunate situation, but it's not something that we controlled. We plugged it back in. It worked just fine.
Do you know when that was?
Well, it was hot, so it probably would have been probably May or after of 2021.
And this is,
2020.
we saw videos yesterday of rainwater flooding into the space. This is a different.
No,
situation.
that was completely different. Yeah.
So the plaintiffs move in as tenants December 1, 2019.
Mhm.
Under the terms of the lease, they have 2 months free rent.
Yeah.
They were required to pay a security deposit at the time of the execution of the lease. Were there any
Right.
issues with the payment of that security deposit?
Yeah, it bounced. And to my, again, I'm crazy about creative people and entrepreneurs, and against the advice of our leasing agent, Peter Kruskamp, and then Bobby's reservations, I chose to say, let's just keep going. They're artists. Let's do this. And I'm just glad they didn't say I told you so.
Did you hear from the plaintiffs when it bounced?
He sent me John sent an email and said, we're so sorry. The check didn't go through. And that's when I went into conversation with Bobby, because Bobby handles all the rent. I don't handle any rent. He handles all of it. Once I get it leased and everything's done, Bobby takes over with the money.
And so under the terms of the lease, first 2 months are free. And then that third month, they're supposed to start paying $1,000 a month.
Yeah, because of the circumstances that were going on, and we knew they were coming into the city, we did not charge market rate for them for that first year. We lowered it to $1,000.
What would have been market rate?
I believe it was $23 a square foot.
And what does this average out to?
Well, I'd have to take 1,000 divided by 693. It looks like it's 1732 according to the paperwork.
And the paperwork you're referring
The
to is the
lease.
lease.
The lease agreement shows that it's $17.32. And then the next year they were to be charged $25 a square foot,
And under the terms of the lease, when were rent payments due?
the first of the month.
Were there any issues with the payment and the timely payment of rent from these tenants?
Yes. The first month that was due, it's due on the 1st, they paid on the 5th. April, they paid on the 17th. May, they paid on time. June, they paid on the 10th. July, the 7th. August, the 5th. September was on the 15th. And it just goes on. The 15th, the 11th, the 22nd, the 20th of January of 21. There were very few times when they actually paid the 5th or earlier. And I will tell you that one thing that did happen, which was good, is that in September of 21, we also had not charged any of our tenants during the pandemic their triple net. Not that it wasn't hard on us too, but in an acknowledgement of it's difficult. And we wanted to help them to make sure that they were stable enough to stay in the space that they were in. And so we didn't charge any triple net. However, in September of 21, Bobby and I spoke about it, and he informed them that we will no longer not charge you your late fee. It's been long enough. We had one other tenant was in the same circumstance. All other tenants were paying on time. But this tenant, and they acknowledged through another email response is that we have the lease. We know we're good. We know we have to pay it. And so starting in September of 21 is when we said, that's not, it almost felt like we were being taken advantage of. So not that I'm saying they intended to take advantage. I'm just saying that was our feeling.
So up to a certain point, you were accepting late payments of rent.
From September of 21 on, it was required.
To pay on time.
Yes.
And if they didn't pay on time, was there a late fee associated
Yes.
with that under the terms of the lease?
Yes.
Did plaintiffs as the tenants pay late fees associated with
Yes.
that?
So just so I'm following, because someone said late payment, someone said late fee. If we fast forward to December 21, if the plaintiffs didn't pay within the first 5 days, they were paying the lease amount, the monthly rent, plus a late fee.
Yes. And in December of 2021, they did not make, December rent was paid on the 2nd, which is great.
So no late fee.
Right. And
I
their
gave a
triple,
bad example.
right. And their triple net was paid on the 31st, which was late.
Okay.
And the late fee under the lease was how much?
$150.
What document are you looking at? What is that?
This is a ledger that Bobby ran for me. He does a monthly ledger, but this was one where he put it all together so I could be clear about what payments were made and the dates they were given.
And so what's the scope of that? Is that from the life of this lease?
It's for the entire portion of the lease, starting on March of 2020, all the way through April of this last year.
Is this something that Floshea would have kept in the normal course of business?
Absolutely. Yeah.
Your
And
Honor,
I'm a little bit of a nerd, so I'm online checking accounts constantly, making sure.
Your Honor, we move to tender this as Defendant's Exhibit 32.
3-2. Mr. Sterling, you have a copy of it?
I haven't seen it.
Apparently you do. Why don't you take a look at it and take your time looking at it? While I look for the exhibit list.
Your Honor, it's not in the notebook. We're using this as a rebuttal since there was testimony that they always pay their rent on time.
Okay, so 32 is already admitted. That was
Sorry.
plaintiffs.
30.
35 would be a number that's not in the binder.
35.
Okay,
Tabs move up.
all right. Mr. Sterling, I think there's been a sufficient foundation laid. Do you want to examine the witness on this before I rule on admissibility? You'll certainly be able on cross to ask questions about it.
No, Your Honor, I don't want to examine it right now. Thank you.
Okay, all right. I'll admit 35.
Thank you, Your Honor. If you're turn to Defendant's Exhibit 2 in the notebook, which has already been admitted. This is the email from Terrence Burrows, the attorney for plaintiffs, to you.
Mhm.
Do you recognize that email?
Yes.
Did you receive that email?
Yes.
And you received this email approximately when it's dated, March 22nd, 2002?
Yes. Which I promptly sent to you.
Prior to receiving this, had you heard complaints from the plaintiffs about electrical problems, plumbing problems, condemnation issues, or flooding issues?
Prior to that point, I had received messages about the electric panel and a little bit of explosive, kind of loud yelling at me
But is that what
about,
we've talked about earlier?
yes, the
condemnation
electric
line?
condensate line, which
Okay.
we did this, yeah.
Electrical problems other than that?
No,
condemnation?
it's all the
Okay.
code. It's all three-phase.
Three-phase means like the two
Yes.
flat guys and the round one? What does three-phase mean?
Three-phase means that they, like for, as an example, to simplify it, is if you have 100 amps coming into your three-phase, because it has three different phases that come into the panel, you actually end up with the ability to have 200 amps.
So that didn't simplify it.
Makes-
Three-phase doesn't
That made
mean
me
the
more
kind of plug with
confused.
three
No,
prongs.
not,
Okay.
that's not it. It's,
Then you're way beyond. I just
I'm
know that
sorry.
they're two-prong plugs, that's old school. And then three-prong plugs,
Yeah.
it's harder to like kill yourself when you plug it in. All
exactly,
Okay.
yeah.
right,
Yeah, I got confused.
okay. But three-phase, you're saying is good? Or is code? If it's
Oh,
not
yeah,
three-phase,
yeah,
it's not
absolutely.
code.
Yeah.
Got it. Is there
If you're going to
four-phase?
run a restaurant, you have to have three-phase because you don't have enough electrical coming into the building. And so we upgraded both buildings to three-phase.
Okay.
So back to the question.
Yeah.
The question was, before you saw this email from the attorney, Mr. Burrows, let's start here. Had you received an email or notice from any attorney operating on the
No.
plaintiff's behalf before that?
No,
Had you received any notice of default or, hey, we think you're not doing what you're supposed to do under the terms of the lease from the plaintiffs?
I do not have any recollection of being notified in writing of anything. The only time that I heard something, I was in a meeting, and please forgive me about the dates, but when there was a deluge of water that came into our city, and I think there were tornadoes close, but that may be my Oklahoma roots talking. I was in a meeting in the restaurant that was just 2 doors up from this unit. And this is not the first time that Thomas had done this with me, but and wasn't the last, but he came outside the window and was hands above the head screaming. And it was quite startling. And I don't do well when people approach me with screaming at me. And I locked the door and walked away. And the rain was really intense. And I get that. The next morning, however, even though it was said that I didn't do anything, I had my waterproofing guy with me, inspecting the outside of the building. I did not enter the building. There was no reason for me to, because it seemed clear as to what was taking place. But I had him with me. I had already waterproofed the base next to the sidewalk in the building because the building goes down below the sidewalk. Okay. That had already been done. We redid it again after that day, even though it was clear that that was not the issue.
What was the issue?
Well, the issue was, you've heard mention of a door on the back of the unit that was unsafe.
And when you say unit,
Yeah,
This-
2291, their unit, yeah. And that that it was unsafe. That door was there, I believe it was a metal door, was there when we purchased the building in 2016. At some point in history, we have no idea. It had been completely sealed inside and out to eliminate with waterproofing, okay? And the reason for that is because the sidewalk was at a slant, okay? The door sat here, which meant if it wasn't sealed, water would come in and go underneath here and down the steps and into the unit. What they replaced it with,
and when you say they,
the tenants, when the tenants replaced the door without, I mean, they're supposed to ask permission for any changes, certainly to the outside walls of our building. They took that out. They replaced it with an interior 6-panel wooden door with no paint and no water sealant around the entire thing. When you stood on the inside of the property during daylight and looked at the door, you saw daylight through the whole thing and around the hole. And I was in the unit at one point after they were not occupying anymore, and rain came in and just flowed down underneath the door. There was nothing else for it to do. It had to. The other place that they made a change on, when we purchased the property, there on the side of the building, there was an opening. There had to be a window there originally, but there was a wooden space in there that had a window unit in it. And that's what the previous tenant had used for her cooling at some point in history. I don't know when. They had taken that out, and you saw them discuss the glass block in there. Again, they didn't ask permission from us to do this. The glass block was installed set back from the edge of the face of the brick. Okay.
What is your reason for saying that the tenants needed to get your permission to change whatever changed with that back door or do the work you're describing?
In our lease agreement, and they showed earlier that Bobby and I hold the responsibilities as the landlords to be responsible for the outside walls.
And this involved the doors, obviously
Yes.
external, and you're describing something that if it wasn't there, I could pass my hand from inside the unit to outside. the unit.
Correct. Yes.
But all the work we saw and heard about with improving the inside, you didn't need to sign off on
No.
that.
Well, yes, actually, it does require it, but I get a little more lax on that, but I don't ever get lax on making changes to exterior walls.
Okay.
Yeah.
I asked it the wrong way. The tenants, the plaintiffs had within code freedom to redesign the inside.
Yes.
It was when something was affecting the exterior of the building, roof walls,
Yes.
exterior walls, that was under the terms of the lease. You're saying landlord responsibility, or at least landlord needs to be a part of decisions that would be affecting the exterior.
Specifically, they needed approval.
Okay.
Yeah.
And would that also be the split in terms of who's responsible for what?
Yes.
If there's
Yeah.
a repair necessary, tenant's responsible for some, landlord's responsible for some.
Tenant's responsible for interior. So the window, to explain the details of the outside wall on a 1950s brick building, commercial building, you see the brick on the outside. There's also brick on the inside, but that means there's 2 layers or more of brick. And the way they built those walls was a gap. So you have a layer of brick here and a layer of brick here, and there's a gap, usually 2 to 3 inches wide. And the purpose of that gap is that if water goes in the outside, it will go down and not to the inside, right? The glass block was set further back, and there was no waterproofing installed around the glass block, which allowed it was a bad rain. I'm not saying there couldn't be water coming in some way, but because it was a bad rain. Anybody that had a basement and if it was anywhere near going to leak, it's going to leak in that rain. And the water literally pounded up against that, went into the wall in between the 2 bricks. And when they described it and showed us it coming out of the weep holes, of course it did. If it didn't have weep holes, that water would have filled up and it would have burst the walls. That's the reason that we had to approve any changes to the outside wall, because it's a structural issue.
And maybe I was the first one to learn about weep holes yesterday, but you talked about it just now.
Yeah.
And y'all had what's a weep hole?
Okay.
What's its purpose?
A purpose is exactly what I said. It is if any brick, and if you have a brick house and you go to the outside and you see little holes at the bottom, that's a weep hole, because brick is porous. And so water can actually go into that brick, and there's a cavity in back of there that allows the water then to come down and seek its way, because it will, out the weep hole. So it's essentially allowing water to exit the wall rather than to build up and burst the wall.
Had y'all had problems with weep holes in either the plaintiff space or any of the other buildings prior to this massive rain event?
No. Mm-mm.
When you got this email from Mr. Burrows, what was your reaction? What did you do?
I was shocked. I was, to say that our billing needed to be, what is it, the term they used here? Where is it? Condemned. I guess one of my reactions is that I never want to have one of our tenants have anything uncomfortable with them. That's not anywhere near where Bobby and I come from. However, that said, it's difficult to see someone create the problem and then become the victim of the problem, blaming us for the issue. And that's how I saw that.
But if there had been things in there that would have been the exterior landlord responsibility.
Yeah.
How would you react?
I would have been there taking care of it, just like I did when they said there was our electrical. I mean, I was even told by Thomas that the Georgia Power came out and they were going to shut them down. And at one point he told me that they were shut down, and that didn't happen.
So we received this email from Mr. Burrows. Let's look back very briefly at the lease.
Mhm.
Did you have any reason to believe or suspect that Mr. Burrows was not representing the plaintiffs at that time?
No, I was clear about it. And immediately we let them know that, because they started trying to communicate with us directly. And I said, we will not discuss this. You need to have your attorney speak to our attorney. Because anytime someone invokes an attorney, it just needs to be attorney to attorney. I don't want any of that.
And we heard yesterday, and maybe this is what you mean because you're doing it yourself, that you waved your hand at him. You said that, is that what you're talking about?
Raise my hand. Oh, well, there's been conversation in which it said that I gave advice on their rent payments. And if you ask any of our tenants, they will hear this, you'll hear from them the same thing. I don't handle the rent payments. And I go like this and I say, talk to Bobby. That's his job. I'm not doing that. And oftentimes Thomas would say, yeah, but, and I'm like, I don't handle the rent payments. So any conversation that is quoted that I made comments about what to do with rent is at the least a misunderstanding, because I'm very clear about my boundaries with that.
So let's look at the lease. And I just want to make sure that the jury sees this. On the first page, the lease summary, we have landlord address, we have tenant trade name. Tenants didn't provide an address or a notice address for tenant.
Right. They were, in all fairness to them, they were in the middle of moving. They were selling their house in New Jersey and moving down, and they did not have, apparently they did move in with some family member not far from there, but at the time that this was done, they were in flux of where they were.
And so to ask it a different way, when we got the email from Mr. Burrows, did you assume that was the point of contact for the plaintiffs?
Absolutely, yeah.
And at any time, were you told that's not the point of contact?
Never.
For the plaintiffs? At the time you received that email from Mr. Burrows, and I know you said you don't handle the day-to-day rent, but you also testified that you go into the accounts daily.
Yeah.
Were the plaintiffs current on what they owed you?
At the time of what?
When you received this email from Mr. Burrows?
No, they were not.
Did you ever find out from Mr. Burrows or plaintiffs what the issues were with condemnation, or more plumbing issues or more electrical issues?
No.
Did you ask for that?
I went to you at that point.
And is that the email that we've looked at from me to Mr. Burrows where we asked for more
Yes.
information?
Mm-hmm.
At some point, did you decide, or you and Bobby decide to send a notice of default to the plaintiffs?
Yes.
Why?
The tenants had started posting things on social media that were not productive. They were aggressive. They were accusing us of doing things that we didn't do. And as you can imagine, that is not healthy for our community. And because every month, when you speak to me looking at the rents, I don't talk to tenants about rent, but I talk to Bobby. And if it's the 5th and I don't see the deposits, I call Bobby and I say, what's up? Where's the rent? And every month, the tenant literally, because I knew the contract, I knew that we had the ability to, and if we wanted to, and they hadn't paid by the 5th, I can go in and change the locks and take possession. I already knew that. That's our right. Don't want that, but that's all right. So every month I would call Bobby. If it's on in 2020 then they didn't pay till the 15th. On the 6th, I was on the phone with Bobby. And my question is, how are you doing? Do you want us to evict them? Or are you okay chasing rent? And he said, I'm okay chasing rent. I got it. Don't worry about it. And then he would chase it down, which meant that Bobby's job was literally to take the rent, put it in the account, create an accounting, send it. Done. But instead, in this situation and one other, it was don't get the rent, get a call from me, chase down, be told you're going to get it, don't get it, then go through and deposit it. So his job became, instead of like maybe an hour a day for 5 days, it became stretched out sometimes. For example, in December of 2021, it took until the 31st for them to pay their triple net. And every time on the 6th, I'm on the phone with Bobby saying, what's up? Are you okay with what we're doing? Are you okay with this time frame? And that's been our process with that.
But even though you chased rent, did you accept that? Was that a modification of your lease?
No, it was not a modification to the agreement. And again, let me stress to you that in September of 2021, when we both talked about it, and it felt as if they weren't just being late, they were taking advantage of our generosity and of trying to help with COVID. We went back and said, no, from this point forward, you're going to have to pay late fees.
And did the plaintiffs acknowledge that change?
Yes, they did, in writing.
In an email?
Yes.
And at some point, I guess you decided to stop chasing rent and you authorized the notice of default.
Yes.
And that's Defendant's Exhibit 5?
Pardon me?
Defendant's Exhibit 5 in that notebook?
Yes.
You heard testimony yesterday that the plaintiffs had fully paid rent. They were not in default of this lease.
That's not true.
How do you know that?
Because I check our accounts every day, number one. And then Bobby's ledger backed up what I found on the account. They were slightly short on, they did not pay their late fee. They didn't pay their rent on January 1. They paid it on the 18th, which meant they owed $150. On the 18th also, they paid their triple net, but they didn't pay the full triple net. They were only short like $2.06. Okay. So at that point, they're $152.06 in arrears with us. Then in February, they did not pay until the 15th. They did not pay their late fee and they did not pay their triple net. Then in April, what happened in March? Oh, no, this is March. So in March, they didn't pay till April 14th, at which point we made the decision, because we have the right to do so, not to accept the rent. We chose that now Bobby's tired of chasing rent. Let's stop it. Okay. And so that's the point at which we quit doing that.
And that's after the date of this notice of default.
After the date of what?
The notice of default is April
Yes.
11th.
Yeah,
You said March was not paid until April 14th.
correct. And they received that notice of default. Anyway, yeah.
No, finish your statement. You said they've
Well,
received.
they
it.
received the notice of default on the 11th. Then, and the date that Bobby has on the ledger of 4/14 is not necessarily when we received it. That's the date on the check that they wrote. Okay. And then again, on the 27th of April, once they realized that it's done, then they brought another check, which we did not deposit. We quit accepting any fees in February. After that, we were done. And it's not that we want to do that. No landlord wants to not have a tenant in their unit. But my job, our job, is to provide a building where people can do business. Their job's pay rent. It's kind of simple. They didn't.
Let's talk about, because there's been a lot of testimony as to what happened. It sounds like on a Friday, which we believe is April 28th,
Mhm.
what happened on a Monday, May 2nd. So let's get to the heart of it. What happened on April 28th?
We notified them that we would be entering the property and changing the locks. And we gave them a notice. And there's been a lot of talk about 4:00. 4:00 is correct, but was on Friday. And what we said was that we were going to change the locks. They have until 4:00 on Friday. It's in writing where we notified them. 4:00 on Friday. And this is not our first request to say, please come and get your things out of the building. And they didn't.
When you say you notified them and it was in writing, can you
Emails.
sent an email, Mr. Williams sent an email and copied you, or what's your recollection as to how this notification? Because you mentioned you weren't interacting directly because lawyers were going.
Well, at that point, I believe that Bobby sent an email in regard to saying we're changing the locks. And it may have been me. It was one of us, and that could have been Kyle. I honestly don't remember.
Okay, but it was email was the mechanism.
Yes, it was. And instead of showing up with trucks to move their things, they didn't. And they showed up with a number of people that were from the community who were told that we were doing something wrong. And we were certainly within our rights. Not that we wanted to be there, but there's a certain point where you have to say, we got to go forward.
And in the interest of time, I'm not going to go through all the emails that we've previously gone through that Shay's been a member of or a party to. But on the 28th, when you went there, you had police officers with you?
29th,
29th,
that's a Friday.
29th Friday.
Yeah,
Why did you have police officers?
there's a
there?
lot of talk that the police officer was evicting someone. They were not. There were so many occasions where Thomas Lavone was pacing back and forth on sidewalks, hand above his head, screaming into a phone or yelling at someone. Sometimes it was me. And I'm uncomfortable with that. And so I chose to hire an off-duty police officer, Officer Muhammad, to come there to just be there because I was uncomfortable. And I also simultaneously hired a locksmith to come over and change the locks on the building. And that was his purpose in being there. There was no eviction. The termination of the lease had already taken place.
And this is Friday.
Yes.
Was there discussion, and you mentioned this 4 PM has been a running
Right.
theme throughout this testimony.
Yeah.
And a conversation on site or a meeting on site between
Yeah.
multiple parties that included you and Bobby.
Yeah.
What's your recollection?
We were there at 4. I had a locksmith. Everything was scheduled. We changed the locks. We respected the time frame. And then later, and forgive me if, no, so from that point, once we changed the locks, Bobby and I walked around the corner in our same building to Aretha's at the Point to have dinner with some neighbors. We were sitting outside on the patio. And Bobby and I discussed them getting their things out. We don't want their things. We want them to get them. And so I said, Bobby, I'm not available this weekend. And he said, got it. So he walked back over and he let them know that he is available anytime over the weekend to just let us know and we will open the doors. They can get all their things out of the building. And Bobby did not, neither one of us heard from him.
At any point up till then, or even then, had the plaintiff said, we want to get our stuff, we can't do it until this date, give us
No.
till Tuesday, give us till Wednesday?
We would have given it to him, but we kept doing that. And you kept telling us to end everything and we kept giving them more time. So,
So you're not available over the weekend.
yeah.
4 o'clock goes and passes on Friday.
Mhm.
What happens on Monday?
On Monday, Bobby wrote again to them, and you've seen it. And we had been clear with them before that Bobby was not available after 12 o'clock because he had other appointments. He has his own business to run. And so that morning he sent a note and he said, I'll be there. I can be there between 9 and 12. Let me know what time. I'll unlock it. You can get all your things out. And they responded, there will be no removal of items on that date. Simultaneously, they posted a video, and I got a call from someone that said, check your Facebook. And I got on the Facebook account and there was a video that Thomas had taken of me standing on the sidewalk, talking. I think it was to Corliss. I don't remember. There were other people there. And he said the word, and this is when I saw it. It was on Monday morning, right after we got the notice that they would not do that. The comment that he made online was, I hope she doesn't wake up tomorrow. And that was my spot. I said, I'm done.
I'll turn you to Defendant's Exhibit 20 in the notebook and ask you if you recognize that screenshot from Facebook.
Yes. Mhm.
Is that the video you're talking about?
Yes.
Or not the video, it's a screenshot. but
Yeah.
Is that the screenshot?
Yeah. And he posted many things on there. I mean, with accusation, even after we were saying, please come and get your things. We don't want them. Please come and get your things. They're posting that we're taking stuff from them. We're trying to give them to you.
And we see in this, there seems to be a layer of posts, and I'm sure Mr. Sterling's going to cross-examine you on this.
Yeah.
There's one that says 7 hours ago, and then one that says edited 5 weeks ago, and that seems to be the video.
I'm sorry, where's that?
In the middle of the page,
Oh, yeah.
talks about
yeah.
the judge,
Finally, after several attempts, server. Yeah.
Judge who has good eyes.
the gut. We'll take you can take judicial notice of that.
Bill.
But then 5 weeks before that, which would have been this timeline of Friday to Monday, that's when this video was posted.
I saw it on Monday morning. And when he said the words, I hope she doesn't wake up tomorrow, that was my point of, I'm done.
But at that point, the plaintiffs had already told you, they're
Yes.
not moving anything.
Absolutely. Yeah. And I already had, this is what took place. I already had people lined up I don't want any of that. We don't want any of this. We don't want to touch it. We're not doing it. So I was in the building. And by the way, it was testified that I took a cart out of there. I didn't touch any items. I didn't move a cart. I did not do one of those things. I had people on site that took care of it. Now, potentially they mistook whoever was pulling the cart for me. The conversation, the one person said that they were outside trying to grab something off the cart. I didn't know anything about it. The only time I heard about it was when that person that did pull a cart came back in and told me that someone grabbed her and that the police made her stop, like physically stop the woman. I don't want any part of that. So when everything went from our possession out, was inside the building, they picked things up from the building and took them. We did not take one thing out of the building. Oh, and by the way, the man that they said was sketchy.
I was just going to ask that question anyway.
Yeah, he's a master plumber that works for me. And he was concerned for my safety. And so he was there because he had seen the behavior on the streets.
Look, I'm going to ask because I know the difference between a residential lease and a commercial lease. This sounds harsh. This sounds pretty bad. And you
It was
changed their
horrible.
locks,
Yeah.
You disposed of their stuff. You took their stuff. Why? Well, you didn't take it, but you removed it from the premises.
What am I going to do? Just continue to go along with this while they're putting all this stuff on social media that people are calling me about what a horrible person I am. And I mean, what am I supposed to do? How far am I pushed? How many times did I have to say, please come and get your things? And when that one video came out, that's the point. I know it may sound harsh that I was done, but don't threaten me.
But they still owed you money. They still were in default. Correct?
Yeah.
We saw a couple of exhibits yesterday about inventory, dresses, equipment, all kinds of stuff, either 6 million or $7.5 million worth of stuff that was in the store, the 697 square feet of store. What was in that store when you rekeyed the locks?
We probably could see better by the video because when they showed the video, but there were, I believe, 4 rods about maybe 3 to 4 feet long with clothing on it in the front part of the store. There was a rod that went across one wall that is approximately 7 feet long that had clothing hanging on it. There were a couple of boxes with fabric down in it. And then there was, but as far as the amount of stuff, it all went into the back of a small pickup truck and 2 cars. I would say maybe 40 pieces of finished clothing. That's a pure guess. Okay. Just when I think about the spacing.
No further questions at this time, Your Honor.
All right. Mr. Sterling, I want to give you a full window to do cross-examination. I think we'll start because we've got about 10 minutes. I just want you to know you're going to get interrupted because I'm guessing you have more than 10 minutes of questions. But at noon, I need to commandeer the Zoom system to get us connected with some inmates at the county jail for work I'll do while you eat lunch.
Yes, Your Honor. Thank you, Judge. Got an additional exhibit for the court.
Thank you.
Thank you, sir.
I think that'll be defendant's exhibit N, Your Honor.
N as in Nancy?
As in Nancy, it wasn't on my original exhibit list.
Okay, we're in that phase now.
Yes, Your Honor.
And it is.
Ms. Embry, would you take a look at that document? It's probably helpful for you to go from the back to the front because it goes in order that way.
The back just has a confidentiality notice. Is that what you mean?
I'm sorry, yeah, but if you read it from sort of the backwards and then
Okay.
second page
Got it.
up, yeah, if you're going up,
Got it. Yeah.
you can see sort of the order it goes in.
Okay.
Now, you and Mr. Williams just talked on direct examination, and you stated that prior to the March 22nd, 2022 notice from Mr. Terrence Burrows, my clients had never informed you in writing about any issues, electrical or otherwise, related to the building. Was that your testimony?
No, I think I said I don't remember that, but a lot of things go around. So if this is here, then I believe that it came to me.
Okay.
Yeah.
But on direct examination, you said you didn't remember if they had informed you in writing.
Yeah.
Okay. Now, you will confirm that this email, well, let me do it this way. Your email is in fact shay@luckystar.com.
Yes, sir.
Okay. And you're aware that Mr. Lavone's email is, or Thomas Lavone, the company's email, Mr. Wesley, is management@thomaslavone.com. Is that right?
I'm sorry, say that again?
Mr. Wesley's email is management@thomaslavone.
I'm assuming it is. Yeah.
And there's a correspondence here between you and management@thomaslavone.com. Is that right?
That's what I'm seeing. Yes.
And it's dated, the first date on it is a message from Mr. Electric of Metro Atlanta to management@thomaslavone.com.
Can you show me where that is?
Sure. If you go to the second page
Uh-huh.
at the bottom where it says forwarded message.
I don't have that.
Your Honor,
Oh.
I'm happy to.
Mr. Electric of Metro Atlanta,
Okay,
from where it says Thomas Lavon, thank you for choosing Mr. Reuter, Mr. Electric, for all your service needs.
Yes.
Yeah, I see that.
Okay. Well, yeah, we'll accept that stipulation so we can put it on the screen.
Okay, so you're stipulating to its admissibility.
Correct.
Plaintiff's N, as in Nancy, is admitted. So if you want to publish it, you can publish it.
Well, I'll ask some questions from it for now, Your Honor, so I don't waste any time, and then we can publish it after lunch.
Appreciate it.
But Ms. Emery, you will acknowledge that on March 16, 2022, Mr. Lavone sent you a message saying, please see attached, sent you to forward. Please see the attached electrical report regarding code violations. I look forward to hearing from you both soon.
I don't see any invoice or thing connected to this that says any issues. Could you maybe provide that?
Well, let's look at the March 16, 2022 email. You're Shay Embry at luckystar.com. Is that right?
I just confirmed. Yes,
All
sir.
right. And you do respond and say, please see Article 3 of your lease agreement attached below for your ease. Is that right?
Yeah.
And in that response, it talks about section 3.1 of the lease, acceptance of demised premises as is clause. Is that right?
Yes, and that's standard policy.
And then doesn't Thomas Lavone, after you send that message, say on Wednesday, March 16, 2022, thank you for your response. I will forward this accordingly.
Yeah.
Is that right?
Certainly.
So on March 16th, you and him have an exchange about electrical issues, which is prior to the date of March 22nd, 2022, when Mr. Burrows sent the letter explaining the electrical and other issues to you.
Mm-hmm.
Is that fair?
Yes, absolutely.
So this letter wasn't the first time they had raised those issues with you. In fact, he had put them in writing nearly 7 days before this legal correspondence was sent.
Sir, my lease agreement, our lease agreement with all tenants is very clear. Anything that happens within inside those walls is the responsibility of the tenant. Now, that said, as we discussed earlier, we brought in new 3-phase electrical and installed that per city code by a licensed electrician with a permit and inspected. The things that they're discussing right here do not pertain to us. But I will point out that in this email that you sent to me, he says in here, it is my understanding that a grant was granted to the owner to ensure infrastructure updates were made. So in regard to that, the only time that I had seen anything in regard to a grant was one of his posts online, where there was some statement from someone that said, we got a $5 million grant to improve the community. And I just wish I knew where that account was, because I never got a $5 million check to improve anything. So this is incorrect.
But it is correct that they communicated the concerns about the electrical to you.
They communicated their responsibility to take care of the building is what they communicated. They did not communicate our responsibility.
Well, you guys are talking past each other. You agree that through this collection of emails, in particular, the start of the chain, your tenants flagged for you a concern they had about
Yes.
an electrical issue in 2291, whatever the magic address is.
Yeah, along with a grant
Right.
we didn't receive.
Okay.
Yeah.
Now, you disagree that it was your responsibility, and you told them that.
Lease agreement does.
Right. Well, that'll be up for the jury to decide, but you disagreed in response that it was your responsibility.
Correct.
Okay. And you told
That's
them.
And I still
exactly-
do.
Okay, and she still does, and that's where we're gonna stop. And if you have one more question on that topic, I thought you were shifting gears.
No, I
I'm
was
happy
just,
to close the loop on N, but then we need to break.
that's fine, Judge.
You're
I'll
done with
close
N?
there. Yep.
Well, if you come back, you're not gonna ask about N. Or because if you have more about N, ask it now.
Well, let me just ask you this. Your response to them was, look at this particular section, which was the as-is clause
Correct.
in the lease agreement.
Correct.
All right, you'll have more questions after lunch. Ms. Embry, please, if you are interacting with the lawyers during the break, don't talk about your testimony. Ladies and gentlemen, it's your lunchtime. We will try to get started as close to 1 as we can. I'm going to take care of some criminal matters. That's why the courtroom has been filling up. And then pivot back to this important matter, as I said, as close to 1 as possible. Don't talk about the case during lunch. No outside research. You know how to ask questions when it's your turn, and you will have that turn with Ms. Embry once the lawyers are done asking her questions. Any logistical questions from you? Enough water, enough snacks? Good. Don't drink the tap water. All right. Thanks. So while they're stepping out, we actually have all sorts of lawyers here. So if you all could shrink down to one spot or put things on that table, that's great. I just want the lawyers to be able to flex. You do whatever you want for an hour. You can stay right here. You do not need to take down the criminal work.
I'm not paying.
Cheapskate.
I know. It's my boss.
I've heard, he knows my law firm.
Ms. Nelson, oh, there she is. There's Ms. Rivers. Great. Hey, Ms. Rivers.
Hi. You're welcome. Yeah.
Mr. Jordan, I haven't seen you in a while.
Yes, how are you?
You bring me please
I hope so. I hope so.
Right here after you.
Hey, Ms. Charles.
That's not.
I did, I was like, you just.
Ms. Livingston, I'm going to start adding some of those booths now.
Okay. You know which ones?
I believe it is, yes, I do. And I got the update. So I'm going to try to add those 4 now.
Okay, thank you.
Wish me luck.
Oh, no, who did this? Absolutely not.
All right, one more room to add. 6 North, booth 1. Okay, good afternoon, everyone. We're pretty close to being on schedule. We've got a status conference calendar with 1 inquiry on it that we will try to power through over the course of the next 56 minutes before our jurors get back. My thought was that we handle Mr. McCoy first because he's patched in from Washington State Prison. And then we'll just go in the order that things appear on the calendar, if that doesn't throw everyone off. Mr. McCoy, can you hear me?
Tell him to come on back.
Hey, we're good.
Good afternoon, Your Honor.
Hey, how are you?
Fine, how are you today, sir?
I'm doing well. Thank you for joining us. Did Mr. McCoy walk away or is he coming back?
He's coming back. He went to the bathroom. He went back.
Okay.
Give me about 2 minutes.
2 minutes. Well, we'll handle a couple others, and if you don't mind muting, and then once he's back, just wave on the screen or something, and we'll switch right to you, okay?
Okay, I sure appreciate that, sir.
Thank you. All right, Mr. Torre, I think maybe we'll do that last, because that'll be a little more involved. We can get some people out of here. So we'll start with Mr. Spencer. Is Mr. Spencer here or online? I know Mr. Wright is online. Let me remove the spotlight here. Hey, Mr. Wright, how you doing?
Hello, sir. I'm sorry I'm coming to you from Rome in my car, so I do apologize, Judge.
Not a problem. You're wanted in many places. Tell me where Mr. Spencer is. Is he online?
Your Honor, I tried to reach out to Mr. Spencer based on the number I had from my file, which was way back over a year ago before I went on medical leave. That was no longer a good number, so I've not reached him. I know Ms. Rockwell had helped with his case and handled his case, so I wasn't sure whether he had found someone else or whether I'm still his attorney, but I wanted to be here. But also, if for some reason he doesn't know to be here, ask the court to consider that on me and give me a little more time to make sure. He was always here before, so I'm not sure exactly where he's at.
Okay, I'm looking at the docket, and your waiver of arraignment form that was filed in November is the last entry by any attorney. A couple days after that, Ms. Nelson entered a scheduling order. So in the docket, at least, you remain the attorney of record. And Mr. Jordan is handling it for the state. What I will first ask is whether you've got all the discovery so that if Mr. Spencer does decide to show up sometime soon, we know this is trial ready or plea ready or however it's going to resolve.
You know, I think I did see a Zoom link come in for with Mr. Spencer's information. I would ask the state to just confirm that they did send it.
I know that on the 3rd of November, Mr. Hand, who is Mr. Jordan's predecessor, did file something saying that there was an evidence.com link that had affidavit warrants, GCIC, a few other things. I'm assuming it's body cam, it's 8 videos. So.
Yeah, I think I did receive that, Judge. This is a relatively straightforward sort of case. It isn't anything that's complicated. I would guess, given enough time to just make sure I can locate Mr. Spencer and that he's aware of court, if we do come up on a trial calendar, we would certainly be ready. I just think, because this was a case that I think he may have been offered pretrial diversion. So I really think this is a case we can avoid trial on. I'm just not sure what happened in my absence with the pretrial diversion.
Okay, so it was a non-complex case till they figured out that Mr. Spencer's a repeat offender. That got it bounced to me. The case is on the April 12th trial calendar. We'll keep it there. I'll deem it as trial ready. I will give you through the end of the week to try to track down Mr. Spencer. Notice was valid in the sense that the last address we have for Mr. Spencer, notice did go there. So if he's not there anymore, he hasn't kept the system, whether that's you or me or the clerk's office, current with his address. He knows how to do that, being a repeat offender. He's been to court before. So I'm going to hold off on a bench warrant until close of business Friday. But I'm going to ask Ms. Nelson to work with Mr. Jordan. If Mr. Spencer doesn't show up, or you let us know, here's good contact information, et cetera, then I will sign the bench warrant. He'll stay on that trial calendar for April 12th, but this does seem to me, like it seems to you, something that you and Mr. Jordan ought to be able to resolve, assuming you're able to track, or someone's able to track Mr. Spencer down.
Yes, Judge.
Does that work for you?
Absolutely.
Okay, Mr. Jordan, is that all right by you?
Yes, Your Honor, and the site has only one additional thing to add. Mr. Spencer.
Can you bend the microphone? Ms. Rivers needs to be able to hear you.
My apologies.
Mr. Hiles was hogging the microphone.
Mr. Spencer was initially accepted into the adult diversion program February 15th of 2022. It does look like he failed to properly enroll in the program, which is why the case was sent back to this courtroom. But I would definitely speak with Mr. Wright going forward so we can come to a negotiated resolution in this case, Your Honor.
Got it. We'll move Mr. Spencer's case to, well, it is on. It will go to the trial calendar. It sounds like discovery was transmitted. Mr. Wright, if you hit that link and it's dead, it's not active anymore, just let Mr. Jordan know. He'll push you that information again. But just looking at the charge, doesn't sound like it's a particularly complicated case. If we don't hear from you, Mr. Wright, or meet Mr. Spencer by Friday afternoon, then I'll ask for a bench warrant to be presented to me. I'll sign it and we will see how it flows. Last thing, Mr. Wright, how are you feeling?
Judge, I am feeling 100%. God is good. I am recovered and cleared of all medical restrictions. So if you see my next conflict letter, you're probably going to see I have maybe 8 special sets already stacking up on me.
I know you're a popular guy given your absence. So I'm glad you're back.
They are rewarding me with special sets. So it's time to get to it.
All right. Well, good luck with all that. Mr. Spencer's case is not specially set down here, but I don't think it'll need a trial. So hopefully we can move it along. You're free to go, Mr. Wright. Thank you.
All right. Take care, Judge. Bye-bye.
We will pivot to Mr. McCoy now, who has returned from his break at Washington State. And let me spotlight that. Whoops, I spotlighted the wrong thing. That's peculiar. All right. Hey, Mr. McCoy, can you hear us? Got some bandwidth issues at Washington State Prison.
Can you hear me, Your Honor?
Yes, sir. Can you hear us?
Okay.
Good. I'm going to focus on your lawyer. I think we'll have a better connection with Ms. Feely. Let me get her on the screen also. All right. If you slide over a little, he can see you if you sit in the center seat. There you are. All right, Ms. Feely, Mr. McCoy has 2 cases on the status conference. Do you have discovery in both?
Yes, Your Honor, we do. And we are very close on plea negotiations. I have some body cam that I still need to review, but I spoke with Mr. McCoy yesterday. I think this is not, this is something that could be added to a plea calendar at some point.
Okay. Well, let's, in that vein, look up. So his 2 cases will also be on that April trial calendar, so a little less than a month away. We'll gladly add it to a calendar before then. Would Mr. McCoy need to be produced, which we can do, but that just would mean it wouldn't be next week. It would be sometime after next week. Or have you talked with him about appearing remotely, maybe with a slightly better connection for the police?
We did discuss that yesterday, Your Honor, and I think he would prefer remote, but I'll talk with him again in the meantime.
Okay, find that out and just work with Ms. Nelson and then Mr. Jordan. Are both these cases yours?
Your Honor, I believe position 12 is my case. Is that correct?
That is correct. And position 11 is mine, Your Honor.
Good morning or good afternoon. How are you?
I'm well and you, Your Honor.
Have you been part of the plea discussions as well, so that when Ms. Feely says, I think these will work out, you're of the same view?
Yes, Your Honor.
Okay, great. Well, the 3 of you coordinate with Ms. Nelson, and if Mr. McCoy chooses to appear remotely, that's easy. We can figure out a lunch break, a before, whatever, to take those pleas if we need to. Otherwise, we are going to need to produce him for the trial calendar. And if he is anxious to stay or desirous to stay where he is, we'll want to get those pleas knocked out soon so that the production order doesn't go into effect.
Understood.
Ms. Feely, anything else on behalf of Mr. McCoy?
No, Your Honor.
Mr. McCoy, have you followed what we were saying?
Yes, Your Honor, I have.
Any questions?
She worked everything out for me, everything I needed.
Okay, well, she will be in touch with you. She will call you. There'll be a better connection. And then I'll just wait to see what next steps are. But as long as you heard that you will be produced to come back to Fulton County Jail if the case isn't sorted out within 3-ish weeks, we need to make sure you're here for the trial calendar, okay? I'll take that as an okay. All right. That takes care of Mr. McCoy. We will help Washington.
All right, thank you.
You're good. Excellent. Thank you, sir. You're free to go.
All right.
Thank you, Washington State Prison.
You're welcome, sir. Y'all have a great day.
You too. We're going to send you some bandwidth from Fulton County. All right. Pressing on with the calendar. Mr. Phillips is next. And here, we'll get Mr. Phillips on the screen. We're just confirming you exist, Mr. Francis. And I saw you walk in, which is a good sign. Let's get Mr. Phillips up. That would be 6 South Booth 1. There he is. Add the spotlight and let me unmute him. Mr. Phillips, can you hear us? Oh, why did that not unmute you? Oh, I unmuted the wrong one. Hold on. Second. Hey, Mr. Phillips, can you hear us?
Yes.
We can hear you. Magic. So you hopefully already know it, but we were very fortunate to get Mr. Francis, who is a participant in our county's C3 project, to agree to serve as your lawyer. He's been appointed as your lawyer. And I want to make sure that Mr. Francis is connecting with the prosecutor so that you are getting the discovery and we can start moving belatedly your case towards trial. How are we doing, Mr. Francis?
Fine, Judge, fine. Thank you for having us today. I have discovery, but I wanted to say that due to my trial schedule, I'm specially set almost through April
2025.
If you could place this on maybe your final plea calendar in May, if possible, I would be ready at that point in time.
All right. That's not going to be a problem. I'm just looking to see where we are. So, Ms. Olivier, how are you?
Hi, Judge Bernie, doing well. How are you?
I'm okay. The other defendants have lawyers. It was only Mr. Phillips where we were casting about for counsel, and we now have it. Excellent.
They should have discovery and everything as well.
Okay. The next event we had was a status conference, I assume for all 3 of the defendants in late May. And that's when we would have the coming together of, does everyone have discovery? Answer for you is yes. We'll make sure the other 2 lawyers do. That's basically final plea. We changed the name, but it's the same. It's a different badging, but it's final plea. If it's going to work out with a plea where your client could withdraw, if he didn't like the sentence, that's at the status conference, which it looks like is May 23rd.
Okay.
That sounds like it gets us beyond your initial congestion. And we'd be at a point then to talk with all 3 lawyers about how do we tee this up. We do have one hiccup, and that is that co-defendant Parks has Mr. Johnson as his lawyer. I am told by GPDC that I will be getting a different C2, that's what we're calling it now, lawyer. We'll see what happens. Don't bank on it yet, but I've leaned into this one. Mr. Parks would need to get that new lawyer, and hopefully May 23rd is far enough away, but what we'll do when that lawyer is named, I will connect him or her with you, Ms. Olivier, because you can get discovery to that person. And that's a couple months. Hopefully by the 23rd of May, we can get all 3 gentlemen LinkedIn, virtually or in person, their lawyers, and say, are we trying and what are we doing? I suspect it would be at most 2 defendants who go. The 3rd defendant Ms. Feely, you should have Mr. Henderson. That this is the case where it doesn't make sense that the public defender has Mr. Henderson because it's a false statement.
And that's a Miss Henderson.
Ms. Henderson, okay. Either way, that defendant has the public defender, hence C2 and C3, but I can't imagine that Ms. Henderson's going to trial. Maybe,
We'll see.
okay, I can't imagine, and it may happen.
Mother of Mr. Parks.
Well, that complicates things.
Yes.
Anyway, let's not get into the facts and circumstances. We'll need to make sure Mr. Parks has a C2 who's in a position to move things forward. Do you need anything else, Mr. Francis, other than May 23rd is a better date for you?
Not right now, Judge. To the extent I have motions, I will file those well in advance of May 23rd.
Please do, because we'll need to tee those up as well.
Okay.
Mr. Phillips, the guy you see on the screen there with the yellow folder, that's your guy going forward, okay?
Yeah.
Any questions?
Yeah. When will I get my discovery packet?
It's real soon. Yeah, we've been communicating with each other by text real soon.
Good, real soon. Mr. Francis needs to get the part that can be paper into paper format, because obviously he can't give you a DVD or a thumb drive or anything, but he will come meet shortly with you, and you'll be able to start looking over all that paperwork, okay?
Yes.
All right, thank you, Mr. Francis.
Thank you, Judge.
Thank you, Judge. That's all I have. May I be excused?
Almost. So you are going to the gang unit?
I am, Your Honor, yes. Effective next week.
Okay, so with whom will I be working on non-gang murders?
Mr. Rabati will be back
Even though he also wears the really pointy hat of supervisor?
for the time being, from what I understand.
All right, so we won't be rudderless.
That is correct.
Okay, so we've got a trial calendar in 2 weeks. Those would be his cases, not yours,
That's correct.
unless they're gang cases.
I will help him as he needs me.
Okay, and do I get rid of Mr. Hiles because you're joining the gang unit, or he stays here?
No, he's staying here.
Okay. All right, I'll be strong. All right, well, we enjoyed your 22 minutes in the major case unit, enjoy gangs. And if there are a couple other murder cases on this calendar, but it's, that's why Mr. Hiles is here. So you're good to go. Thank you. All right. And Mr. Phillips, you are free to go as well. Happy you got a lawyer. All right. Next up is Michael Harper. Needs to be here. There's Mr. Harper. Hey.
Hello, Judge. This one is ready for a non-negotiated plea.
All right. We can't do that today because of this civil trial. But if you would coordinate with Ms. Nelson, we can take that non-negotiated plea virtually, in person, whatever is easiest. Your case, Mr. Jordan?
Yes, Your Honor.
Okay, but let's try to do that. I got time this week. This trial will get to the jury today. But the whole week was blocked out. I know we've got a couple other criminal things going on, but it would be easy as long as you're waiving notice to slide Mr. Harper in for a non-negotiated plea.
Yes, Judge.
But it sounds like in terms of status, you've got what you need and you all have reached a point of disagreement, but not so far apart that it can still be a non-negotiated plea.
Yes, Judge.
All right, Mr. Harper, does Ms. Wood have a good way of reaching you?
Yes, sir.
Okay, she will be reaching you. I may see you later this week. We ought to take this plea as soon as we can, okay? So stay in touch with her.
I'll give you a call.
All right. Anything else, Ms. Wood?
No, Your Honor.
All right. Jerry Hewley. The grown-up is Jerry Hewley. Okay, not the one you were holding. All right. Ms. Wood.
He's mine, Judge. I have everything I need. I have an offer. I just need to get with Mr. Hewley and get an updated phone number for him.
Okay. Who's handling that?
ADA Willingham, Your Honor.
Ms. Willingham, your case. All right. So it sounds like all discovery. Mr. Hewley, before you leave, you need to give all good contact information you have, yours, any significant other, to Ms. Wood so she can track you down. It'll be real important that she's able to do that. Your case is on the April 12th trial calendar. So one of two things is going to happen soon. Either your case is worked out, whatever the negotiations are, and you agree to them, or on April 12th, you're ready to go to trial. Okay? Any questions about that? All right, please make sure Ms. Wood gets the right numbers for you. Once she gets that, you're free to go unless Ms. Willingham, we need anything else from the state. All right. Mr. Swanson is online. Mr. Swanson, if you could join us.
Hi, how are you, Your Honor?
I'm well. I'm looking for you there, and there he is. Excellent. Oh, looks like we interrupted your job, or you're about to get outside.
It's all right. I got off a little bit early for court today, Your Honor. Everything's well though. I spoke to the supervisor.
So, Ms. Wood, status conference, you have the discovery in Mr. Swanson's case.
I am missing some body camera, Judge.
Okay. Beyond that, your review is, you think you've got everything?
Yes, Judge.
And you have some body cam or no body cam?
Is this the one that I'm missing?
Yes, Your Honor, and I can speak to that. College Park just sent my office a letter about 2 days ago stating that they were migrating video footage to a new vendor.
That never goes well.
And yes, absolutely. So any video prior to June 25th of 2022 is going to be unavailable, and they did not give us a timetable on when it's going to be available, unfortunately.
Ms. Wood, your sense of the importance of the body cam video is what? You're entitled to it, but sometimes body cam video is, hey, are you Mr. Swanson? I am, and that's it. Other times it's central.
Mr. Swanson believes it would be really important to the resolution of this case, so yes.
Okay, so like I said, you're entitled to it regardless, but this is one where it's particularly important, and we ought to tap the brakes.
Yes, Judge.
Okay, what can we learn about College Park's deadline? Is that something where a supervisor could reach out? The court should reach out? What?
Yes, Your Honor. I'll have my supervisor reach out and see if we can get a deadline or at least a timeline.
Yeah, just a timeline. I mean, I get it that for a little bit the system's down, but to say TBD, I mean, law enforcement knows better than that. So, and I take it that this footage is from before June of 2022.
It is, Your Honor.
Is this a particularly old case, or, oh, it looks like the arrest was in January of 21.
Yes,
okay, so this footage goes way back.
It does, Your Honor.
All right, so the due out for you, Mr. Jordan, is to let Ms. Wood and Ms. Nelson and me know what College Park says about when we might get this body cam footage. I think Mr. Swanson is on the April 12th trial calendar, which I think has been published. Don't panic. We'll keep it there, but if the state hasn't provided the body cam footage, then it sounds like because it's exculpatory, you'd want a continuance rather than that's the state's problem. Let's go forward with trial.
Correct.
Okay. All right. Mr. Swanson, any questions about what we were talking about? There's a hold up, not your fault, with getting the body cam footage from College Park Police.
Yes, Sean, I understand. All I would ask just for my attorney to maybe call me so we could discuss it more. I haven't really got a chance to talk with her that often, so I really do want to, get to consult the case, get, with my counsel.
Okay, I am confident Ms. Wood will do that. Your case is becoming more front and center, and she moves from case to case as they get more urgent, and yours is on a trial calendar coming up. So, Ms. Wood, do you have good contact information for Mr. Swanson?
I do, Judge.
Great. So she will contact you. You guys will have good conversation about the case, and we'll hear from Mr. Jordan about when College Park can get everyone the body cam footage.
Yes, Your Honor. Thank you.
All right. Say hi to your kids.
Okay. Thank you.
You're free to go.
And Your Honor, I can forward you and Miss Wood the letter that College Park sent us.
That'd be good. Theoretically, court might need to get involved, so it'd just be good to see what they've got to let them know what works and what doesn't.
Yes, Your Honor.
Aquarius Hopkins.
Mr. Hopkins is on Zoom, Your Honor.
All right. There he is. Okay. If you'll sit in the middle seat, and we've got Ms. Charles. Mr. Hopkins, can you hear us?
Yes, sir.
Excellent. Good morning. Good afternoon. I keep saying that.
Good afternoon.
Ms. Feely, do you have the discovery in Mr. Hopkins's case?
Yes, Your Honor.
Any issues that would prevent this from reaching a trial calendar?
No, I need to get Mr. Hopkins in to see me, but we are working on a pretrial resolution.
Okay, let me hear from Ms. Charles after I pull this up. So this is also on, I'm getting the sense all these are on the April 12th trial calendar. Okay, great. I don't have to keep looking it up. Ms. Charles, what's the state's perspective on the Hopkins case?
From the state's perspective, that this is very likely going to be a non-trial resolution. There was one small issue we were trying to work through. I don't know that even if we work through it, it would change the state's posture. And that is, we were trying to get Mr. Hopkins's DNA, we got the cell phones signed to get a third testing done by the GBI because there's a partial. There were two tests on one, there was no real DNA found. The second, a partial profile was found. And we're trying to see if we got an additional DNA. We could get that comparative testing done a third time. However, even with that, we still feel that there would be an issue with the case. And so we're just gonna work through that. We're hoping he would have been here today. We had our investigator ready to go, but
He's not here. Yeah.
So we'll work through that myself and Ms. Feely. However, that's our announcement for now, Your Honor. Although I'm making the announcement today going forward is ADA Hall, who's taking over from me. She'll be handling Mr. Hopkins going forward.
I've heard of Ms. Hall. Welcome back, Ms. Hall. How are you?
I'm good, how are you?
I am happy to see you again. Sad to have Ms. Charles disappear, but it's all these circles that are completing. Ms. Charles was here, she left, she's back. You were here, you left, you're back. That's great. Ms. Hall, if this for some reason isn't resolved before the trial calendar, you will be the prosecutor on the case come April 12th. All right. If it is something that is a plea in 2 weeks, you'll be the prosecutor taking the plea. All right. So important that you hear this. You all are free to pursue additional DNA, et cetera. I won't, if you say I need more time, delay this trial because you weren't able to not so much get the DNA as it is get the GBI to do something with the DNA. That's where you really would impress if you could get them on 2 weeks' notice to do something. But who knows? I just want to make that clear that I understand why you're pursuing it. And if you get it done, great, but that won't be a reason that I would weigh real heavily. Would there be a motion from the state for a continuance? Okay, great. Mr. Hopkins, do you have any questions?
No, sir.
Okay, and Ms. Feely, you've got good information on Mr. Hopkins.
I do, thank you.
Okay, if this is something that can be resolved short of trial, let's try to do it before the call of the calendar so we avoid that kind of congestion. All right, great, thank you. If this was the last, whatever your unit is called case, you both may go. All right. Linda Seals. Mr. Hopkins, you're free to go. Thank you.
All right, thank you.
Ms. Seals is there, Your Honor. That is my case. We have had an offer extended to us that Ms. Seals is not interested in, so this will be ready.
Okay, and I think this may be the case. Ms. Nelson, is this the case? Yes, okay. The alleged victim in this case has been doing a lot of outreach to my office as well, hopefully through the victim advocate who's assigned to the case. And I just want us to be real mindful of her concerns as well. So you're good with discovery. You're not good with the offer. Ms. Seals is on. Does she have more than one case?
Not indicted. I think she has a CP
A
case.
CP case also. Got it. But this will be one that everyone will need to be ready for trial on.
Yes, Your
for
Honor.
April 12th. Okay, any concerns from the state side?
No concerns from the state side, Your Honor. I've made ADA Willingham aware of the unindicted case, which is 20 CP 192548. I think the victim in the terroristic threats case has some concerns about the bond related to that case. So I've spoken with Ms. Harris, the victim in the terroristic threats case at length about the the bond issues with the unindicted case. She believes that Ms. Seals did violate her bond as a result of this case. So I just wanted to say in open court that I've explained to Ms. Harris those issues, that I'm not the prosecutor on the unindicted matter, but I would bring it to Your Honor's attention that she does have concerns that Ms. Seals violated her bond in the terroristic threats case.
So the 20 CP case is older than this case.
It is, Your Honor.
So any bond that Ms. Seals would have received in this case couldn't have been violated by, maybe this has been what you're explaining. I'm just trying to understand the chronology. Neither case is particularly new. The arrest in what I'll call our case, the terroristic threats, was in October of 21. Just by the CP number, that has to have been the year before.
It is, Your Honor.
So if any bond was violated, it would have been the bond in the CP case.
CP case, Your Honor,
Okay.
which is what I explained to Ms. Harris. She just wanted on the record that she was concerned that the bond had been violated in the CP case with actions.
Got it. How would the bond in the CP case not have been revoked given the arrest and ultimate indictment in the terroristic threats case?
That was what I explained to Ms. Harris as well, that may have been an error by my office as far as us not moving to revoke the bond, given that there were specific bond conditions that may have been violated as a result of this crime, Your Honor. I know that's all in the weeds as far as the other case because it's not indicted, but I did tell Ms. Harris that I would bring that to your attention because she was concerned about it.
Sure, I appreciate you doing that, and she should be concerned. Is Ms. Harris associated in any way with the CP case? Is she I don't know what the charges are, but was she the alleged victim in the CP case?
Was not, Your Honor. From my understanding, her only involvement involved helping to bond Ms. Seals out for the 2020 case. They are related. They are aunt and niece, with Ms. Seals being the aunt and
Okay.
Ms. Harris being the niece.
Got it. No, and I briefly read the indictment in this case, and the alleged threat was pretty clear if it was made as to what the intent was. So I understand Ms. Harris's concern, and we got to remain mindful of that. But I assume that in speaking with Ms. Harris, you or the victim advocate uncovered no evidence that Ms. Seals has violated the conditions of bond in the terroristic threats case.
Your Honor, there's some, and perhaps this would be better to have with just the three of us, but there are some things that Ms. Harris brought to my attention that could have possibly violated the bond in the 20 CP case. But I will reserve comment on that in court.
That's fine. I just, as long as your office is being responsive to Ms. Harris's concerns, and if there's evidentiary foundation to them as opposed to emotional foundation, I'd like that brought to my attention.
Yes, Your Honor.
All right, Ms. Willingham, was there anything you wanted to add?
No, Your Honor, I just wanted to acknowledge that I was made aware of it. Unfortunately, I was in court this morning, so I have not had a chance to actually look into it. But I will do that once I get out this afternoon.
Okay, sounds good. Ms. Seals, you've got bonds in two cases. You need to make sure that whatever those conditions are, you're complying with those conditions. And if you've got any questions about that, reach out to Ms. Feely. She's your lawyer. That means she's your counselor, so she can give you counsel on whether something would be consistent or inconsistent with the bond, okay? Yes, great. I will see you at the latest when we call the calendar, the trial calendar, the April trial calendar, because your case is on it. And I understood what Ms. Feely said, which is right now, the way this would be resolved is a trial because you're not interested in the offer that the state made. So we all need to be ready for that trial that week in April. Anything else, Ms. Feely?
No, Your Honor.
Mr. Jordan?
No, Your Honor.
All right. Do you need anything from, you want Ms. Seals to sit tight?
We're going to talk about
Okay. All right. Thank you. Mike Tate. Hey, Mr. Tate. I am doing okay. Ms. Wood, your client.
Yes, Judge, we have everything we need on this one, so it is ready. I think it is on the April trial calendar. I just need to speak with Mr. Tate in the hallway after this to get some good contact information.
Okay. Have you and Ms. Willingham had discussions about resolutions?
She has sent me, yes, we've had some emails back and forth. I just haven't had a chance to connect with Mr. Tate.
Got it. Mr. Tate, it's important that you give Ms. Wood whatever your latest and greatest contact information is, whether that's a phone number or an email address or a mailing address. But Ms. Wood, over the next few weeks, needs to be in regular contact with you because your case that has some serious charges, I'm not saying you did anything, but the charges are serious. It's going to be on a trial calendar in less than a month. And so if this is something that you were hoping you're going to work out, you and Ms. Wood need to be having some serious conversations so she can give you her thoughts about what a reasonable resolution is. Okay? So please stay here until Ms. Wood says it's okay to go. She's going to want to make sure she gets all your contact information. Hey, Ms. Patterson.
She's gonna.
Excellent. All right. So actually, if you go talk with Ms. Patterson and ignore Ms. Wood for right now. So Ms. Willingham, I guess you and Ms. Wood will keep talking. She needs to talk to Mr. Tate, but it sounds like everyone's got discovery and it's ready. We could try it if we need to. You don't have an issue of tracking down your alleged victim. All right, great.
That concludes my business. Can I be excused?
You certainly may. Thank you. Ariane Kelly, and I apologize if I mispronounce your first name. Ariane. All right, Ms. Kelly. Also, Ms. Wood's case.
We are ready for trial, Judge.
Okay, you've got discovery, you've got an offer. You and Ms. Kelly don't like the offer at this point, and so we will see each other in early April for the call of the calendar and then maybe for a trial.
Yes, Judge.
Okay, Mr. Jordan, you have an ability to get your hands on witnesses, alleged victim, et cetera, if this is something we need to try.
Correct, Your Honor.
Okay, great. Then Ms. Kelly, just stay in close contact with Ms. Wood. She's going to stay in touch with you. I understand the posture we're in. Things may change if the state makes a different offer, but otherwise I'll see you for the call of the calendar. Before that date, Ms. Wood will have a better sense because there are a whole bunch of cases on the calendar where yours falls on it. It's only a 1 week calendar, so there are only so many cases we can move. But as cases resolve, you'll move up if you're not already at the top. Okay? Any questions?
No, sir.
All right, thank you for being here. Mr. Wilson and Mr. Smith and Mr. Hiles. Nope.
Oh, I said hello.
Oh, hello. What? We just went through this. Bait and switch. Mr. Smith, good afternoon. You've got all the discovery you need.
I do, Judge.
Okay. And let me look one thing up. This is on the May trial calendar, not the April trial calendar. I know we've got another hearing to have and we'll do that, not today, but there's something else calendared. I just wanted to make sure our status conference is simply everyone have discovery. And then if there's anything else you wanted to bring up.
I do want to bring up a couple things. Judge, I know we're live streaming. I was going to make a specific request. I know we have 2 other co-defendants that are on. They should be online.
They're in their booths.
So I'd like to see if we could possibly go into a breakout room or in the alternative to not have it live streaming so we can address a few things.
Okay.
With all 3 of the defense attorneys.
Oh, the other defense attorneys, me and Mr. Hiles.
Yes.
We can do that. We're not gonna do that first. I want to then take care of things for purposes of the status conference, which is sort of final plea date and everything good with discovery. I'm hearing you, Mr. Smith, on behalf of Mr. Wilson saying, we're good.
We're good.
Okay. All right. Check. And I will come back to your request, which should work. All right. Mr. Pepper, and I saw Mr. Davis on there.
Good afternoon, Your Honor.
Hey, Mr. Davis, how are you?
I'm doing well. And yourself, Your Honor?
I am all right. Let me get your client. That's booth 2, 6 South, booth 2.
He is present, Your Honor.
He is. I understand. I'm just getting him. There he is. Hey, Mr. Pepper, can you hear us?
Yes, sir.
Excellent. We got everyone we need. So, Mr. Davis, thank you for joining us. Do you have the discovery in this case?
Judge, I have discovery and I am reaching out to the prosecutor to make sure I have everything they plan on presenting. So we're good.
Okay. Mr. Hiles, any reason to think there are pieces missing? In other words, there are things you intend to get to Mr. Davis, but you don't have them yet, or you're still compiling?
There's a blood splatter expert that's got a final report. I don't even think that's going to be an issue. We'll talk in just a minute and I'll explain.
Okay.
But no.
Okay.
Short answer is no.
No. Mr. Davis ought to have all the discovery through what you've given him so far.
Absolutely.
Okay, great. Well, Mr. Pepper, your case is on our May trial calendar. So we're teeing it up to try to get it resolved by then. If it's going to be resolved short of trial, it'll need to be short of that date. Otherwise, my expectation will be we are in a position to go to trial with 1, 2, or 3 of the defendants. I know there's a motion to sever in the mix, so it could be we break it into different pieces. If that happens, just so you know, Mr. Pepper, the state actually picks who gets tried first. I don't. So if I grant a motion to sever, then we'll find out from the prosecutor which of the 3 defendants or which grouping will go to trial first. That's not done in the dark. You'd be part of that conversation, so you'd know exactly how that's going to play out. Mr. Davis, anything else on behalf of Mr. Pepper at this time?
No, Your Honor, and we didn't file the motion to sever. I don't think a motion to sever would be a motion that would have merit in this case. And also, just in terms of a multi-defendant case in which you have a number of lawyers, I have decided that Mr. Scott will be the lead attorney. We've discussed the strategy of the case, and whatever motions he makes, whatever objections he makes, we're going to adopt that going forward. And I just want to let the court know that.
Okay, I appreciate that. Mr. Smith's probably able to bear that mantle of lead. There is, as I understand it, a motion to sever in the mix. We weren't going to
Not
talk
by
about.
us, George. Not
No.
by us.
Understand, but
Okay.
you just then said I'm gonna adopt all his motions. So either way, I'm not going to ignore the motion that has been filed.
Right.
We're not working through it right now. I just, that was on my radar and is something that I would need to work through before that May trial date. But you've got your discovery. You've got Mr. Howells's contact information. It sounds like
Yes,
you and
sir.
Mr. Smith and Ms. Fagan have had conversations and
Yes, sir.
you're comfortable with where this is headed.
Yes, Your Honor. 100%.
Okay. All right. Mr. Pepper, you are free to go unless you've got any questions for me.
Judge, can we stay around for that conference? or-
You can, do you want Mr. Pepper staying around?
No, Mr. Pepper doesn't need to stay around, Judge. I'll stay around if they need me, but he doesn't need to stay around for a conference.
Okay, great. That's up to you, Mr. Pepper. You can stay in the booth. You can listen to what Mr. Davis said, go about your business, but we're done discussing your case unless you have any other questions.
I'm done.
Okay, all right, I'm gonna mute you. And we get to the third co-defendant and last person on the calendar other than Mr. Torre. And that is Mr. Hall. And I need to figure out, so he's 6 North Booth 1. There he is. And there's Miss Fagan. All right, let me unmute 6 North Booth 1. Excellent. All right, Mr. Hall, can you hear me?
Yes, sir.
Good afternoon. We've got your lawyer, Miss Fagan, here. We've got the prosecutor, who I don't think you can see, but you'll be able to hear him, and that's okay. Ms. Fagan, do you have the discovery in this case?
Yes, Judge.
Any discovery issues?
No.
Okay. Mr. Hall's case is set for trial, as you have heard, in mid-May. As I have heard, you're on another case as well that takes up some of your time. We'll need to navigate that when that date approaches. Anything else other than the conference Mr. Smith has asked for that you want to discuss at this time concerning Mr. Hall's case, Ms. Fagan?
No, Your Honor.
Mr. Hiles, anything on Mr. Hall's case?
No, Your Honor.
Okay. All right. Then if you all will sit tight for a second, let me understand what we're going to do with Mr. Torre. And he's on the screen as well. And then we can, does he need an interpreter?
Does, but it's just going to be a quick announcement.
Okay. Why don't you make your quick announcement?
Sure. So we have transportation through Ms. Patterson to take him to the housing and program that we have set up for him on the 28th.
Okay.
So working with Mr. Jordan to get the appropriate orders done to get the case where he can be released.
Okay.
So
And you know, Ms. Sellers has leaned into this case as well.
I am aware, Your Honor. I believe that she may have emailed a proposed order, I believe. And as soon as that order is signed, her involvement with the case will end.
Okay, got it. That just pulls it out of her realm because it's the restoration to competency. And then Feely and Jordan can sort things
Hey,
out.
Ms. Hayward, listen, I'm in a video.
That's Mr. Davis. So this is a resolution to the case, or it's a relocation of Mr. Torre out of jail and into supportive housing and care?
it's our hope that it will be a resolution.
Okay, excellent. Do we need to connect Mr. Torre with an interpreter, not today, or when you connect with him, you have a Spanish capable person with you? How is that going?
I think we'll be able to handle that on our end.
Okay, I'm anxious to see this work out. If I can assist in any way, let me know. But it sounds like I could write on my notes that the 28th.
Yes, sir.
That's March 28th, not August 28th. March 28th would be transport. So at some point before then, we're getting Mr. Torre in court for a plea. What are we doing? Or it's going to a dead docket? What? Just so I understand the rough contours.
We're still pretty, I think we're getting closer to either one of those resolutions, Your Honor. It may be a dead docket. I still need to talk to my supervisors further about that.
Okay.
I believe that we'll have it resolved by the 28th.
Okay, whatever it is, if it involves Mr. Torre needing to come to court, we'll just need some notice. I will borrow a spot from some other judge to get him here. But the 28th is 13 days away. And someone, position 1 on the consolidated calendar announced it's ready. Your colleague from Judge Cox said she's ready. So you got at least one case ahead of you on Tutman. I haven't received any other announcements, but let's stay focused on Torre. Okay.
Yes, ma'am.
Anyone know how to let Mr. Torre know he can go? Hey, Mr. Torre.
You know, he actually does understand some.
Let me unmute him and let's see. I got to reconnect. And I'm gonna, it's nothing personal, guys, but I'm removing you from the spotlight. All right, Mr. Torre, how are you today? Good. There you are. You can go now. I appreciate you being here. I had to talk with your lawyer, okay?
Okay.
All right. But we will see you soon and we hope to be getting you out of jail, okay?
Okay, thank you.
All right, thank you. You can leave the booth now. Bye-bye. Bye-bye, Mr. Torre. Thank you. All right, I'm circling it in red, March 28th. Mr. Smith, all that's left is to have this conference. I'm not quite sure. I can't shut down the Zoom because it's going to be the trial that we pick up on. So
Do a breakout room with the attorneys or no?
I'm just thinking through the mechanics of that. Let's try.
Okay.
Let's see.
And I could always go back to your chambers too, if the court invites me.
I don't invite you. I think we can do this. Let's see. Is that first? Can it not be taken down? So
Yes.
Ms. Rivers doesn't need to worry about it. Okay. So Ms. Rivers and Ms. Jackson, thank you so much for joining us. We actually had a plea we could take today. We don't have time to do that. But we will make that happen soon. And Ms. Tucson's here in person. Thank you all for being here. You are free to go.
Okay, Judge. Have a good afternoon.
You too.
May we be excused as well, Your Honor?
Yes, ma'am.
Nice to see you.
Same.
I was here, so I came home.
All right. So we'll add Mr. Davis and Ms. Fagan and
Podium.
the podium I'm gonna.
Okay. I could always mute it, I guess.
That's what I'm gonna try to do is mute the podium and add the defense attorney one. But let's see. It's not letting me.
May I piggyback on the request?
Yes, yeah. No, everyone else is free to go. Mr. Hiles needs to stay. It's not, we'll try this. Mr. Davis joined, witness joined. Let me mute the podium. All right, Ms. Fagan and Mr. Davis, you should be back in. I sent you to the breakout room because we were trying to figure out technology that would get you all of us into a breakout room, but I couldn't do it and not have the whole courtroom be in the breakout room. Can you hear me now?
Yes, Judge.
Okay, great. So I got an update from Mr. Smith, who Mr. Davis indicated could be a spokesperson of sorts. Ms. Fagan, you didn't say that, I understand. But Mr. Hiles or Mr. Smith can give you an update about what we discussed. It was basically helping me understand some of the evidentiary developments that will be influencing the state's decision-making about who goes to trial, if anyone does, and what the next steps are for the state. There are 2 Apple iPhone extractions that they are waiting on. It's a re-extraction from Apple. That's the only thing that's left for the state. And that would only, it sounds like, further confirm their greater understanding of the events that transpired inside that vehicle. That's sort of a summary. I don't want to go into any more detail, but I encourage Mr. Davis and Ms. Fagan to contact either Attorney Smith or Attorney Hiles. And I'll just stay in close contact with all of you so that we can make sure we're moving this case along. Ms. Fagan, any questions on behalf of your client?
No, Your Honor, I'm aware of where ADA Hiles is. We discussed the case yesterday. I think, and I really look forward to their digging deeper.
Okay. It sounds like he'll do lots of digging. I don't know that the phones are going to change a whole lot, but where they are now seems like a situation that's not a terrible situation for your client. Mr. Davis, anything you want to add? Mr. Davis, you still there? Okay. Well, I'm going to pivot back to our civil trial. So if you don't have any more questions, Ms. Fagan, you're free to go. I'm going to thank you, Ms. Livingston, for lining up the 4 folks we needed to talk to. And I will let you all go. Thank you.
Thank you. And Mr. Hall, you have an early morning visit on Friday. Thanks, Judge.
You bet. All right, let me remove all those. And I think counsel in Lavone versus Floshea, you can migrate back to counsel table.
And Your Honor, I do have some protein bars in my backpack if anybody.
I'm good. I'm gonna go get something in just a sec. I don't mean go out to American Deli. I wouldn't do that. No, American Deli's, I just like poking at them a little bit.
Here, you put on water? Well, I have that one there. Okay. Thanks.
Whoops. Right, I think we've got all the right things. I'll be back in a couple minutes. Are our jurors back? Do you know? They are? Fantastic. Just give me a second.
Just, okay. Okay.
Yeah, I'm glad I have this jacket on. It's cooler than it was yesterday.
Yeah.
No. Tell her she's coming. What to do?
Now you're conscious about it.
I'm not conscious about it. I know my job.
Yeah. Had a, what are they called? Cuties, little orange guys. You have more time. Exactly. The plaintiffs disappeared. Are they coming back?
I would assume. If not, I renew my motion.
What's the exhibit number of the ledger? Of the ledger? 35.
35 or 36?
35.
I like that. Just found another piece of evidence. No, it's helpful in case I get called out on like, I wasn't listening. But that means you're human, which is good because we've got machines. Yes.
Sitting next to those. Just make sure you.
All right. Mr. Sterling, are you ready for the jurors to come back?
Yes, sir.
Anything else we need to talk about before then?
No, Your Honor.
You should mute your computer, please.
Oh, now. Yes, sir. Oh, my Zoom.
Yeah.
There it is.
All right. Mr. Williams, ready for the jury?
Ready for the jury, Your Honor.
Let's bring him in.
All right, for the jury. Jurors are present.
Thank you, Deputy Gordon. Folks, you may be seated. Welcome back from lunch. Thank you for being here. You missed out on some excitement in the courtroom while we dealt with some criminal cases, but that is done, and we are returning to this case, Ms. Embry, you remain under oath from before lunch. And we were in the midst of cross-examination from Mr. Sterling, who told me he was done with N, but N looks like it's back on the screen.
Well, Your Honor, in fairness, I contradicted myself because I said I wanted to move on and then bring it back up so the jury would be able to see what we were actually talking about.
Okay, now they can see it. You're a witness.
Thank you, Judge. Miss Embry, it's my understanding that you testified on direct examination that it was you and your electrician who you chose that did the electrical box inside of the facility. Is that correct?
That my electrician installed the new three-phase panel, yes.
Okay. And that was done in 2021, is that correct?
I think so.
It was, well, let's say it wasn't at the beginning of the start of their occupancy of the building.
Again, I did a lot of work on those buildings in terms of the date. I'm not certain about the date. And if that's where it is, then that's where it is.
Okay. And then, and I know that you and I are not, well, we wouldn't be in court if you and I agreed on everything, but
Sure.
I know we'll disagree on whose responsibility it was to do what. But I wanted to make sure the jury had an opportunity to see what you and I were talking about before the break. And if you go to the second page of Defendant's Exhibit N, as in Nancy, and this was as we discussed, and you don't have to agree with the content. I mean, you don't have to agree with the substance, but there's a Mr. Electric of Metro Atlanta sending an email to management at thomaslavone.com saying, thank you for choosing Mr. Reuter, Mr. Electric for all your service needs. Is that fair? Is that correct?
Yes, that's what it says. Again, if you have a copy of what they wrote, the contractor might help.
Sure.
I don't know. Yeah.
Sure. And I'm not necessarily going into the contents of that, just.
Oh.
Yeah.
Okay.
And then management at thomaslavone.com sends an email that says on March 16, 2021, that says, please see the attached electrical report regarding code violations. I'll look forward to hearing from you both soon, but you can't tell who that's to, or you can't tell who that's actually forwarded to based on what you see there.
Is that a question?
Yes, ma'am.
Say it again. I'm sorry.
Yeah, you can't see.
I'm
who
trying to
it's-
picture the contractor's thing and I got to,
No
so
problem.
you're not going to have that.
No,
Okay.
no, I don't have that.
I apologize.
So it says it's management at thomaslavone.com wrote, please see the attached electrical report regarding code violations. I look forward to hearing from you both soon on March 16, 2022.
I see those words. I'm not certain about a code violation. If I wrote it as a general contractor, I probably would believe it, but I'm not certain somebody is not that. Okay.
Sure. And I'm not
Yeah.
saying you have to agree with the substance of it, but that is what's there.
Thank you.
Okay.
Yeah. Thank you.
And then there's a response from you, Shay Embry at Lucky Star.
Yes.
Please see Article 3 of your lease agreement. Is that fair?
Yes.
And it's referencing the as-is clause in the.
Correct.
Okay. And then Mr. Lavone responds, thank you for your response.
Further, it likely, because again, this is a partial email and there were so many emails, I apologize, I don't remember all the details, but it's unlikely that I responded that way without having seen the contractor's list and having been certain that it was the responsibility of the tenant.
Sure.
Okay.
But you would agree that this is sent on March 16, 2022?
Yes.
And that would be
absolutely.
before the legal letter on March 22nd, 2022?
Yes.
Okay.
The legal letter, meaning the letter from Mr. Burrows,
Yeah, the letter Exhibit D2.
Saying that it needed to be
condemned.
condemned.
Right. His letter saying there's electrical issue, there's plumbing issues, there might be a condemnation issue that he sent on March 22nd, 2022. This was before that.
Yeah, absolutely. Yeah.
Now I want to talk a little bit about the rent payments that were made. I don't remember the number. I think it may have been defendants 37, 35. You mentioned in your direct examination that you had a conversation with Mr. Flournoy about the rent. Is that correct?
Yes, I do every month.
And that you had a conversation particularly about Mr. Woodard, Mr. Wesley, their company paying the rent a little late each month. Is that correct?
Yes, we discuss all tenants every month. Yeah.
And you actually had a conversation with him about whether or not you all should continue to accept the late payments or make a change in whether or not you should accept the late payments.
Yes, until our decision changed in September of 2021.
Okay. But at the time that you had that conversation with him, he said, no, it's fine. We'll keep accepting the payments. You described it as chasing the payments, but we might describe it differently. We'll keep accepting the payments, the late payments.
Yeah.
And then you said in September 2021, there was an email sent. Is that correct?
Yes, there was.
And we've seen a lot of emails in this case. Is that fair to say?
Yeah.
Did you provide your counsel with a copy of the email or bring it today for the
Yes,
jurors?
He has that.
Let him finish his question.
I
I'm not sure
apologize.
which email he's going to be asking you about.
Okay.
You provided your counsel with a copy of the email you sent to my client saying in September of 2021, saying we're not going to accept any more payments that are late.
No, that's not what it said.
Okay.
It said that the late payments will now be charged.
Okay. And and have you brought that email with you today?
Apparently the answer is yes.
Yes.
And it's your understanding that they were told in that email that that any further payments would be considered late and they would have to pay the requisite late fee?
Yes, to which the response was, we have the lease, we know. And they started paying a late fee in September of 2021.
Okay. Now, if you look at the chart that you provided, Defendant's Exhibit 34, and let's look at January 18th, 2022.
Yes.
That's the date rent was paid?
The January rent was paid on the 18th of January. They owed a late fee, but they did not pay it.
Okay.
The triple net was paid at $500, but it was short by $2.06. So at that point, they were in arrears $152.06.
Okay. And then the next time they paid rent was on February 15th, 2022. Is that right?
Correct. Again, they didn't pay the late fee and they did not pay the triple net fee of $502.06.
Okay. And this is a document that was created by Mr. Flournoy?
Yes.
Okay. And did he keep copies of the receipts or the
Yes.
dates in which they were deposited?
All of them. We have them here.
Okay.
We have actually the original checks that were given to us, as well as printed copies.
And were they checks or money orders?
Money orders.
And he kept a copy each time one of those was paid?
Pardon me?
I'm sorry, he kept a copy each time my clients provided
Yes,
one.
yeah. And he records it with a photocopy every time, as well as keeps the original in the file. And again, if you'd like to see them, we have them here.
And so in September, you said, we'll continue to accept the late payment so long as you pay the late charge.
What we said is that your late charge will begin in September.
Okay.
The reality of our lease agreement, according to my understanding, is that when we told him that he had to start paying a late fee, if we had chosen, we could have changed the locks and taken possession as soon as he was late. So for example, on the September rent in 21, he didn't pay it until the 18th of September. And so we could have taken these same steps then, based on my understanding of the lease agreement.
Okay.
And every month after that. Almost.
And I want to go back a little bit to the beginning of the relationship between you and my clients. You said that when they initially accepted the property, they took it as is that
Yeah.
correct? And then they started a build out of the inside of the property. Is that correct?
Very slowly. And I don't remember, but I remember at one point, I'm like, are they ever going to open? I mean, I think it may have been 10 months after they took possession. And I'm like, and the reality is their lease agreement required that they were open in 90 days. It was COVID. We relaxed it. I'm going, when are you opening? When are you opening? So that became an issue.
And at some point, you were able to see the improvements or the changes they had made within the building. Is that correct?
I saw them partway through, as I described earlier, when I had a conversation with their contractor and expressed concerns about the lack of ADA requirements met.
And did you put those concerns in writing to my clients or to their contractor?
No.
And we saw a picture that was admitted in an earlier exhibit from plaintiffs, a picture of you at the grand opening. Is that correct?
A picture at the grand opening or at when they did their, they did a fashion show on my other property. That's the photograph.
Okay.
Was at a fashion show.
The picture that had Thomas Lavone LLC in the background with you at the microphone.
Yeah, that is on my other property on what it's an AstroTurf area, and they wanted to have a fashion show on our other property, and I'm like, great, let's do it.
Okay.
And they asked me to speak.
Okay.
Yeah.
But that wasn't.
And I was thrilled to.
Sure.
Yeah.
That wasn't on the 2291 Cascade property though.
No, it was not.
And you said that when they were doing the build out on multiple times, they kept asking you to come by and see it.
They were just like, come by and see it. We're so excited. And I was busy.
Okay.
I had 13 units to work on.
But they weren't trying to hide what they were doing. They were
Absolutely
inviting you to come
not.
by and
Not
see
one
it.
time. Yeah.
Now, prior to 2022, my clients had not complained of any issues with the electrical box or electrical issues. Is that correct?
Prior to 22, I don't remember the dates. I feel like they had that issue about the condensate line that we moved down. I think it was in 2021, but again, I don't remember the date. I apologize.
And prior to 2022, they hadn't complained about rainwater flooding into their buildings.
It never did that until the wall was changed and the door was changed.
Good.
And by the way, it was a horrendous rain, so.
And when you say the wall was changed, you mentioned that there was an air conditioning unit up top. Is that correct?
Yeah. Mhm. And a doorway that was sealed.
Well, we'll do it one at a time.
Okay.
Let's talk about the air conditioning unit first. So there was an air conditioning unit that was like a wall unit or window unit that was up there. And how did they change that?
They took it out and put in glass block.
Okay. So
And the glass block was installed set further back, which allowed the water to go in between the two bricks that was the structure of the wall.
Okay, so it was an air conditioning unit that was taken out. And I think you said it was an old air conditioning unit.
It was, if you can picture an opening like this that had to have been a window at some point in history. It's a 1950s building that had a wooden, a piece of wood that was set close to the edge of the brick on the outside. And then the window unit was mounted inside that that wooden panel. And so as you can remember, window units where they jut out,
Sure.
that's what it was.
Okay.
And somewhere I would probably have a picture of that here.
And you said they took that out and just put a window in,
They put glass block windows in.
glass block windows.
Yes,
And it's your contention that that's what caused some of the leaking.
I know that it did.
Okay.
In fact, I had my guys out there and the mason and the waterproof, and we ran a hose over it. And while I'm inside, they're running the hose and it came out the bottom.
Okay. When did you do that?
Not long after they moved out because I needed to repair it. I didn't want to damage my building.
Okay. So after they moved out, you repaired that.
Yes.
And do you know when they took the air conditioning unit out and put the window in?
I don't remember. I remember seeing that the work was being done and concerned. And hopeful that the person putting it in was doing a really good job. And when you looked at it from a distance, it looked really good. And I can imagine that they thought that it was well done as well. But under closer examination, it was not done properly.
Okay. And did you provide a report of what your inspectors saw, what the results of that was related to that window unit?
No, they were no longer my tenants.
Did you provide or do you have that report with you subsequent to what?
No, there was not a written report. I'm a general contractor, so I could look at it with my people and know what needed to be done. It was pretty obvious.
And what about a picture of what you were able to change within the
Yes,
building?
we have that.
And
Yeah.
I'm sorry. Oh, I'm very sorry. Yeah.
Okay, but both sides, but in particular, you may know where Mr. Sterling's going with the question, but
Apologize.
until he comes to full stop, you don't buzz in early. Let him
problem.
finish, and that way the court reporter gets the full question and then the answer.
My apology.
Picture of what you were able.
what you were able to change? Did you?
Yes,
Did you provide a picture of that? Do you have it with you today?
my attorneys have that.
Yeah, but can I see it? Can I see it?
33 in the note.
It's in the notebook.
33, Your Honor.
Got it.
Now, is this the picture of what you installed subsequent to my client's leaving?
No. The one on the left at the top with the red arrow says window unit when tenant took possession. That's what was in there.
Okay.
If we're going to get into the details, do you have any objection, Mr. Sterling, to the admission of defendants 33?
I don't, Your Honor.
Okay, let's admit defendants 33. And then, Mr. Brickman, if you don't mind publishing it, that way everyone's following along.
You want me to continue?
Yeah, just walk us
Just
through.
wait till it's on the screen.
Okay.
Yeah, walk
You
us
got
through
it.
what we're seeing. So the first picture to our upper left says window unit when tenant took possession, and that's the air condition we're talking about.
Yes,
Okay. And then window unit removed by tenant, which is the square window blocks you were talking about.
glass block.
Glass blocks. Okay. And then water sealed door at the back when tenants took possession is bottom left corner.
Yes, and I'm sorry, it's not a better photograph. I searched through all my things, but if you'll notice, the door is white. And it was a sealed metal door that no water seeped through it.
And then you said, and then water sealed door removed by tenant and was replaced with a wooden door.
Yes, and again, I'm sorry, it's not easy to see, but you can see that it's a 6-panel wooden door. And there's no paint on it. There was no waterproofing on it.
And then on the next one, is this what happened after you took back possession? You bricked up both of those?
Yes, once we took possession of the property, I had our mason come in and completely close those spaces off. And I put a receipt on there.
The $1,400.
Yes.
Okay. Now I want to talk a little bit about the day in question. We can go back to the Friday, the 29th, April 29th. And that was the day that the locks were changed on the building, and
Correct.
And Mr. Woodward was asked to leave.
Correct.
And he left the building that day at the direction of the police officer that was on the premises.
He may have left, but he was still at the building when we went over to have dinner, because Bobby walked back down and told them that they were welcome to come in over the weekend and we'd like for them to come get their things out. So I don't know what time after that they left.
Now, was there a discussion about at that point, at that date on April 29th, you've heard the testimony. Do you recall the discussion where they said you have until that one of the sergeants came and said everybody agreed that they'd have until 4 p.m. on Monday to get their things?
That's not my recollection. I know that we put in writing that they had till 4 p.m. on Friday, which we gave them more time. We gave them through the weekend. And my recollection is that Bobby was clear that I was not available on Monday, but was clear that he was not available until before noon. So it had to be in the morning on Monday. That's my recollection.
And do you recall the email that we saw in evidence of Mr. Flournoy saying, come get your things by noon today?
Yes.
Okay. But you all went into the building before noon. Is that fair to say, to start removing the items?
We did, because the tenant sent us a response to the email, which you've seen, that says we will not remove the items today.
Sure. We'll plus later, me and Mr. Williams, about the classification of that document. But you had told them they had at least until noon, but they sent you an email earlier than that, and they said there wouldn't be a removal today. Is that fair?
What I know is that they said we're not removing anything. So if they're not removing anything, it seemed like a perfect assumption to go ahead and get done what we needed to do.
Were they incorrect in saying that they did in fact show up when they realized you were removing their things? Did they show up at that point?
At some point in that, yes.
And did they ask, hey, please let us take our things?
I do not remember that. But at that point, the people that I had, excuse me, I apologize, tasked with removing the items, I had already given them the items and said, they're yours, take them out.
Okay. So you had actually given the items away at that point to other people?
Yes, I'd asked them to remove them from the property.
Do you remember Commissioner Abdul Rahman showing up and asking could they get their things back and waiting with them for a couple of hours?
I'm sorry that I don't have that memory. First of all, I didn't step out of the building during that time. So if the commissioner was outside, I wouldn't have seen her. And frankly, I didn't know who she was. So even if I saw her, I apologize. I just wouldn't have known who she was. And there were a lot of people around.
And what about the NPU chair, Mr. Donovan Dobbs? Do you recall him trying to mediate and say, hey, why don't you just let them get their things back?
Again, he didn't come in the building. I was inside. I did see Donovan on the streets out there, which was a little confusing because he was with NPU-R and our building is in NPU-I. So I was somewhat confused with his presence and assumed that he was just there in the capacity as a friend.
But my clients were there and available to get their things at the time those things were being removed.
They did not request to get them. They sent me an email and said nothing will be removed from the property on that date.
And now that's the email, but they were there as things were being removed.
And they never said, let me have my things.
So now it is your recollection that they never asked for their things, because just a moment ago, you said you didn't recall if they asked for them or not.
I do not recall them doing that. And that's what I'm saying. I don't recall them ever saying that. And I apologize if I created confusion on that, but I didn't interact with them. I stayed on the inside of the building.
And is it also your testimony that you never touched any of their items? You had other people do it?
Yes.
And what happened to the property?
I have no idea.
You don't know what actually happened to the items that were removed?
No.
Do you know where the property is right now?
No.
Were you aware that your lawyer represented that the property was completely discarded?
Your Honor, I said disposed of.
Right, so we shouldn't testify for different people. Ms. Embry has testified as to how she dealt with the disposition of the property. Other people left with it. You can ask her, does she know what other people did with it? But we're focused on her knowledge.
Can you give us the names of the individuals who took the property?
There was one person that had a name, and then
I don't
she
know that
had,
we need to get it on the record. If that's some information that you want to get, you can get that. But if you can tell me how it's relevant that those names are made part of the record of the trial, the testimony has been, as I've understood it, and the jury will make their own conclusions what the testimony is, other people than Ms. Embry left with your client's property.
Well, Your Honor, in all fairness, we were told the property was completely gone, and this trial is about the fact the property's been gone, discarded, disposed of. If Ms. Embry has knowledge that people have this property and that it is still available for my clients, I believe that's highly relevant.
How is that relevant to what this jury decides? Because your clients don't have it now. That doesn't change whether I'm saying you can get this information. I don't know why you need these names aired out in public.
Well, Judge.
How is your closing argument different if you're able to say Fred Smith left with the garments as opposed to someone left with the garments? How do you make a different argument, argue for more damages or different damages if it's Fred Smith who left with the garments than someone other than your clients left with them? Either that person was entitled to do it or not entitled to do it. And if they weren't, you argue conversion. If they were, the defense argues something. How does the identity of the person who walked away with the belongings of your clients matter to any argument you need to make to this jury in this case?
Well, Your Honor, maybe not the identity of the individuals, but the fact that Ms. Embry can identify them and has failed to do so, I think that is relevant.
Explore that.
Okay, thank you, Judge. Ms. Embry, at any point did you provide the names of the individuals who took my client's property?
did I provide them to where?
To anybody?
No, I don't. No.
Do you know who they are?
Again, I know one of the persons, and then she brought people that assisted in the removal of the property.
And when my clients asked for the property back via a TRO hearing, did you do anything to reach out to those individuals to see if they could get my clients their property back?
No.
And so you had basically disposed of the property.
To my understanding, I have no responsibility to store any property that is left behind by a tenant. That's just my understanding.
And you mentioned that when Mr. Williams asked you, why didn't you just give them the property back? It seems harsh. You mentioned you had seen a Facebook message from one of my clients that disturbed you.
The reason that I continued with what I was doing is because I got an email that said, no, nothing will be removed from the property today.
But on direct examination, if we're being fair, Mr. Williams asked you, why would you do this? This seemed harsh. And you said, I was done. I was fed up. I saw this Facebook message from Mr. Woodard
that said, I hope she doesn't wake up tomorrow.
And did you copy that Facebook message or provide it to Mr. Williams so the jury would have it here today for their
Yes.
consideration? You have a copy of that message, that
Yes.
video.
Happy to show it to you.
You have a copy of a video of Mr. Woodard saying that.
Yeah.
Yes, Your Honor.
I have a copy of a video that he took and posted of me standing on the street and his commentary saying, I hope she doesn't wake up tomorrow.
So if you've got that, let's play it.
And these were previously identified.
Okay, this would be defendant's exhibit 36,
19.
19. It's already in there. Okay.
So keep all of mine muted and then this should play through the.
Correct. If you click the audio, share audio box. But just so we're clear, that's why there's nothing on for tab 19 in my binder. It's empty because it's a video.
Correct.
Mr. Sterling, any objection to the admission and publication of defense 19?
I have no objection, Judge.
Okay. Yes, it's admitted.
I must have messed something up.
You can try playing it with your audio on as well. We'll get that reverb, but I don't know if the audio starts at the beginning.
It does.
Oh.
Now, is that you right there, Ms. Embry?
I'm sorry?
That you that we're looking
Yeah,
at
that's me.
with the police officers?
Yes.
Here. And is this May 2nd? Is this May 2nd, the day the items are being taken out?
It likely has a date on my recording, but I don't see it on here.
Let's not talk while it's playing because of this. You can ask questions after it's played.
I don't know that helped provide any clarity, Judge.
We can blame that on Mr. Brick.
But the date on the video is 5/7/2022. That was at the bottom. Was that correct?
Your Honor, that's the date the video was.
That's,
posted.
the day the
that's
video
when
was
the video
downloaded.
was taken, yeah. Because that, you could see kind of in the background, because I didn't know how to save it. I'm not that good on saving things on Facebook. And so I videotaped it on my phone.
And that was part of the reason that you were upset that day, and part of the
No.
reason when you were fed up and done.
No,
That didn't
it
upset
was
you.
pretty rude. I apologize for interrupting. It was pretty rude. But the
Fair enough.
reason that the reason that we were doing what we were doing is because they had not paid their rent, their late fees, or their triple net, period.
Now, on the date of, according to your chart, my clients didn't pay the March rent until April 14th.
Correct.
But you heard testimony earlier from my client that they actually paid it before March 14th. I'm sorry, before April 14th.
I hear what you're saying, but we have checks that show the dates.
Okay.
And the date that the check was written, the cashier's check is stamped with April 14, 2022.
And then the second one was paid on April 27, 2022.
Yes.
And
we did not cash any of that.
And then on April 29th, 2022 was when you said they had until 4 o'clock that day to remove their items.
There was an
Friday.
email that went out on a date. I don't know what day we sent that, and I think it may have been on the 27th that we emailed and said, you have until 4 p.m. on Friday, which gave another 2 days.
And then Mr. Flourney sent a subsequent email that said you had until noon. Is that correct? Noon on Monday.
Then Mr. Floyd and I went to him and gave them all weekend. So it went from Wednesday with a deadline for Friday. They didn't meet it. And then it gave them until Monday at noon, and they didn't meet that.
But you were moving the items before Monday.
They said they were not removing any items for that on that day. That was a pretty clear statement.
But you did move it before noon.
So we're going around in circles here now. If you want to explore a different topic, but we've covered these several times.
No further questions, Judge.
Any redirect?
Very briefly, Your Honor. Mr. Sterling questions you about plaintiff's exhibit N, which is this email. The subject is your invoice from Mr. Electric at Metro Atlanta.
Yes.
We hashed this quite thoroughly. They sent you what we believe may have been an invoice for electrical work. You said not landlord's responsibility, as is. And towards the bottom of that first page, you see management at thomaslavone.com's response to you, where you are saying this is not my responsibility as landlord. They say, thank you for your response. I will forward this accordingly. You see that?
Yes.
And then above that, we see what seems to be the forward of that. March 16th, 4:02 p.m. They respond, I'm going to forward what you've told me. We don't know to who again, maybe the council, maybe whoever. But we see above that at 12:09, March 20th, they forward it to engage@mpuratlanta.org. Do you know who that is?
Did I what?
Do you know who engage@mpuratlanta.org?
I'm assuming it's Donovan Dodds that testified earlier. That again, he's an NPUR, so it was confusing because we're an NPUI.
Do you know why your tenant was forwarding this to them on March 20th?
No.
That last sentence in that email says, it is my understanding that a grant was granted to the owner to ensure infrastructure updates were made. I think you touched on this briefly, that you don't know what grant.
I don't have any idea what they're talking about.
Did you receive any grant monies from the city of Atlanta or for anybody to make infrastructure improvements to this property?
There was a storefront improvement grant that was offered for our district a number of years prior to this. And they awarded us 2 of those. One was for Buzz Coffee and Wine House, and one was for Sound Resort Studios. And we completed the work, turned in our receipts for the work, and then was repaid for the work done at that point. But again, that was when Buzz Coffee was coming in, which I think would have been in 2017.
But that wasn't for electrical work or infrastructure
No,
work?
and I have never applied for another grant. No.
Do you know why your tenants were purportedly turning you into the MPU on grants?
No.
Mr. Sterling asked about it, and you talked about this September 2021 email. And I just want to make sure we get that into the record. So I'm going to show and mark that is not in the notebook. Defendants, what I believe is 36.
Correct.
May I approach, Your Honor?
May? And Mr. Sterling has a copy?
Yes.
No objection, Judge, to its admission.
All right, 36 is admitted.
So we can get that on the screen. Let's start with the second page. Bottom half of the first page, and then the second page. Do you recognize that?
Yes.
What is that?
You're talking about the part that is section of late payments?
Correct.
That is providing them a cutting from the lease agreement of section 11.10 that states the guidelines of how late payments are paid, which means that after the 5th of every month, they are then to pay that money.
And who are you forwarding that section of your lease to? If you look at the first page.
John Wesley.
No, let's look at the bottom of the first page.
Bottom of the first page. Bobby.
And why would you have been forwarding that to Bobby on September 9th, 2021?
I can only assume that he called me and asked me, and I sent him a copy so that he could provide it to the tenants.
And then above that, does he provide that to the tenants?
Yes, he did.
And do the tenants respond to that?
Yes, they did.
And what do they say?
They said, Bobby, again, we have our lease. We are clear. We got you.
And this is September 21st, 2021.
Yes. And that's the month that they paid on the 18th.
I'm going to show you what I'm going to mark as Defendant's Exhibit 37. May I approach, Your Honor?
Yes, actually, both sides have continuing authority to approach witnesses until revoked.
I still will probably ask.
Okay.
37. Mr. Sterling asked you if you had receipts or check stubs or anything like that. You said you did. You said you still had the originals and you had a copy. Do you recognize Defendant's Exhibit 37?
Yes. These are the copies of the checks that were written.
I would move to tender Defendant's 37 into evidence.
No objection.
37 is admitted.
No further questions, Your Honor.
Mr. Sterling, anything else?
No, Your Honor. Thank you.
All right. Questions from the jurors for Ms. Embry? Deputy Gordon will collect them. If you're still writing, take your time. Thank you. All right, counsel, I'll see you right outside, please.
Joseph.
Ms. Embry, a few more questions. Given your background in contracting, general contracting and whatnot, can you explain to the jurors why you elected to let these tenants, and maybe it's all your tenants, do their own internal build out? By that meaning they could do what they want in fixing up the inside of the unit.
That's a pretty typical commercial choice for landlords. Because commercial people come in and they have specific needs, like I had never designed restaurants, and I just designed and built 2 restaurants, but that's way outside of what I normally do. And if someone had come to me originally and said, build them, I'm like, no. If someone came to me right now and they're a doctor, for example, the eye care, I would have said, no, I'm not doing your build out because you need someone that specializes in that. So each tenant has unique needs, and that's what we did.
So it's not uncommon for you or others in the industry to let a tenant do the build out, the interior build out.
It is actually very common.
Okay. Did you communicate with the tenants in that unit? So whether it was Mr. Woodward or Mr. Wesley in 2020 or 2021 that their late payments were not acceptable?
In September of 2021, we started charging the late fee, but we never took away our right as landlords from the contract to enforce what we could enforce. So I don't think specifically I said, you know, we're never going to let you be late on rent, because what our solution is, we're going to charge you more if you do that. But it did not give up our rights, in my opinion, to do what we could do based on what the contract said.
Okay, well, Defense Exhibit 36 is that email from September 2021, where you forwarded to your tenants the provision about late payments. Prior to that email, had you had any conversations, written, oral, with either Mr. Wesley or Mr. Woodward that this late payment situation is not working? It doesn't work on the 10th or the 15th. Any communication as opposed to what you thought the situation was?
I did not communicate with either tenant ever about rent payments. I only communicated with Bobby.
Okay. Did you ever direct Mr. Flournoy to tell either Mr. Wesley or Mr. Woodward, stop with the late payments?
That was in our discussion. And again, every month when tenants are late, I ask Bobby, are you okay? Do you want to terminate their lease, or do you want to keep doing this? And it was his choice to continue to do it.
Okay. Did you ever direct Mr. Flournoy before September 2021 to inform Mr. Wesley or Mr. Woodward, you got to stop with the late payments?
The answer would be yes. But again, we can say pay on the first all day long. That doesn't mean they're going to do it. And they did pay for a couple of months on time after the late fees were kicked in September 2021, but then they went back to the same behavior. And our recourse is to make a decision whether to terminate or just collect the thing and go on about it. But after a certain point of so much of it, it gets to be too much.
Is the lease that we've spent a lot of time looking at standard lease language for all your tenants at the point development?
It's the exact same language with the exception of square footage and their payments.
But the right to self-help or the
Yes.
obligations of the landlord or the tenant, word for word, it's cut and paste.
Yes.
You just have different size units, different rents.
Yeah.
And obviously different identities of tenant, same landlord.
All I do is fill in the blanks, but they're all the same lease agreements.
Have any other tenants in that collection of properties been late on their payments?
Yes.
And what was the outcome in terms of termination or late fees?
We have to make decisions on individual basis. The one that was had similar issues in terms of being late was Sound Resort Studios, but he had been there as one of our original tenants. And I mean, at one point, he was 3 months late like this, but his rent was only we left him at $500 a month. So when he went 3 months behind, he was $1,500 behind. And he then would make it up and be good, and pay the late fee. So that one was probably the most difficult other than this one here.
Did any other tenants at the point had their leases terminated for non-payment or late payment?
For non-payment or late payment? I don't think so.
Have you had to do that with other tenants you've had elsewhere in your real estate history?
I had one, and it was a frustrating situation. It was not commercial. It was in DeKalb County. I owned a property that had a little house on it on Columbia Drive, south of Memorial. And the family moved in, and you couldn't have pets. And after 3 months of not paying the rent, and they had a pet that they'd never took out and all used the brand new carpet upstairs, I went through the process of eviction, which of course is different from the commercial lease, but yes, once.
Was there a clear communication to your tenants, Mr. Wesley and or Mr. Woodward, of the specific amount that was owed, which if paid would cure the default?
Yes.
And how was that communicated to them or their lawyer?
Through an email. In fact, even though our lease agreement doesn't require it, the attorney, through a letter, we gave him 10 days to make, we didn't have to, but we gave them 10 days to come forward with the total amount, and they did not.
And the total amount was specified. It wasn't, hey,
Yes.
you need to balance things out, not sure what it is.
Yes, and the amount was $5,082.24.
Okay. Did the plaintiffs ever pay any late fees?
Yes.
For which months?
They paid, I can tell you, a late fee for September of 2021, but they didn't pay it until September 30th. They paid a late fee for No, they quit paying the late fees too.
So just one.
Yeah.
The door that got switched out was at the back of the unit. Is that correct?
Yes, and I actually have a photograph in the things that we showed earlier that they didn't go further and show the image, but we have a picture at the inside of the door, which gives a clearer picture of that door.
Clear or not, the door's in the back.
Yes.
So we all watched video of water coming in the business that appeared to be coming through what looked like the front door. It was glass, not wood, and water coming through what I've come to learn are called weep holes, or at least were named by people who were testifying weep holes. But all that seemed like it was at the front of the building. How is that in any way connected with an allegedly faulty replacement of the door in the back? Or are they not related?
They videotaped and put online a video of water cascading from under that back door down the steps into the building. I don't know if water was coming in the front, in the storefront. All I know, based on what I saw, was that it was coming through the weep holes and down the steps in the back.
Okay.
And it could, I'm sorry, it could have come in through the storefront. It was a massive rain.
Okay. But are you able to connect from a general contractor perspective, water coming through the weep holes, which we saw, with water coming through that back door that you've been talking about?
They're separate items. I'm sorry, there are separate items.
Okay. Did anyone film the removal of the property from the store? Anyone with whom you're affiliated?
No.
Mr. Williams, any other questions for Ms. Embry?
No, Your Honor.
Mr. Sterling?
No, Your Honor.
All right, Ms. Embry, thank you for your time.
Thank you.
Mr. Williams, next witness.
Defendant's rest.
All right. Mr. Sterling, do we need to pause to work through any legal issues, or do you want to shift to your rebuttal case?
We do need to pause for legal issues.
Okay, we're going to have a break. It won't be as long as the break you had this morning, I don't think. But we've reached one of those points where one of the sides has rested. Please don't talk about the case, even though you've now heard from both sides. There may be a little bit more. You haven't heard closing arguments or my charge to you. We'll get you back in here as soon as we can. Thank you. Uh-oh, what'd you forget? Uh-oh, all right. Okay, Mr. Sterling.
Yes, Your Honor, we'd asked for a directed verdict on the counter plaintiffs, defendants, counterclaims rather, related to libel and defamation. They haven't demonstrated even remotely that something was said of or about the plaintiffs that harmed their reputation in any way. To the extent that anything was introduced that my client said, it was one, mostly complimentary about Your Honor in terms of what they did in moving forward TRO. And I believe that's protected. They just simply gave a report, hey, we're moving forward with the legal case. The other one was testimony that my client was upset and said something mean, but didn't talk about the reputation. And then the third one was a Facebook message that talked in general about corporate grifters, but never identified the defendants in any way. So I would argue, Your Honor, that we're entitled to a directed verdict because they haven't met their elements, and there's no way a reasonable juror could conclude that my clients defamed or libeled or slandered the defendants and their counterclaims in any way.
I'm inclined to grant any motion that wants to memorialize that someone thought I had good eyes, but I need to base this on the law and facts. Let's start with slander.
Your Honor, Mr. Sterling has argued eloquently, and he and I will agree. And we've wrestled with this with our clients. We're withdrawing voluntarily dismissing all of our counterclaims.
Okay. Slander was going to be the easy one. Libel, there would have been some discussion.
Agree, you've got good eyes.
Okay. So all counterclaims, including tortious interference with contract.
We agree on.
Okay, got it. Which would mean that what remains would be, I assume you're renewing at this time your motion for directed verdict.
Correct, Your Honor.
So there are no counterclaims. There are claims from plaintiff for 3 different slices at theft. There's conversion, and then the 2 negligence per se's. And there's the question of should Ms. Embry be included as an individually liable defendant? Do you want to add more to that? I guess I should ask you, Mr. Williams. It was your motion.
Add more to that, since we looked at this, because I think part of our directed verdict, why the court denied it was because of the question of fact of the course of conduct and the case law that was cited by plaintiffs. We would point out to the court OCGA section 13.4.4, mutual temporary disregard of contract, speaks specifically about when to a contract there's an obligation to pay or to do certain things, and that those are temporarily not strictly construed, that's the case until there is active notice or notice to change that. I'll turn the court to Reynolds versus CBT, which is 342 Georgia App 866. And this has specifically been interpreted and extended towards leases. Ford versus Rollins, 171 Georgia App 882.
If I were to look at Reynolds, which is from this century, how does it intersect with, I closed it, the Hannum case, which says, hey, there can be a written clause saying no course of conduct modifications, and yet we can ignore that if there are course of conduct modifications. The missing piece in the analysis, and maybe this is what Reynolds speaks to, is assume for a moment I find that there was a course of conduct modification. Can that be undone unilaterally by a party saying no more shenanigans? We're going back to the language of the lease, which plainly happened here. 21 September 21. That email I find would have been sufficient to say we're going back to the ground rules. I just don't know what the law says about one party saying, hey, all that nod and winking we've been doing about late payments, we're done with that.
13.4.4 says until strict notice. If you look at father and son versus Peachtree Airport, 229 Georgia App 860. This is a landlord-tenant situation, a commercial lease. The tenant had a dog in the premises, which was not allowed under the lease. It was the argument that the landlord knew about the dog, allowed the dog to stay there, but the evidence was also that at a certain point, the landlord said the dog's got to go.
And could point to language in the lease that obligated the tenant to remove the dog.
Remove the dog. And in that situation, they said that strict notice, that removal of the dog, notice to the tenant, defeated the course of conduct, defeated those previous agreements. There's also case law, and these cases say that, is that there may have been a course of conduct before September 21st, which we don't dispute. Then after that strict notice under 13.4.4, that changed it.
Okay.
So we renew our motion for directed verdict on both points.
All right. Mr. Sterling.
Well, I'll start with the latter, Your Honor, with the idea that I disagree, and I heard what the court said, but I disagree with there's somehow strict notice in the September 18, 2021 email. It seems very vague to me. It simply seems like they're forwarding the language that says you would have to be responsible for a late fee. Right. It's not saying you can't pay late, or if you pay late, we're going to strictly enforce our default provision. It's simply saying, hey, going forward, if you pay late, pay the $150. but it's not saying, hey, we're changing the course of conduct. You can't pay late anymore. You can't do this. And I think Mr. Wesley correctly talked about the fact that he over communicated, talked to him, explained to him things that were late. And I think the jury has to take that into context when considering whether or not there was a course of conduct modification to the contract. And I think there's enough there, Your Honor, for it to go to the jury. And I think certainly I can argue here, they're not saying we won't take your late payments or we will strictly enforce the contract, the default provisions. We're saying you got to pay the late fee.
Right. In fact, right. My read of it is that had the landlords wanted to have been more specific about your late payment has got you on the verge of default, it would have said something other than, here's the part, and now I'm quoting, the part of your lease that references the late fee, to which your client said, we got it. And in fact, they paid belatedly a late fee 1 month. And things fell apart after that. But I'm following your argument here that this really a jury is going to need to wrestle with what type of strict notice, whatever term you used, was provided to undo the course of conduct that had been allowed by the landlord over the many months preceding it.
Yes, Your Honor.
Okay.
That's my argument.
Any additional thoughts about Ms. Embry remaining as an individual defendant?
Yeah, Your Honor. I mean, I think that Ms. Embry made it clear that she was the individual who directed and gave the property to individuals without knowledge of who those individuals were, knowing that they had no right to the possession of that property. She gave it to them. Your Honor, probably correctly wouldn't let me find out who those individuals were, at least not in open court.
You ought to get that name. I don't have an issue with that, just so we're clear.
Yes,
It's
Your
just, I don't think it's germane to what this group needs to do or what
And just
folks
so
who
you-
may be watching would need to do with whatever that name is.
And just so Your Honor knows, I wasn't trying to obviously out anybody in court, but I did think it was pertinent to the fact that we were told before it's discarded, where now there might be an opportunity for my clients to get their stuff back if we can find out who these people are.
And I'll ask Mr. Williams to get you that name before you leave today.
Yes, Your Honor. But I do think that the fact that Ms. Embry essentially conceded or admitted, and the jury, again, I think there's something the jury will wrestle with, that, hey, I was the one who sent the property away. I was the one who told these individuals, you can have the property, take it, do what you will with it. It was at my direction that all of this happened, and it's not of or related to the tenancy itself. I think it's of and related to the property.
Mr. Williams.
Your Honor, clearly we disagree with that. Everything that Ms. Embry did, she did as a landlord. An LLC has to act through a live person. And there is no evidence that she ever took off her hat as the landlord or as the managing member of this LLC. That's how she operated. The lease is clear in that individuals, no personal liability for the tenancy. This is clearly the wrap up and the termination of the tenancy that is coming from that. The occupancy, which includes not only the person, but the property. This was all done by the LLC. Ms. Embry should be dismissed individually from this lawsuit.
Okay. The motion for directed verdict is granted as to the counterclaims, but it's moot because they're withdrawn. But I just want the record to be clear that there will be no further presentation of counterclaims, libel, slander, tortious interference. I am also granting one part of the defendant's motion for directed verdict, and that is as to Ms. Embry. I find that her conduct in this case there's not a jury question as to whether her conduct in this case is covered by the language of the lease. She, and in theory, Mr. Flournoy, although he didn't testify and the testimony doesn't indicate that he was necessarily one of the actors in terms of getting the property out of the space on May 2, but they both were the agents of the landlord, which was the LLC, which remains in the case and remains subject to liability should a jury find that there was conversion. I do find that there is enough evidence for a jury, if they credit the plaintiff's version of events and discredit the defendant's version of events, that there wasn't sufficient basis for the landlord, which is the LLC, to find a default and thus terminate the lease and thus engage in the self-help. I don't need to find it. The jury will work through it. I think that the self-help provisions include disposition of the property because it gives them dominion over the property. But if there were no default, then that gets Mr. Sterling to that element number 2 of the conversion, which would be the defendants weren't in lawful possession of the property that they disposed. So where I think we are, before I ask you if you're putting on any rebuttal, is that there are no more counterclaims. The plaintiff's claims that are going forward are all theft related. Ms. Embry is no longer in the case. And I think that's it. Are you putting on rebuttal?
Yes, Your Honor.
How long do you think that'll last?
Not long, Your Honor, maybe 30 or 45 minutes. I've just got a couple of people to call based on testimony Ms. Embry gave.
And they're here now?
They are, yes. Your
Okay,
Honor.
waiting outside?
Yes, Your Honor.
Okay. Mr. Williams, anything else before we bring the jurors back in?
Not before we bring the jurors back, but based on the rulings of the directed verdict, we would at the appropriate time revisit the jury charges. We've got.
Yes, we have to clean up the jury charges. I've already been striking through a few things. So the draft you got will continue to change.
Well, we will also request that with respect to the instruction for modification of course of conduct, that reflects the totality of the law.
Okay.
That we've cited to you.
You may need to send me a little more language.
Send you some language, Your Honor.
We'll get to that.
Mr. Rickman has his computer open.
Good. Okay.
Correct.
We're going to have another break when the rebuttal is over. That's when I'm going to give you all a break as long as our court reporter is good. She smiled. She's good. So let's bring the jurors in. There he is. He's just taking their chair.
She had peanut butter and chocolate for lunch.
Oh, dang. Better than my cutie or adorb or whatever it was called.
Witness who's another tenant of yours who's going to complain about the condition of the property.
Yeah.
Assuming it's drain.
All right, for the jurors.
I keep wanting to say Dwight as much as I do. Because I want Dwight.
Thank you, Deputy Gordon. You all can be seated. Mr. Sterling, it's my understanding that you want to present some rebuttal evidence.
Yeah, just briefly, Your Honor, at this time, we would call Mr. Dwayne Kelly.
Okay, and ladies and gentlemen of the jury, while Mr. Kelly is working his way in here, rebuttal evidence is simply an opportunity for whatever side went first to say, well, wait, based on what you heard during the defendant's presentation, there's a little bit more you need to hear. And that's what we'll get from whatever witnesses that Mr. Sterling's going to call. And this would be Mr. Kelly.
Raise your hand. You swear affirm that the testimony will be the truth, the whole truth, and nothing but the truth. You go ahead. State your name.
Dwayne Kelly.
Mr. Kelly, I need you to get a little closer to the microphone, please. The chair doesn't have wheels. And if you could spell your name for us.
Yes, it's DWAYNE. Last name Kelly, KELLY.
Thank you.
You're welcome.
Mr. Kelly, how old are you?
I'm 40 years old.
And what do you do for a living?
Recording engineer, and I also have a handyman business.
Do you own a studio company?
Yes, sir.
What's the name of it?
Sound Resort Studios.
And in your capacity as the owner of Sound Resort Studios, did you ever enter into a lease with Ms. Shay Embry or her company, Floshea at the Point?
Yes, sir.
Okay. And when did you enter into that lease, if you remember?
I believe it was 2016, I believe.
And how long were you a tenant of Ms. Embry or Floshea at the Point?
I believe it was 2016 until beginning of this year.
Was there a particular reason that you left Ms. Embry?
I was really I paid up my rent and it was really late on the triple N net. And she actually kicked me out after 1 month of being late on the triple N, but I did pay my rent.
Was there ever a point when Sound Resort Studios was 3 months late on rent?
No, sir.
Can you tell me about your experience with getting repairs done by Ms. Embry?
I mentioned to her that the water heater was dated 1988, never had hot water. The AC unit was old, never had heat, never had air. And she mentions that said I had to put in a whole new unit in her building and a new water heater.
And were there ever any structural issues with the building that you reported to Ms. Embry?
Yes, sir.
And tell me about those.
The drywall had mold and it was falling off due to water leaks from on top of the roof. The AC unit also had rust inside the unit and mold.
And did you inform Ms. Embry in writing about these issues?
Yes, writing, I have text and I have email.
And what was, I'm sorry, I didn't mean to interrupt.
No, that's fine.
What was her response?
Back in 2016, I have text, no, 2017, I have text that she said she was gonna look at the issue and give me a new unit.
And
But that never happened.
That was gonna be my next question.
Yes,
What
sir.
ultimately happened?
The unit, everything are still the same.
What I'm sorry, what was the reason you ultimately moved out or the lease was terminated?
I was kicked out. Because I wanted to stay. I have an email stating to Miss Embry that I was going to have a guy rent out the studio to help me keep it going. And then after I didn't pay the triple N, they said I had to vacate the premises.
And when was that?
January. No, it was February, beginning of February, I believe.
So wasn't the rent you were late on? It was the
Triple N, yes, sir.
And that was only 1 month?
Yes, sir.
Not 3 months.
Not 3 months.
No further questions, Your Honor.
Mr. Brickman.
Yes. Hey, Mr. Kelly, how are you?
No way. How about yourself?
Doing good.
Good.
So just to start off, I just want to confirm with you, is your email address info@soundresortstudios.com?
Yes.
Okay. So you just testified that your lease was terminated with Floshea at the beginning of February.
Yes.
2023. Okay. And the reason was you failed to make complete rent payments.
Correct. Triple N.
Okay.
Yes.
Do you say triple N? Can you tell us what that means? Those of us who aren't.
Well,
tenants.
triple N, I think, according to Miss Embry, and it's extra fees on top of the rent that covers. I think they said ground maintenance and a couple other things. That's in it, so.
But it was something that was always part of what you were supposed to pay. You were there
So
for a bunch of
They
years.
started a triple N maybe a year or two ago.
Okay.
Okay. And did Floshea reach out to you initially when you were behind on rent?
Yes, and I corresponded with Miss Embry saying I would have it the payments up to date. But when I didn't get the 1 month triple N, that's when I had the notice of vacate.
Okay. And did Floshea cooperate with you in assisting you in trying to make those payments, even though you were behind?
She did, but like I said before, it was only 1 month that I didn't get the triple N.
Okay. So how did your relationship with Floshea end?
We really didn't have much correspondence after I vacated the premises. I got all my stuff out. I gave her the keys and the keys to the doors and the keys to the mailbox.
And all of your items were removed by you?
Yes, sir.
From the unit. And Floshea afforded you that opportunity?
Correct.
And how much time did Floshea afford you?
I believe it was a week.
Okay.
She gave me a week.
And you coordinated that removal with Floshea?
Correct.
And they let you in?
I'm sorry?
They let you in to the property? And
the time that I received the email to vacate, she said from this day until a week from there, I had to get my stuff out by that certain date.
Okay.
Yes, sir.
And you did?
Yes, sir.
And she didn't take anything?
No.
Okay. That's it.
Mr. Sterling, anything else for Mr. Kelly?
Nothing further, Judge.
All right. Jurors, any questions for Mr. Kelly? Nope. Thank you, Mr. Kelly, for being here. Where's your new spot?
Well, right
TBD?
now. Yeah, TBD.
In the back of your house?
Right. In
All
my
right.
garage.
Well, good luck with that.
Thank you, sir.
All right. Thank you.
All right.
Mr. Sterling, next witness.
Jacqueline Wesley. This is what you do, Jacqueline Wesley.
Thank you.
I do. Jacqueline Wesley.
Can you spell your name? Oh, sorry, you were about to do that.
It's a long one. J-A-C. I'm nervous.
Don't be nervous.
Before.
This is gonna work out for you.
All right. J-A-C-Q-U-E-L-I-N-E. W-E-S-L-E-Y.
Thank you. When you're answering questions, you're gonna probably need to speak a little more slowly, even though you're nervous, so that the court reporter can get it. You spelled very quickly. So when you're given the words, go a little more slowly, okay?
I will.
Great. Thank you so much. Mr. Sterling.
Ms. Wesley, can you tell us a little bit, what do you do for a living?
I work in customer service.
Okay. And what part of town do you live in?
I live in Southwest Atlanta.
Is that near Cascade at the Point?
Yes, it is.
Are you familiar with my clients, John Wesley and Thomas Woodard?
I am.
Are you familiar with their business, Thomas Lavone LLC?
I am.
And are you familiar with the defendants, Shay Embry and Floshea at the Point?
I am.
Were you present on May 2nd, 2022 to witness an incident at the Thomas Lavone LLC building?
I apologize. Is that Monday or was that Friday?
Monday, May 2nd?
Yes.
And tell us what you saw.
I saw there were 2 men, 3 women. One is the Michelle, and they were with trash bags, packing up all of the items, dresses that they could get into the bag and transported them to around the corner to the back of her restaurant.
And did you see Ms. Embry personally bag things up?
Yes.
And did you take pictures of her bagging things up?
Yes.
Would you look at what's in front of you, Plaintiff's Exhibit O?
Yes.
Is that a true and correct copy of a picture you took on May 2nd, 2022 at 10:57 a.m.?
Yes.
And without going into detail, has anything been altered or changed from that picture?
No.
And did you provide me with this picture just today?
Yes.
And if that's a true and accurate description or copy of the picture that you provided me today that you took on May 2nd, 2022?
Yes, you can see Shay actually with a bag, opening it up so that somebody can put it in.
So before we get into the contents of it, do you have any objection to Plaintiff's O, Mr. Williams?
No objection, Your Honor.
Okay, Plaintiff's O is admitted.
Thank you, Your Honor. Would you publish question so the jury can see? Let us get it on the screen and you can tell us what we're looking at.
Okay.
All right, tell us what this picture is.
Yes, it's a screenshot of a picture. You can see me, I'm actually in front of the push sign, and I actually zoomed in where Shay, and there's a man beside her. She's actually opening up the bag because they were putting all of the dresses and everything into the bags to take it out of the building.
And you witnessed, you took this picture, you witnessed Miss Embry herself putting stuff and stuffing stuff in the bag.
She was along with the team, the other people.
No further questions, Your Honor.
Mr. Brickman?
Hi, Ms. Wesley.
Hi.
If it makes you feel at all better, I'm extremely nervous too. So we're on the same page. I'll be very brief. So based on this picture, you were not inside the building, correct, on May 2nd?
No, I was not inside the building.
Okay.
I was outside of the building, the first person on the scene.
Okay. So you don't know what was being said inside of the building?
No, I couldn't hear outside the door.
Okay, that would make sense. And you didn't see what appears to be, or as you've testified, is Miss Embry leaving the building with that bag that she was holding?
No, I actually saw the individuals that she let in the building. They actually were the ones that were leaving the building. I only saw her helping them pack them up.
Okay, but it wasn't Miss Embry who was leaving with anything?
No, the other ladies and gentlemen were actually leaving. She went in a different direction. While they went one way, she went the other way.
Okay. And other than this picture, do you know what was going on inside?
It looks like they were taking things that they didn't belong to them.
Okay. That's all I've got. Thank you.
Any follow-up, Mr. Sterling?
No, Your Honor. Thank you, Ms. Wesley.
Yes.
No, hold on one second.
Oh, okay.
Jurors,
Sorry.
any questions? Ms. Wesley, you're not related to Mr. Wesley. It may even be a different spelling, but you two are not kin, are you?
Yes.
You are?
Yes.
How are you related?
I'm a sister.
His sister. Okay. No wonder you're a fan of the shop. Okay. Ms. Wesley, thank you for being here. You are free to go.
Then one of the jurors had a
Oh, someone did have a question.
Attention.
I'm sorry. Take your time.
They'll write it down. We'll talk to the judge and then we'll come back.
Okay, do I get up?
No,
You stay
just-
right there.
Okay.
Not trying to run a courtroom, Your Honor.
You're doing a great job. Thank you. We'll be right back. We all right with this?
Yes, Your Honor.
All right. Press the little black button. There you go. Ms. Wesley, you were describing people leaving the business with the bags. Did they take them into a neighboring restaurant, or were they taking them and putting them in a car, or what do you recall seeing where the bags were going?
Okay, that's a great question. They were actually going into her restaurant. There's a back way to her restaurant, so that they were taking the bags as well as a wheelbarrow full of items to the back. If you remember where she showed the pictures of the wall, the unit, and the door that they bricked in, there's another door beside that joins the restaurant. So they were taking it to the backside of the restaurant instead of giving it to the crowd of people that were waiting for the items.
Any follow-up, Mr. Sterling?
No, Your Honor.
Mr. Brickman?
None, Your Honor.
All right. Ms. Wesley, thank you so much. Appreciate your time.
Yes, sir.
I wish all our witnesses made that sound when they stepped down.
There's one more, Your Honor. We would recall Mr. Thomas Woodard to the stand.
All right, Mr. Woodard?
Thomas Lavone Woodard, that's THOMAS LAVONE WOODARD.
Thank you.
Mr. Woodard, I want to just kind of limit your testimony to some of the things we heard about, particularly about the window unit, the air conditioning unit, and the electrical unit from Ms. Embry. And you've been here in court, you've heard everything she said, is that
Yes.
correct? Okay. I didn't give you a copy. I want you to look at plaintiff's exhibit P, Q, and R.
Okay.
Now, are these pictures is plaintiff's exhibit, and I'll try to get them all introduced at once. Plaintiff's exhibit P, is that a picture in the indoor of the air conditioning unit that was located inside of the unit you rented from Ms. Embry and Floshea at the point?
Yes, it is.
And you took this when you all first were taking occupancy of the building, is that correct?
Yes, it is.
Before you had made any modifications or changes?
Well, we started doing the demolition, but this AC unit was already in there.
Okay. And then is exhibit Q, what it looks like after you all finished or removed the AC unit and put in a window in place?
Yes, this is correct. This is what it looked like when it was finished.
And this was a before and those were before and after pictures?
That is correct.
And that's from the inside?
That is correct.
Okay. And are they true and accurate representations of the pictures that you took with no alterations or modifications?
That is correct.
And exhibit R,
Yes.
is that the electrical unit that was installed by Ms. Embry and her electrician in 2021?
Yes, it is.
And did you take that picture at the time after the unit was installed?
Yes.
Okay. Has there been any alterations or modifications to that picture?
No.
We would move, Your Honor, for the admission of exhibit P, Q, and R into evidence.
No objection, Your Honor.
All three are admitted and may be published.
Thank you, Judge.
Can I say?
You may not. You can answer questions, but you don't get to give speeches.
Mr. Wood, is there something you would like to say about those pictures?
Now there's a question on the table.
Thank you. The pictures that you see on with the AC unit, let's go to the one with the window that was placed in there.
So let's
which
use
is
letters.
Q.
Q.
If you notice, both sides had weep holes on the bottom. You may have to go to picture before and then, which come you can see the weep holes on both sides. And if you notice on the video, if you recall the video, the weep holes is coming from the right side and the windows on the left side. The water was coming in from the right side. So how did she get water behind that coming in when the water was coming from the weep side on the right side and the windows on the left side?
Well, let's go back a little bit, okay? Before this air conditioning unit was in there when you moved in.
Yes.
Now, did you do anything in terms of what your contractor did or what you authorized? Were the improvements you were making to the building, were they authorized by Ms. Embry or the landlord prior to you actually making the improvements?
Yes, that is correct. And Shay was in there during the time we took the AC down because we had a hard time taking it down. She was aware of it.
And did you get a certified contractor to put in the window unit in the manner that was approved by Ms. Embry?
Yes.
And when we look at P, we see the air conditioning unit, and was there a brick wall on the other side of the air conditioning unit?
On the outside?
Yeah, on the outside.
Yeah, there's a brick wall on the outside.
So you simply moved an AC unit where there was a brick wall. Did you touch the outside of the unit?
No.
Wait, I just want to make sure I understand. You're saying if you remove this AC unit, there wasn't daylight? There was actually brick?
There was no. I'm sorry. When you removed it, it was just a empty wall. You could see right through it. if you will remove it. I'm sorry.
Okay,
I'm
no,
sorry.
the question wasn't real clear.
I did, yeah.
This wouldn't work if there was brick behind it.
Right,
So,
exactly. Yeah,
wanna
you
make
make sure
sure.
air coming through. I'm so sorry.
All right.
I'm so sorry.
Yeah, I think when I said the other side, you're thinking this side, but I meant the exterior of the building itself.
No, if you remove that AC, there was a little bit of wood, and then you will have a clear wall. I mean, you can see right through the next building if you remove the AC unit.
And so when you all removed the unit and replaced it with the window, that was done by a certified contractor approved by Ms. Embry.
Yes, it was, and there was no leaks.
And that was going to be my next question. Over the course of the years you were there ever any leaks that came from that particular entrance?
No, sir.
And then let's look at Exhibit R. And let's just wait a second so the jury can see it as well. All right, tell us what we're looking at in this picture.
This is the electrical box with the wet line going across the electrical box. I know, I used to work for engineering service, and I worked for the VA hospital in East Orange. So I know certain things you cannot do. That's got to be violated with OSHA. So this is like a wet line coming from the HVAC system for the water to escape from out the building, but it's going across the electrical box.
Okay, and did there come a time where you all alerted Ms. Embry to this particular issue?
Yes, we was going back and forth it's been actually longer than we discussed. We was going back and forth since August about this.
August of what year?
August 2021.
Was that around the time that this was installed?
I believe so, because when it was installed, the Georgia Power Company came and shut everything down around the whole building. They shut everything down because all of that building the electrical was outdated. So they had shut the electrical down in that whole area. No one had electricity for a whole week. As a matter of fact, we didn't have electricity for a while. That Shay had to connect her electricity to us so we could have electricity and continue doing what we're doing.
And was this ever repaired in any way?
No, only thing when I kept telling them this needs to be repaired, because OSHA standard, if I looked it up, OSHA standard is that you can have a wet line and a separate line from electrical box. You can't have both of them run on the same side, because the water line break, it can get it all to electrical and it can cause electrical fire. So you gotta have them on two separate walls. They cannot be on the same wall.
And was this the electrical issue that you all were emailing Ms. Embry about in March of 2022?
Yes, is where that's gonna start a fire.
Now, you can take it down. Now, I want to talk about May 2nd for a bit. You heard the testimony of Ms. Embry. When you and Mr. Woodard were there with a few other people, a few community leaders, were you all asking to have your stuff given to you so you could take it out?
Yes, but I'm Mr. Woodard, that's Mr. Wesley. But yes, we were asking her, can we grab our things? Can we have our things? We kept asking. We asked them, where's the stuff? Where can we have our things? And they just kept walking past us because we couldn't do anything. So we just.
And was the stuff taken out by different people in different cars going in different directions, or was it taken to Miss Embry's restaurant?
Partially some to cars, partially to some in Aretha's restaurant, which is Shay is a part owner of.
But you were there asking to have your stuff back.
Yes, and the young lady that she had hired was a cook at the restaurant that was help pulling the stuff out at that restaurant.
No further questions, Your Honor.
Mr. Williams, do you have any cross-examination of Mr. Woodward?
No questions, Your Honor.
Jurors, any questions based on what you just heard? Yes? Thank you.
It seems like the same.
Mr. Woodward. You may have already said this, but we need to be reminded, the glass blocks that we see in Exhibit Q, when were they installed?
They were installed, that was probably 4 months after we got into the building, 5 months. After we got
Okay.
into the building.
So your lease began December 1, 2019. So it would have been early 2020, April-ish?
20 or
One?
Oh, yeah, probably like, it was, I know it was warm outside because we was outside with no jackets on. It was
Okay.
warm outside.
But it would have been in early 2020, not 2021 or 2022.
I think that's because we did take a while to open because of the simple fact that with the COVID thing going on. So it took us a while to open. So my dates are kind of confused, but I know that this window was installed during the time we was doing the build out.
Okay. Do you have a copy of this approval you say you received from Ms. Embry that authorized you to remove the AC unit and install the glass blocks?
I'm glad you asked that question. Shay never gave us any paperwork for our approval. She just came out and said, yes, do it, but it has to be modified to this. She always gave us how, and I'm glad that question came up because she was the one who suggested that we even take the thing out, that it should be replaced because it's old, and put it in glass. So we only followed what we were told to do.
So you're saying it was Ms. Embry's idea, not your idea, to put the glass blocks?
Well, we put the glass block in, but she was one suggested that, you know, she come up with designs and concept and ideas. We was blocking out. She's like, you should put a glass in it. So we thought of the block glasses. Okay. And that's what we came up with.
Do you have any evidence that the electrical box was up to code or not up to code?
I can pull the records from OSHA that this is not gonna pass. The picture itself, a wet line over electrical box, that's not gonna pass with OSHA.
Okay, but assuming the wet line isn't there, were there concerns about the electrical box, or the concern is the obvious one, which is there's a wet line?
A wet line going across the electrical box that can cause a fire, and that fire take place, we will be responsible because it's in our premises. That's why I was so adamant about this. If it was in somebody else's premises, I wouldn't have cared. You know what I'm saying? But because it was in ours, I was like, no, that means that we're gonna be held responsible if this fire take place. No. So we went back and forth about it for a while, and she kept promising she'll fix it. And she never fixed it. It's probably, you go there today, it's probably still the same.
So you're saying when you were removed from the building, the locks were changed?
It was still the same way.
Okay. Mr. Sterling, any questions for Mr. Woodward?
No, Your Honor.
Mr. Williams?
There you are.
All right, Mr. Woodward, thank you so much.
You're welcome. Thank you.
Next rebuttal witness.
Nothing further from the plaintiffs, Your Honor. We would rest our rebuttal case.
All right, anything, Mr. Williams, from the defendants?
There you are.
All right, ladies and gentlemen, the evidence is closed in this case. I'm going to give you another short break. I need to talk with the lawyers a little bit about the charge that I need to give you and our schedule for the rest of the day. And then we'll let you know what that's going to look like. Please go with Deputy Gordon. Don't start deliberating yet. The evidence is closed. No more witnesses. I promise. It's just the lawyers. And then I'll talk to you about the law, but talk about other things during this break. Thank you.
It's a serious, but the consequences are different. You know what I mean? So yeah, it's stressful. It is. It always is. Like kids sitting next to me at 19.
You all can be seated. Okay. Let me check one more thing. All right, so we have to have a charge conference. We need to do closings. I need to charge the jury. They need to deliberate. We told them they'd be done today. Not all that is fitting in. It would be great if we could do closings today so that when they show up in the morning, I charge them and they can begin their deliberations. I'm confident we can get 12 to come back tomorrow. I don't know. I haven't asked them yet. But we booked them through today. Are there specific issues you need resolved about the jury charge before you can give your closing? And I ask only because it may be that we could do the bulk of the jury, the charge conference after you do your closings. But if there's something that hinges, your closing depends on knowing exactly what's going to be in the charge, we ought to work through that right now.
I think certainly, I know that defendants wanted to talk about the modification by course of conduct. I think certainly that could be important to our closing and probably to theirs as well.
Your Honor, and I think pattern jury charge 16.100, contracts, temporary departure generally. I think that covers my concern that OCGA 1344 is covered. I'm happy to email that.
Right, I don't have access to patterns. I mean, technically I do, but it requires me to sign into something I don't know how to sign into.
Can you email that to the
Everybody.
court, Ms. Niles and
Yes.
Mr. Sterling?
What was it?
16.100. It's got language in there you're like too.
While that's headed my way, there was a request for a charge of the duty of good faith performance in contracts. And I don't think that applies here. I don't know who requested it.
Probably me, Your Honor. I was being broader as opposed to being more.
Broad is better, but that didn't seem to fit, performing your services skillfully and carefully. This isn't that kind of case about, hey, the plumbing fixture wasn't installed with the skill that you're supposed to apply as a master plumber. All right, Ms. Niles has sent me 16.100.
She's quicker than you, Mr. Britton.
Sheesh, I can't type fast enough.
So I've got that in front of me. Okay, I think that's an accurate statement of the law. I may clean up the language a little bit. Do you have it in,
I do. I have it in front of me, Judge.
Okay. I think it applies here. And I think the thrust of the law is appropriate here. So if you were hoping to argue it in your closings, I think you can do that. And I'll tinker with the language, but it won't not be in the charge. What else, Mr. Sterling, were topics that you, again, we're not working through the entire charge right now. I just want to enable you all to be able to argue the law that you want to argue during your closing, and not worry that then you'll be waiting for me to say that law during the charge.
I think that was the big one, Your Honor. I think the rest of it, I think, should be sufficient to make our closing arguments.
Okay, hold on one sec.
Your Honor, if I may,
Yes,
I have concerns about landlord and tenant duty of landlord generally on page 5.
okay, that's one that I had highlighted. Let me do this so we're all looking at the same thing. Okay, it's on your screen too. You're welcome to look on the pages, but it's also on the screen.
I think the thrust of those apply more to residential, and I think the law in Georgia is that parties to a commercial lease are able to contract around those obligations. And subject to the separate agreement, and perhaps the way to handle that is, as you have suggested in the one on the bottom of page 7, in the absence of an agreement to the contrary. But I don't think that the evidence, nor the documents, nor applicable Georgia law requires in all circumstances that landlord repair, respond. Commercial situations are different in the parties, or assumed to be able to contract around those and be held to those standards.
What about the second half of that? If there were substantial improvements made on the inside because the tenants elected to do that, and the landlord had consented to it, is the landlord liable to, I don't know what the lease said. The lease didn't say that either. If the tenants had redone the roof, not the roof, but the ceiling, and then the ceiling collapses and hurts someone, that's not the landlord's responsibility. If the tenants, under the terms of the lease, which is unless someone provides case law, like the case that said you can have modification of a contract by course of conduct, even though the contract says you can't do that.
With the caveat.
Yeah.
Of 1344. The lease is clear as to what's the landlord's responsibility, what's the tenant's responsibility, both in terms of when they took possession, as well as when they improve it or don't improve it. As what Ms. Embry testified, they're typically the commercial landlord's responsible for the envelope of the building, the roof, the exterior walls, infrastructure to a certain extent, but they can negotiate those between the parties. And I think the lease should control there.
Okay.
I think Georgia law supports that.
Right. So why wouldn't the lease be what you'd be relying on, Mr. Sterling?
It would be, Judge. I don't have a problem. I think I talked about that language in my opening. So
Okay.
I'm fine with withdrawing that.
Okay, great. So again, we'll get a more final version to discuss more fully, maybe tomorrow morning. Anything else you want to know isn't in or is in, Mr. Williams? Mr. Sterling has identified his question.
I don't think so, Your Honor.
Okay. Then how much time, Mr. Sterling, do you plan on opening and closing or just closing?
Just closing, Your Honor.
How much time, Mr. Williams, do you want, or Mr. Brickman, in the single digits to get ready?
In the single digits. I'm good. 5 minutes to get ready. 30 minutes for closing. I'm going to be quick.
Okay. I think we can get closings in. They can stay a little past 5, especially if I explain what the process is going to be. Why don't we try to get the jurors in here at 3:20?
Your Honor, you had mentioned earlier that you might, and I'm not sure that either one of us need this for closing, but conversion, theft by taking, theft by deception.
We'll work through that. I think that I had some question as to what the deception was, and you'll see that I had struck through, if we go to theft by deception, I struck through a number of the statutory definitions of deception because they didn't seem to apply here. The pattern is simply charge what OCGA 16, whatever it is, for theft by deception, but some of them just don't fit. There wasn't the sale or transfer of property, not disclosing a lien, for example. So I have denied the motion for directed verdict. These are pled somewhat in the alternative. So I think some of it will be shaped by what the closing argument is, but I didn't know. I think what I would add, if I add something to the jury charge is, and maybe it's to the verdict form, I don't know, it's that you find which of these, and maybe you could find both. Certainly it's not a double recovery thing. Recovery flows from the finding of a tort. And it won't be double the whatever the figure is because it was theft by taking and conversion. But I don't think you can have both. I mean, it's going to be one or the other. What are you thinking in terms of what you're arguing? How are you envisioning arguing to the jury conversion versus theft by taking versus theft by deception?
Well, I think they all kind of flow, Your Honor, from the idea that my clients never defaulted on their rent. So I think they all flow from that. So obviously the false representation would be that it was a proper eviction, that my clients did default, despite the fact that we believe that not to be true. And so I think that's where, I think it all flows from the fact that the eviction wasn't lawful, therefore this wasn't lawful. But I think for the alternative, even if you find that the eviction was lawful, they still improperly converted the property.
Okay.
So under 11.5, my argument is that the willful and wanton destruction of the property, which was strictly prohibited by the lease, is what gets us potentially to the conversion. But in the alternative, if you find that that the contract was modified, my clients were in compliance, or if you find that my clients had the right to set off or withhold because proper repairs weren't done, then I think that the jury could reasonably get there. That reasonable jurors could differ.
I see conversion and theft by taking coexisting here. The theft by deception, though, one version of deception is that the defendants created or confirmed the impression of an existing fact, which is false and which the defendants knew to be false, but there isn't any evidence that the defendants knew that it was a wrongful termination of the lease. The evidence is that they believed it to be a very proper termination of the lease. That's only one. The next is failing to correct a false impression. But again, I guess what's the evidence you point to that shows that the landlord knew that the steps they were taking, that their claim that there had been a default and thus termination of the lease was false? Well, they may have been mistaken, but that wouldn't be theft by deception. They might not have been in lawful possession of the property, then it's a conversion, or it could be a theft by taking. But what you'd have to prove by theft by deception, I think, from reading this, is that the landlords knew that there wasn't a default and thus there wasn't a proper termination, but they were bound and determined to take that back. And so they didn't care. I don't know who would have ever told that. The lawyer never wrote back. And your client said, we're not removing our property. What's your evidence that they knew it was false? I don't think false is the right word. They were either mistaken, that's your argument, or they were correct, in which case is a less good outcome for your clients. But there's this sort of intent and malice, not in terms of you shouldn't have thrown the stuff away when they were standing outside saying, give it to us. We argue that. That's not deceit. That's not we actually knew in our heart of hearts, and there's evidence to show that there was no default.
Well, Your Honor, I guess from my perspective, it was that my clients were telling them, hey, you can't do this. This is wrong. We're paid up in rent. Now, what you're doing is incorrect. So there was this repeated communication where my clients were essentially claiming, hey, this isn't right. This is wrong. And so I understand what Your Honor is saying, but I don't know if a juror could say, hey, I believe that they knew that what they were doing was wrong and they did it anyways, and that they would not correct the false impression that these individuals were being improperly evicted.
Okay. I'm going to remove from the jurors' consideration theft by deception. So I guess that's a directed verdict as to the count that is negligence per se, theft by deception. Still leaving the charge about negligence per se and theft by taking. But I don't think that there is evidence upon which the jury could reasonably rely to determine that it was a theft by deception. That'll streamline things a little bit. That's not why I'm doing it. I don't think the record supports it. Because of the way theft by deception is statutorily defined. I understand the argument. I think the argument really is they had a mistaken understanding of what the situation was and proceeded at their own risk, the consequences of which is this lawsuit and damages flowing towards your clients.
Yes, sure.
All right. I ate up a bunch of your break. Hopefully you were thinking about it, but let's bring the jury back in at 3:25.
Thank you, Your Honor.
Okay. Is that a long enough break for you? You can be all right? I didn't hear you say no. You thought this was going to be one day?
I was gonna say, I was holding my tongue. I was figuring Monday.
Right. Then we don't even use you on Monday.
Tomorrow, my only day, like, off, where I can do office work, and I really be off. So.
Well, if you are here tomorrow, you'll be able to do lots of things that aren't this because there'll be very little talking, but you're here. Yeah.
Go out much. Try to stay in work. Not every day this week. Will be every day. Oh. Plus it mounts pages up, which may or may not be needed. I'm just playing.
And then the last case we had with Mr. Brown, I was gonna do a replay of that bond hearing. One of the guys died, was he had that look on his face.
The one where the lawyers came up here?
Yeah.
Yeah, I didn't really, but they said, hey, the victim's dad. So the deceased's dad was here and that was, you were ready with the radio?
So he had that look on his face, that's why I called for assistant, but maybe she came. So, yeah, he had that look on his face.
Yeah. Well, and the words that these people were saying, if you could hear them, weren't going to make him happy because the defense was saying, look, the evidence is looking more and more like the deceased. So this gentleman's son, who was the front seat passenger and is the guy who's dead, he ended up getting shot in the front. So, but he's in the front seat. So he turns to look in the back and it's sounding now like he shot first. He shoots.
When Mr. Rouse coming through the door, that's what he was explaining to Mr. Lee.
Okay, yeah. Yeah, and so he gets hit here, but he shoots first, misses, I guess. And not Mr. Smith's client, but the guy who would have been in, I guess, sitting behind the driver. He pulls out and he is a better shot. Yuck.
All supposed to be friends, right?
No, I think some of them were, I think Smith's guy, who is the music superstar, he didn't know so well. He knew the guy sitting next to him, who's Miss Fagan's client, but the supposed shooter, who is now in self-defense, they didn't know him so much. I don't know that they weren't strangers, but the people in the front seat seemed to know each other too. It's a weird setting. All right, I'll be right back.
Just so you have my notes on final points. Do it, please.
Is there has to be unanimous? Charge, jury.
Thank you. Sorry. And I think we probably need to take down the charge conflict just because.
I know.
But other than that.
No charge. No charge.
No, oh, yeah.
So clear your calendar.
You're making sit through all this and not on your.
No, we're gonna, you can sit there.
I'll just make sure.
You interrupted my closing.
I just had my office manager out after lunch tomorrow, so I gotta run the office and, like here, gotta make sure. I can do all the day.
All right. Mr. Williams, you ready?
Yes, Your Honor.
Mr. Sterling?
Yes, Your Honor.
I will be.
Okay.
Might as well.
Well, jurors are heading this way.
Get on my feet, right? Dance.
You go first.
Because he's got the right to open and close.
Yeah.
I don't know who moves faster, you or Ellerby. Judge, I don't know who moves faster, Judge McCartney or Judge Ellerby.
If you had said this was through Thursday, I'd be moving more slowly.
All right, juror. Juror present.
You all can be seated. Welcome back, ladies and gentlemen. Let me give you some updates as to where we are and what's going to happen next. So everyone has rested. They didn't get to unrest during your break. No more witnesses. The next phase of the proceeding is closing arguments or summations. That's when the lawyers are given an opportunity to argue to you what they think the evidence has shown or failed to show. It's an effort by the lawyers to persuade you to decide the case in their client's favor. There's nothing wrong with lawyers trying to persuade you, but keep in mind what I told you at the outset of the trial, which is what the lawyers say is not evidence. You've received the evidence, witness testimony, and you'll get all the exhibits to look at up close. But that's the evidence. So if a lawyer is telling you something, and this is what the witness said, and that just doesn't jibe with your recollection, you may feel free to be persuaded by it. But during your deliberations, if you catch yourself saying, oh, I know what happened because the lawyer said X, that's not the right basis to make a factual finding. It would be your recollection and the collective recollection of what witnesses said and what's in the exhibits. Now, the lawyers will be telling you what they think the lease means. The words are the words, and they're free to say, and this is what those words mean. That's appropriate efforts at persuasion. A couple things have changed since the beginning of the trial. Because of rulings I've made and motions that the lawyers have made outside your presence, I have removed one of the defendants. That's Ms. Embry. She was sued in her individual capacity. And I've determined that's not properly before you. So the defendant is the landlord. That's Floshea at the Point LLC. Number two, the plaintiffs have withdrawn some of their claims. They are moving forward, and Mr. Sterling will get into this more when he does his closing. They're going forward on their claims for conversion and theft by taking. It's negligence per se / theft by taking, and then any damages that would flow through that. They are not proceeding under fraud. There are a couple other allegations, but those are no longer before you. So it's conversion and theft by taking, and then damages that would flow through those torts. The defendants have withdrawn their counterclaims. So they had countersued for slander and libel and something called tortious interference with contract. Don't even need to worry what that phrase means because they've withdrawn it. So what remains for you to consider after closing arguments are a handful of the plaintiff's claims now against Floshea at the Point LLC, not Ms. Embry as well. The lawyers will make that clearer, but I just wanted you to understand that, as is typical in cases, as things evolve and lawyers reevaluate, and the fact that they need to put all the charges they might hope to go after in their original pleading, we've pared it down to the things that I've described. Because the only claims remaining are claims from the plaintiffs, that means that the burden of proof is only on the plaintiffs now. I had mentioned before that for the counterclaims, the defendants had that same by a preponderance of the evidence burden. They're not making any claims anymore, so there's no burden on the defendants. Because Mr. Sterling does have the burden of proof, he gets to go first and second, open and close with closings. He has told me he is going to simply close, so he'll have the last word, which means in a moment, Mr. Williams will give his closing argument to you all. When he's done, then Mr. Sterling will have a chance to give his closing argument, and that'll be all we can do today. By then, my guess is we'll be bumping up to 5 o'clock. The lawyers and I need to stay late so that we can finalize the charge that I will give you in the morning. But even if we stayed a little bit later and I charged you, which I can't because we haven't had all of our charge conference, it's not appropriate to say, why don't you start your deliberations at 6 o'clock? Because that puts weird pressures on you. Some of you will say, I want to finish this tonight and not come back. And that's not the dynamic that should be in the jury room. You should take as much time as you need. You may need 5 minutes, you may need 5 hours, but you decide that, and it shouldn't be the clock that's ticking. I mean, ultimately, I decide. If we're at this 5 days later, I call it quits and say you can't reach a verdict. But we had asked you, because of the representations of the lawyers, to commit through today. So I need to know before Mr. Williams gets up to give his closing argument, if for any of you it is an impossibility to be here tomorrow morning. It's an inconvenience. It's not what you planned for, but it's not an impossibility. That's what I'm taking from the facial reactions and the lack of hands going up. I hear you. I had planned to be doing other things here, but we'll all be together. And actually, we'll be together very briefly in the morning as I give you the charge, and then you'll retire to the jury room and you'll do what you need to do as jurors, deliberating. With that, Mr. Williams, you got a few extra minutes. You're up.
Thank you, Your Honor. Good afternoon again. This is the last time you get to see me. Aren't y'all happy? We told you, I told you, the court told you on Monday that we needed you. You have probably seen over the last few days why. Because you've heard different things, you've seen different things. There's a lot of documents just. You've heard, you've seen. I've said a lot of things. Mr. Sterling said a lot of things. There's a lot of stuff out there. Well, who said what? Who did what when? Distractions. Folks from Fulton County Commission. Folks from MPU. But the question before you is fairly simple. Was the tenant, the plaintiffs, in default of their lease? That's the heart of this question. You're going to hear from the court. You're going to hear what the law was. And while we all may have walked in here with different expectations of what an eviction is, what an illegal eviction is, how you can dispossess or kick somebody out of your home, your garage apartment, or your business, you're going to hear from the judge what the law is. And what the law is that it's different. Residential is one thing. And most of the testimony you've heard from that stand is looking at this through the prism of a residential lease. That's not what you're going to hear from the court. That's not what the Georgia law says. What Georgia law says is commercial is different. Commercial, the parties are free to negotiate. The parties are free to contract. The parties are free to say, you're responsible for the build out on the interior. I'm responsible for the walls or the roof. The parties are free in a commercial setting, what's called self-help, which feels uncomfortable. It feels abnormal. But what you're going to hear from the court is that Georgia law says if a landlord and a tenant agrees in writing, in their lease, in their commercial setting, if there is this opportunity for self-help, a landlord can rely on it. Here. The question before you, though, is not, is that provision legal or not? You're going to hear from the court that it is. The question before you is, did the landlord go through that correctly? And I said in the very beginning, because I've had to do this, and I'm sure y'all's notes reflect that the timeline matters. What happened when? What didn't happen when? What the timeline is going to show when you look at the documents, when you look at the emails, when you look at the correspondence, and when you weigh that against what you heard from the witness stand, is undisputed. December 1st, 2019, the lease is entered into, agreed to, undisputed, signed by the tenants, by the plaintiffs, signed by Floshea as the landlord. We don't have a dispute as to what's in that lease. What you're going to see from the checks that are going to go back with you, from the ledger that's going to go back with you, is that tenants didn't timely pay their rent. We don't dispute that before September 2021, the landlord took late payments, did not strictly enforce payment of CAM, did not strictly enforce requirements for late fees, the $150 owed under the lease. But the timeline is going to show, and the emails are going to show, and you're going to hear the law from the court, that yes, while that course of conduct, and that's what the law calls it, while that course of conduct before September 21, 2021 may have changed what the agreement was. What strict notice is given, what reasonable notice is given. Look, we may have excused this till now. We're not going to excuse it going forward. And you'll see that email where strict notice was insisted on. First, September 21, 2021. You will see the email response back from the plaintiffs. It says, we've got the lease, we got you. You will see the corresponding payment of their September rent in that month late. They're late. They do. It may have been excused before September 21, no longer excused. You will see March, this rain event, this flood event, we've heard different testimony as to that. The documents don't lie here. And the documents are not in dispute. The emails are not in dispute. This missing witness, probably the most important one, Mr. Burrows, sent the email March 22nd, 2022, complaining about condemnation, code citations, water, flooding, electrical, you name it. Even the plaintiffs disagreed with his characterization of what was wrong. You will see that in response to that, the landlord said, tell us more. This is the first time we're hearing about this. We will live up to our responsibilities under the lease. We will do what we're supposed to do. And what did we hear? No responses. No counters. Then you see us talking to the wall. You see our letters to Mr. Burrows. You see our emails to Mr. Burrows. You have the testimony of plaintiffs that says they're going to hold back rent. They're going to stop paying rent. They knew they were behind. They knew they were in default. You will see the letters, the notice of default, that again says we will abide by our responsibilities under the lease. You received your email, March 22nd, 2002, Mr. Burrows. Still need more information. You do what we're supposed to do. You've got to do what you're supposed to do. And in that letter, it says, as of now, you owe $5,089 and some change. It's not one late payment. It's not 1 month late payment. April 11, they owe $5,000. You will not see any pushback on that. And what I said from the beginning, and what you hear from the court, is that commercial settings, the lease controls. And the lease said, Ms. Embry testified to, you don't pay rent, if you don't pay CAM, you're in default. And it doesn't matter how much, in for a penny, in for a pound. A default is a default is a default. What does the lease say? The lease says, in the event of the default, we don't have to give them a week. We don't have to give them 10 days to cure. We don't have to give them 30 days. We don't have to file a lawsuit. You can, without notice, invoke any of those self-help amendments. That's not what my client did. What my client did was try repeatedly. Work with us, solve this, pay the money you owe, cure the default. They didn't do that. So again, you will see the documentation of the termination of the lease. It says, since you've not cured the default, you heard Shay said, eventually enough's enough. This is her business. Her livelihood. You gotta protect her interests. Because the evidence will show the plaintiffs didn't protect things. They blew off all of those letters. That was the testimony. They received them. Either didn't believe it, didn't think it was the law, didn't respond. Repeatedly, opportunity, fair notice, and warnings were given. You even heard from plaintiffs' rebuttal witness. Different tenant, different situation, not involved in this. Similar situation. He got his stuff. We worked with him. He was allowed to remove it. There was no issue there. Here we have email after email. We have notice, we have fair warning. Over and over again. And those were ignored. Then they refused. There would be no removal at all. Look to the lease. There was no obligation under the lease for landlord to accept late payments. There was no obligation for landlord to accept partial payments. There was no obligation for the landlord to accept payments tendered after the termination. The lease was over. Those were returned. The timeline here matters. And the lease is very clear. We went through this ad nauseum, and I appreciate you bearing with me because I know you're going to read this 30-page lease. Once there's a default, once there's a termination, once the tenant does not remove whatever's in that space, it's surrendered. The lease says the landlord is excused from exercising dominion over tenant's property. Does that sound harsh? Absolutely. Is that the law? Absolutely. Tenant, at its own peril here, took the risk. The tenant pushed their responsibility to preserve their self, to preserve their property onto us. The law is different. You're going to hear from the court, and you're going to see it in the lease. Look at the lease. Look at the ledger. Look at the emails. Look at the notice of default and the notice of termination. Because what the plaintiffs are suing their landlord for, the former landlord, is for theft, stealing. We stole from them. It's not what the lease says. We also have before you the inventory. For testimony as to a couple of garbage bags that went into a truck, a couple of cars. Yet we have $7.5 million worth of damages plaintiffs are in my client. You saw the videos of the space. You saw what was in here. While we contend that doesn't matter, it does. Because the timeline shows, and you can see it from the emails where plaintiffs are forwarding emails to politicians, to their attorney, threatening their landlord, but you will hear from my attorney even though it wasn't an attorney. They sat on their rights. They sat on their opportunity to remove their stuff. And now they're waiting for a payment. They're asking me $7.5 million. The lease is clear. The law is clear. And the plaintiff's own testimony show they cannot pay anything that they were able. Ask you to then come back with a verdict that was fair. It was based on the law, based on the facts, based on the lease. Uphold this lease. Uphold that the default is a default, and that entitled the landlord to rely upon the self-outrageous here. You think did that. it should be a defense verdict. I'm asking for that. I thank you for your time. I know this has been a sacrifice. I know it's not been what you wanted to do. So I've asked better questions than me. I appreciate paying attention. And I appreciate the time that we're going to spend back in that room. Going through, sorting through the documents, the ones that matter, the ones that change. There's a lot of noise here. There's a lot of complaints. There's a lot of side story here. There's a lot of allegations that the grant money, the commercial grifters, the facts show the tenants voluntarily, freely, of their own, entered into a lease. And that was. Thank you for your time. Thank you.
Thank you, Mr. Williams.
Look at that, really short.
Mr. Sterling.
Thank you, Honor. I can just have one moment. Ladies and gentlemen, I told you when this case started at the beginning. You'll hear me repeat a lot of the same things I told you at the opening because I believe that I've kept my word to you. I told you that this case was going to be about broken promises, a stolen dream by a small startup business that was on its way up with a high trajectory that was completely and totally destroyed. And I believe that's exactly what you've seen in this case. And I too want you to look at the lease. You see, there's something in that lease Mr. Williams doesn't talk about. There's something in that lease that he forgets every time. You see, that lease talks a lot about the landlord's rights, what happens if the tenant defaults. The landlord can do this, the landlord can do that, the landlord can do this, the landlord can do that. But you didn't hear one thing or see one thing about what happens if the landlord defaults. What can the tenant do? You didn't hear one thing about it. If you don't meet your obligation, if you don't make the necessary repairs, if you do things next to our building or construct things within our building that are faulty, what are my rights? What can I do? See, Mr. Williams misses one thing at the very end. See, it says at the very end of that lease, all of these provisions are governed under applicable Georgia law. And see, that's where my clients find their remedies. They look to the law to protect them because in a lease written, negotiated, and admitted to that it's the same lease used over and over again by the landlord, tenants have very few rights, except at law, except being able to exercise their rights at law. So when someone breaks their promises to you in a lease where you have no rights, you have to look to the law to see what your remedies are. That's exactly what my clients did in this case. They looked to the law. What are my remedies? They sought help, as you heard. They sought out a lawyer first, sought out city council people, sought out a commissioner. That's reasonable for a business constituent to say, hey, I'm having a problem that is not being fixed, and you look to your community leaders to help mediate, help solve, help resolve. No one came in here with a mean spirit towards Miss Embry or her company. You heard from the community leaders. They came in, hey, You're my constituent, they're my constituent. What can we do to resolve this matter? What can we do to solve this issue? And he wants you to look to the lease because he wants you to ignore Miss Embry's actions. He wants you to keep looking at that lease over and over again so you forget about what she did, about how she looked my clients in the eyes as they took out their life's work over and over and over again. As my clients and their congregants pleaded with them, please, can we have our stuff? Please, can we have it? You're taking it out. We see it right in front of us. That's our life's work. That's every stitch this man has designed over and over and over again that he told you about by hand. Imagine the hard work that he poured into that. Everything that he's ever done in his life. And you know she was familiar with the business because she was there with them at the opening when they were still on good terms. So she understood what was happening. She understood what she was taking out of there. And I know Mr. Williams wants you to devalue it, but what is the value of your art? Right? And you may not be into fashion. You may think, oh, that's not a big deal. I'm not into fashion. But imagine it was something you are into. Imagine it was that great novel that was being written. Imagine it was that movie script. Imagine it was that painting, that undiscovered Basquiat painting. Imagine it was something that somebody poured their heart and soul into. And as they're sitting outside with a rightful claim to their property, it is being taken away from them and admittedly given to other people to discard and do whatever they want to do with it. That is conversion. That is theft. They had a right to get their property back. And instead, it was discarded. And we wouldn't even be here today. This is about a lease for sure. This is about the termination of a lease and my clients being kicked out, but this is really about my clients' hard work taken from them and destroyed. When the better solution, when the right thing to do would have been not to steal it, not to take it, not to give it to other people, not to convert it to your own use and discard it, but to give it back to the individuals to which it belonged. Now, I want to talk to you a little bit about the law. As Mr. Williams describes it, we want to talk about the lease. Some of the things I mentioned in opening came out when we talked about the lease. So I want to walk you through some of those provisions and walk you through some of the law that the judge is going to give you. Let's go to the next slide. So a contract is a promise. Right? I mean, at its basic level, it's a promise on what you will do, how you will perform. You do this, I will do that. I pay you rent. You do this, I do that. It's your word. It's an agreement. It's an agreement. It's your word. It's an agreement. And what you heard from Mr. Wesley was, and Mr. Woodard, was that like at the very beginning of this lease, when we first started, we were in a transition phase. We had some issues. We overly communicated with our landlord. We told her and him, Mr. Flournoy, we told them all about issues we might have making late payments. We overly communicated. We talked to them. We communicated with them. We let them know what was going on, and they accepted it. And I'm going to tell you why that's important, because some of you asked some very good questions, right? Some of you asked the question, hey, did y'all always take late payments? Or did you ever tell them the late payments weren't appropriate before September 2021? That's an appropriate question. Because while Mr. Williams wants you to hold them strictly liable to the lease, that's not what the law says. See, the law understands that when people contract to do things, there might be changes. There might be flexibility depending on the facts and circumstances. The law contemplates COVID might happen. The law contemplates things may arise in the difference between the parties. The law contemplates the parties may decide to act and conduct themselves differently than the written agreement. And because the law in Georgia contemplates that, my clients have the right under the lease to look to Georgia law for their relief, which is not provided by contract, written, constructed, and given to them to sign by the landlord. Their relief is Georgia law. It's your word. It's your word. So if they're relying on the word, if they're relying on the agreement by the course of conduct, In 1 month, all of a sudden you decide we're changing what we agreed to, what we've been agreeing to for the past 2.5 years. That's over with. We're changing it right now. And we're strictly exercising our right to kick you out, despite the fact we conducted business differently over the past 2.5 years. That's not right. That's not the law. That's not the law. Let me tell you a little bit about what we are seeking and what we have sued the plaintiffs for. One, we sued them for conversion. We have to prove to you 3 things. 1, my clients had a right to the property. 2, the possession of the property was wrongful by the defendant. And 3, we demanded possession, but defendants wouldn't surrender it. I believe we've met each and every one of these elements by a preponderance of evidence. My client certainly had a right to the property. It's theirs. It belongs to them. That's not in dispute. Defendants took possession of the property while my clients were there, asking for it back, while my clients were entitled to it. Right? Their possession of the property was wrongful. And there's no dispute. 4, 5, 6 witnesses said they were out there with them, ready to help them, demanding the property back, but they would not surrender it. We believe we met each and every one of these elements. My clients had a right to the property. Possession of it was wrongful by the defendants, and they wouldn't give it back when we asked for it. It's that simple. It's not complicated. It's that simple. It was their property, and it was taken from them wrongfully. We also have a case, to go to the next slide, of theft by taking. Theft by taking. So if you say, hey, look, I don't know about this conversion, Mr. Sterling, but tell me about theft by taking. Well, we've got 4 elements here. You unlawfully take the property. So you unlawfully take it, or alternatively, you're in lawful possession of it, but you appropriate that property of another person with the intention of depriving them of the property. So you can either unlawfully take the property, or you can actually lawfully have it, but you appropriate that property to another person to permanently deprive them of it. There's no dispute my clients have been permanently deprived of the property, right? No dispute the property was appropriated to another person. It was admitted. I gave it to other people to get rid of it. And no dispute that either they were in lawful possession of it. If you believe Mr. Williams, hey, they abandoned it, we had a right to it, okay? So you're in lawful possession of it. Let's say you agree with Mr. Williams. You're in lawful possession of the property, but you appropriate that to another person with the intention of depriving them of the property. It's that simple. We've met those elements by a preponderance of the evidence. Each and every one of those elements have been met when it comes to theft by taking. And that is the law that the judge is going to instruct you on. Go to the next one. Why are the payments and acceptance important? How long did you accept the late payments? That was one of the jurors' questions. Well, what you will hear from Your Honor is that parties can modify the written terms of a written contract through course of conduct, and a party may rely on that modification of the contract if the parties have become accustomed to handling regularly conducted business with one another. In other words, even though it says rent is due on the 1st, right? So why are these consecutive rent payments late? What was going on? Well, Mr. Wesley told you, we had issues from the beginning and we just stayed in communication. That was part of the way we operated. And they accepted payments on the 5th, the 10th, the 15th. So as we got into that groove, we just wanted to make sure we were making our rent payment every month and that we stayed in close communication with them. And they did. They stayed in close communication. And you heard Ms. Embry admit that Mr. Floor, she would ask Mr. Flournoy, hey, do you want to go back to the strict interpretation of the contract? Or do you want to continue to allow this to happen? Is it okay to just keep taking late payments? And he said, no, I'm fine with the late payments. Right? As long as they're making the payments, I'm fine with the late payments. We'll continue to accept these late payments. So that was completely and totally acceptable. The parties agreed because of the circumstances and situations they were in, because they were communicating with them, because they had a good working relationship, because they put $5,000 into improving the space and making it a better space that would ultimately go back to the landlord that she now owns and controls, despite the fact they made the improvements to it. Right? Because of all of these things, and because I support entrepreneurs and I understand it. Sometimes, you get invoices in one day, you got accounts receivable one day, sometimes you have a cash flow issue, sometimes there are things that come up. We're okay accepting these late payments so long as you continue to make the payments. So the contract changed through the course of conduct, right? And the law is flexible on that. Right? That's the reason why those late payments are important. That's the reason why we talked about it. Because, and that is important because if you believe that, right, if you understand that this was the course of conduct that modified the contract, then then my clients were not in default. They were not in default when they said they were, because they understood that the payment would come later. But you know what happened, right? I mean, you can see it. My client started complaining about the building. Now you can see it as plain as day. Everything was fine. Everything was okay. Everything was good to go. We were willing to deal with you in the condition in which you were. We understand entrepreneur, things come up, cash flow issues, all of these things happen. But don't try to hold me to repairs I need to make. Don't tell me about this wet line issue that could be an OSHA concern. Don't try to get me to do what I'm supposed to do with this electrical box and these plumbing issues and these flooding issues. Because as soon as you do that, I'm going to go back to the strict interpretation of the contract, despite the fact that we've been dealing with each other different. I'm going to default you and I'm going to kick you out. That's what happened. That's exactly what happened. There was no issue until my client said, come do what you're supposed to do under the contract and make these repairs. That was it. Otherwise, they were willing to work with each other and deal with each other. So the reason we talked about improvement so much, the reason we talked about what was going on in the building so much is because the judge is going to instruct you that when the premises are in repair, when the premises need repair, my clients have communicated that, the landlords refuse to do it. That's in the lease agreement as well. That my clients have the right to make the repairs, to clean up the water, to get rid of the water damage, to do all of the things necessary to improve to make the repairs, to make it suitable to deal with their customers. My clients have an absolute right to do that. And then they can set it off. They can recover from the landlord reasonable expenses, or they can set off the expense from their rent. It's as simple as that. And that's why that's important. Because even if you believe that my clients are in default because they paid the rent late, despite the fact that that was a part of the modification of the contract by their conduct, even if you believe they were in default, well, my clients still had an absolute right to set off the expenses that they made for the repairs, for the water damage, for the plumbing, for the leak. They had a right to set those expenses off without fear of retaliation from the landlord. And we talked about in the opening, right? We talked about this. What was promised? What was promised and what actually happened? Right? So when we talk about the broken promises, Mr. Williams wants to focus on the one thing that my clients didn't do on time. The one thing they didn't do on time. Despite the fact that there was this course of conduct, there was this communication, there was this modification. You didn't do this. Well, that's, and as I mentioned earlier, it doesn't talk about what the tenant's remedies are. It only talks about what the landlord's remedies are, right? But my clients knew that the landlord could change or improve the building. They could put things next to the building. But if it materially impacted my client's ability to conduct their business, then that was prohibited, or they had to get the written consent of my clients before they did that. So for example, if the electrical box creates a hazard because there's a water line over it, you were supposed to get my client's written consent before you did that. That never happened. This Embry didn't talk about getting your written consent to do that. This Embry didn't talk about getting their written consent in terms of changing the dimensions or doing things within their structure that impacted their own safety, their health, their wellness. She didn't get their written consent to do that. My clients had to look to the law for what their remedies were. Go to the next one. Required to make repairs. This is in the lease. You see, Mr. Williams wants to cherry pick the parts of the lease that support his theory of the case. But I just want you to understand that there's more than that to this particular agreement. There's more than what he's just saying. His client was required to do repairs, to make necessary restructures to plumbing, pipes, conduits located outside of the premises. The water leaks, those conduits, those things that cause the flooding to come into the building. His client was responsible for making those repairs to the electrical part that she actually took ownership of doing. When she failed to do it correctly, she was required to then repair that. That's what was promised. That's what was promised would happen. Go to the next one. And again, one of the key pieces of testimony was where this water came from, where the issue started from. And somebody asked a key question. We didn't see any water coming from the back. You didn't, because it didn't come from the back. It came from the front. And that there were no issues when the window was put in 2020. There were no issues in 2020, no issues in 2021. There were only issues in 2022, when, as my clients testified, and as Ms. Embry admitted, construction next to the building began to take place. Pipes and plumbing were pulled out, water, things were happening underneath, and all of a sudden the flooding came in. And then my clients brought it to their attention that, hey, this construction you're doing, it's impacting our ability to conduct our business. They took videos to document it. And then they emailed Ms. Embry about it, an email that she conveniently forgot that she received. They emailed her about these repairs. They didn't wait to get a lawyer. They didn't run to a lawyer first. They took the first possible alternative, which was, we're required to email our landlord to make the repairs. And then when she refused to do so, what did they do? Got a broom and did the hard work themselves. Got somebody to help them, cleaned up the water damage, did everything necessary to make that business suitable for them and their clients, because that's what Georgia law allowed them to do, as the judge will instruct them. And they could make the repairs themselves and set it off against any rent that was owed. Look to the next. Now, Mr. Williams really wants you to forget about section 11.5 of the lease. And I want to go back to make just one point with you. I've got the burden of proof, so I'm talking a little bit more than Mr. Williams, so you have to forgive me, because I'm really the defense attorney, and I'm not in this position today. I usually don't get the last word, so I'm very happy about that. But Mr. Williams wants you to believe that when his email was sent in September of 2021, you'll see the email. You got it, and you'll have it in evidence. When his email was sent in September of 2001. So what he says is, yeah, I agree, I can see that we modified the terms of the contract and accepting the late rent, but that changed in September of 2021. But when you see this email, there's nothing about this that changes that at all. It simply reminds my clients, hey, if you're late, it's $150. Here's the provision. It doesn't say we won't accept late rent. It doesn't say we will enforce the first of the month provision on you if you pay late. The first of the month default provision on you. It doesn't say we will exercise our self-help remedies if you pay late. It simply reminds them, hey, if you're gonna pay late, pay the $150. If you're gonna do that again, pay the $150. It's about money, right? This isn't an email about strict compliance. An email about strict performance. It's an email about money. Hey, you can see that. Right, you can see that. If you're gonna be late, pay the $150. Let us get our extra money if you're gonna be late. And that's what this email is about. This isn't about saying, hey, by the way, remember, if you don't pay on the first, you're gonna be in default. If you're in default, we're gonna exercise strict compliance with the lease. If we exercise strict compliance with the lease, we're gonna use self-help remedies, and we're gonna kick you out and ask for possession immediately, and we're gonna take all your stuff and we're gonna destroy it. Now, this email says, it says, remember the late fee is $150. Pay me my money. Give me my money. That's what the email is about. It's about money. It's not about strict compliance with the lease. Now, when you look at the lease, and Mr. Williams wants you to look at the lease. I want you to look at the lease. I'm okay with that. I'm not running from the lease. You will see a portion in there that talks about damage to property or persons. That's a provision he completely ignores. He doesn't want you to look at that part. Look at 11.5 of the lease. And what it says is there is one exception. There is one exception to when a landlord can be held liable for the damage of the property inside. Any other time, any other damage, if there's a fire, they're liable. If there's theft of your building, they're liable. Any other time, my clients are the ones liable to any damage of property. The only time the landlord is liable for damage of property is if they do it intentionally. If they intentionally take the property, if they intentionally destroy the property, if they intentionally damage the property, they do it willfully, wantonly, grossly negligently, then the landlord, Floshea at the point, is held liable. That's the only time they're held liable. And that's what we have in this case. There's no dispute that they should be held liable because according to section 11.5, they did it intentionally and willfully. Took the property in the presence of my clients and others, took all of their property, and then sent it away, discarded it, took it to the restroom, sent it to the restaurant, sent it out to other people. Just got rid of it. Just got rid of it. So I want you to look at that section, look at that part of the lease. That's the one time that they're held liable, when they do it intentionally. In this case, it's undisputed. They did it intentionally. Now, the reason I talk about a contract and being as good as your word is because I remember, growing up, my grandfather was a rice farmer and he used to make these deals with people and he would just shake their hand, right? I was like 8, 9 years old. He would just go talk to people, you shake their hand, I'm gonna give you this much rice, you give me this. I grew up in a small town, Southeast Texas, and my grandfather was a rice farmer. I saw him make deals with people all the time. We just shook their hand. Because the contract is really about being as good as your word. Well, if you tell me something, then I should be able to count on it. If you tell me I have until Monday at 4 o'clock, I should be able to count on it. If you tell me I have until Monday at 12 noon, I should be able to count on it. Right? If you keep cutting it short, if you tell me, hey, you got until Monday at noon, and you don't give me till Monday at noon, you're not as good as your word. If you tell me Monday at 4 o'clock and 4 witnesses tell you that, Mr. Wesley, Mr. Woodard, Mr. Dodds, right? They all tell you that, Miss Dobbs, they all tell you that. They said we were there. We were there at the conversation. They had until 4 o'clock on Monday. And here my clients are getting a notification at 10:40, 10:52 a.m. Stuff's being taken out. There's nothing fair about that. There's nothing right about that. And when one piece you tell me orally, I have until 4 o'clock. Then you put it in writing, I have until noon, and you didn't give me either one of those. That makes what they did unlawful. It makes it wrongful. You gave me a deadline by which to get my, no matter what I said, right? I'm not getting it. Well, I could have changed my mind at 11:50 and been on my way, like, let me get my stuff. Since you said I had till noon, at 9:30, I might have said, I'm not coming to get it because I'm going to try to fight this in court. They may have been on their way to court to file an injunction to try to see if they could stop it. And when that didn't succeed, they were going to be there by noon to get their stuff. Who knows what could have happened? But if you tell me I have until noon, I believe I have until noon. They believe they had at least until noon. They believe they had until 4 o'clock. But they believe in writing they had at least until noon. And what was Ms. Embry said? Well, when they said that it wouldn't be a removal today, well, that might have just been bluff. Puff. He might have realized at 11:45, you're gonna take my stuff. I'm gonna come get it myself. But you didn't give him the opportunity. You said he had until noon. That's what Mr. Flournoy said. That makes the possession unlawful. That makes the taking unlawful. That makes their possession of the property unlawful when you gave them a set deadline and then you broke your own deadline. Isn't that what they're accusing them of? I mean, are you kidding me? You're accusing them, you're saying, we give you a deadline to pay the rent. You didn't pay it default. We're giving you a deadline to pick the stuff up and we break it. Right? I mean, what's good for the goose is good for the gander. You're accusing them of breaking the deadline. You broke the deadline. They had until noon. And when you took the stuff before noon, that made it unlawful. And look, if I get emotional, it's because I've been dealing with these jokers for almost a year. And I know what they lost. They have been on my back because I'm busy and sometimes I don't have time for them, but I understand exactly what they've lost. Could you imagine? I couldn't imagine somebody coming into my office and taking 20 years of my legal work away from me. My closing statements, my things that I've created, things that I've done, how I've creatively done my practice, things that I've championed, just taking it away from me. So we've had some fun in this trial and made jokes, and we've been cordial with the judge. Me and Mr. Williams get to walk out of here and try the next case, and I'm gonna forget about them, right? I'm gonna move on to the next client. I'm gonna stop answering their calls after a while. But right now, in this moment, they've trusted me with their life's work. That was stolen from them. They can't even start over. And she did it while she was looking them in the face, while they were asking, can I have my stuff back? That breaks my heart. So I'm sorry if I seem a little passionate or I seem a little emotional, but I understand exactly what they lost because they put it on me. And sometimes your lawyer has to carry it for you. And it was done right in their face. And it was wrong. It was against the law. It was unlawful. It was conversion and it was theft by taking. Go to the next one. Here's what I told you, Mr. Williams wants you to keep looking at the lease because she doesn't want you to look at Ms. Embry's actions. But what happened is 10/8, May 2nd, all of their business items, all their tangible intellectual property, everything related to their business was taken out. Them and others show up, say, can I have it back? Commissioner, NPU leaders, other lay witnesses say they were asking for it back. Ms. Embry doesn't remember that part. But 4 or 5 other witnesses say they were asking for it back. They couldn't get it back. Go to the next. You saw Ms. Embry's response. Remember that exchange? She said, I never heard a complaint from them. They never wrote me anything. There was never a repair request. There was never anything sent to me. She would have stuck with that until I showed her that literally a week before a lawyer sent a message, which she said was her first correspondence. My client sent her an email. And he didn't just send an email saying I need repair. He sent an email with an estimate from an electrical company about what it would cost to fix everything. And he asked her to fix it. And she responded, you have to accept the property as is, you have to accept the property as is, as is, as is. Well, this was 2022. There was something she had done on the property. It wasn't like that when they took the property. So yeah, they accepted it as is at the point they signed the lease. But when you do something on the property, as the lease explains, you have a duty to handle that, fix it, repair it, make it right. So at the point she took it upon herself to put the electrical box in, to handle the electrical issues, then she had a duty to fix it. It was no longer as is. That was her reliance on that clause, as is. But my clients told her long before they got a lawyer, hey, this is a problem. Go to the next one. So these are all of the things my clients did. Mr. Williams, he's a good lawyer. He's actually a friend of mine. No, it may not seem like it. Me and Mr. Williams go way back. Yeah, it's a friend of mine. But, you know, he wants you to think that my client somehow going to city council was wrong. Well, but no, that's what you do, right? I mean, people go to the city council, people all the time. I've worked in government before. You'd be surprised about the things that people think you can do, right? People go to their city council members, their commissioners, their community leaders, having a problem with the person who owns and runs this business, who owns this property, Is there anything you can do to help? I think the property may not be up to code. I think there might be an issue with flooding, right? I've turned to my landlord, right? I don't have a whole lot under the lease. She's got a lot of rights under the lease. I don't have a whole lot. So I only have a few options. I can look to Georgia law. I can look to my local leaders. I can look to get a lawyer. I can look to do all of these things, all right? I don't want you to see something that was admitted into evidence. When you look at that correspondence between Mr. Lavone and Ms. Embry that she had forgot about, when he sent her the electrical issues, way before the lawyer correspondence, look at the very top of that, because what you will see is a message from Mr. Lavone to Michael Sterling on May 2nd at 5:56 p.m. So they want you to think that he was bluffing about getting a lawyer. They want you to think he was just pretending when he said, I'm getting an attorney. Well, call me, send me an email, 5:54 p.m. May 2nd. Now, if he had called me on Thursday, we might not even be here. But he wasn't bluffing. Mr. Williams wants you to think he was just bluffing. This is just making this stuff up. Now he called me, sent me an email on May 2nd, and you'll see that. So this phantom attorney that he keeps trying to refer to, this phantom attorney, he was looking for somebody. And he wandered into my office and found me. So he wasn't just bluffing or making it up. Right? He was actually trying to find remedies, trying to find a way to solve this problem and seeing what his actual recourse at law was. Go to the next one. Go to the next one. Now, this is what, and you'll have it back with you, this is what we valued it at. Now, I could have gone through we could have been here 3 more days. If I'd have gone through a whole bunch of tax records and accounting records and brought in all kinds of folks to prove up all of these damages and everything like that. But we wanted to keep this succinct. We wanted to keep this directly to the point. And at some point, we had to bring this to a conclusion and trust it in your capable hands. But what you heard from Mr. Woodard was their time. I actually valued it low. Right? When I valued my sketches, I actually valued it lower. I've sold them for as much as $10,000. I mean, as much as $60,000. I could give away all of the credit, all of the artwork. I can never use it again. But I sold them for as much as $6,000. I mean, $60,000. But I valued them at $10,000 because I thought that was more reasonable. Right? And you can see the pictures of everything that was in there, the things that were being taken. Right? You can see the pictures of, you heard Mr. Weston describe how a lot of times they seal these dresses and they pack them down. Like, that's not unreasonable. I mean, how do you value somebody's work of art? And then you also heard Mr. Woodard testify that he had gotten an offer. No reason not to believe him. Mr. Woodard, when he was wrong, he conceded it. She did this, she did that. When he wasn't trying to paint Shay out to always be a bad person. Right? He conceded the point. Right? He was credible, believable. He said, look, somebody offered us $3 million for the business. We were featured in Elle, up and coming designers. We had celebrities at our shows. We had these designs we were doing. We had an award show. We had a potential contract with the city of Atlanta, and all of that was taken away from us. All of these things were taken away. Now I work at Walmart. It's not looking for a payday. I can guarantee you one thing from what I know about this man. He would give all of this up to have his business back. All of it. He's not just out here looking for a payday. He would give it all up just to have Thomas Lavone LLC, all of his artwork, everything back. He would give it all up in a second. So yes, we're asking for damages because that's the only recourse. So when he came to me, I said, well, there's not a whole lot I can do at this point. The only thing I can do is find you some recourse at law. And in civil cases, that's the recourse. File a lawsuit and see if you can get some portion of what you lost back. He'll never get his business back. He'll never get those designs back, the sketches, the artwork. He'll never get any of that back. The things he told you and described in detail that he did, the sketches, the dresses he did by hand with a sewing machine, one by one. the countless hours he put in, he never gets that back. And so, yes, we're asking for damages, $6,884,280.78. Please don't forget the 78 cents. So when you go back to that jury room, I want you to find that they did improperly convert my client's property, that this was conversion. They unlawfully took it, or my clients were demanding possession of it. They did take it. They stole it. It was theft by taking. Because whether you believe they were in lawful possession of it or unlawful possession of it, they took the property and gave it to another with the intent to permanently deprive them of it. And once you find them liable, I'm asking that you either give Mr. Woodard the valuation of the company at the last time someone made an offer, $3 million, or you give him the valuation as he explained what was took, $6,884,280.78. Thank you so much for your time. We appreciate it.
Thank you, Mr. Sterling. So, ladies and gentlemen, you're going to get to go home a little early because it's going to take me long enough working with the lawyers to sort out what goes into the charge that I give you, that I'd be bringing you back out here after 5. It'd be before 6, but after 5. And that's not how we're going to use your time. So what I'd love to do, since we'll finish our charge conference today while you're commuting, is have you back here at 9, but tomorrow is more flexible because it's primarily going to be your deliberations. If you want to start at 9:30, you can start at 9:30. But I'd ask you just to confer right here for a second to let me know what time we should expect the 13 of you back here for me to charge you and then for you to begin your deliberation. My proposal is 9, just like we've been doing it. You had it nailed this morning, but it's an unexpected day. Done. Wow. All right. If you've got a verdict, you could just give me that too. We could skip tomorrow. No, you're not there yet because you don't have the law, and you've received some snippets of it from the lawyers, but it officially comes from me. So I apologize on behalf of everyone involved that we are reaching into your Thursday. As soon as the 13 of you are here and the clock is close to 9, I'll be here well before that. We'll get you out here. So if everyone's here at 8:55, we'll start the charge at 8:55. I'm not saying, a couple of you 2 days ago got here at like 8:10. And you're welcome to do that. It's a wonderful jury room, but that's not my expectation. Just be here as close to 9 as you can. I will charge you and then you will begin your deliberations. Any logistical questions? Same ground rules tonight. Be boring with other people when asked about the trial, other than to grouse about the fact that it's spilling over into Thursday. Doesn't matter why. Hey, I got to do a little bit more on this case. I have a colleague whose jury has been deliberating for 9 hours. They were supposed to be done yesterday. They're having to come back tomorrow. You don't have that. You've got to you're coming back for a little bit tomorrow. So life is good for you all. And they started last week. You guys started this week. So with that, thank you for your time and attention. Any logistical questions? Also, I never talked about this, but you will get a letter at the end. So sometime tomorrow that says, hey, you've been with the court all week long. And that will cover, if you had been telling people for work purposes, I'll be back on Thursday and now you can't, there will be documentation on official letterhead that you've actually been here. If you end early tomorrow, it actually is good for all day tomorrow. You can do what you want with that extra time. All right. Thank you for your time. Go with Deputy Gordon.
Yes, ma'am. Yes. Yeah, there she is. Take it.
All right, you all can be seated. I just need 2 seconds.
charges.
Okay.
Going to, he's going to tell. And that's what we're telling you.
Oh, I wish I did, thanks.
Matt, could you bring it in? Order it in. I got that here. Oh, okay.
Yeah.
No, okay. I was thinking about this one, but I told you water. I don't want to bring it in.
Did you still get this most recent email that they had sent?
Yeah.
Appreciate
it. Yeah, I already emailed that.
So that got emailed?
Yeah, like the last jury charge discussion. Your family's supposed to have these too.
Yeah, no more.
Those are the go.
Yeah.
All right. You all want the charge conference taken down.
Yes, Your Honor.
All right, great. You're stuck.
I'm
So
gonna stop paying her now.
for the one-day Monday trial,
She made me promise her.
I made a promise what they say he worked.
All right.
Listen to all this, it's like there.
it is. Let me share screen again and we will work through it. So the way I like to handle this is that I will move us to the places where I have questions. That may cause me to skip over areas where you have questions and just pull me back to what I skipped over. I have already amended. So if you look at the hard copy, it's going to be a little bit different. It removes the counterclaims and it says that plaintiffs are suing for conversion and theft by taking. So that very first paragraph you'll see, and it doesn't need to say at all anymore right there. Okay.
Are you gonna amend the caption, Judge?
Well, the caption is the caption. I mean, I could take Ms. Embry's name out, but
I don't have a preference either way. I just saw it.
yeah, no, I saw that too. I don't usually, I'm happy to change the caption, but the verdict form, more importantly, is going to only have Floshea as the potentially liable party. And so burden of proof now simply says plaintiffs must prove. It doesn't talk about, well, there's this parallel burden of proof for the counterclaims. The evidence and credibility of witnesses, very standard. Failure to produce evidence. It's a pattern charge. I don't know who propounded it. So raise your hand and tell me why it should stay in.
I know I did for sure.
Okay. Well, I'll start with you, Mr. Williams, because you raised your hand as opposed to simply saying I did. What is it that well, you've already argued? I don't know what it was you argued. Why am I telling this to the jury? I don't recall your argument being, wait a minute, why didn't the plaintiffs present this evidence? You said, look at the lease.
I said, look at the lease. I also said, look at the damages. We have a 2-page summary of $6.8 million worth of damages. Mr. Sterling in his closing said he could have showed you all that backup documentation.
Okay, got it. And as there's similar things on the other side where if you were letting my clients know specifically what the issues were, what you've given us is the September 21st email, which says you need to pay late fees and not, we're going to throw you out.
Yes.
Okay, that'll stay in. How about failure to produce witnesses? I don't feel like we skipped many witnesses. Mr. Flonoy didn't testify, but I didn't hear you arguing saying, look, you really would have heard the truth, but they hid him from you.
No, I would draw that one. You know, that was mine. I know that was mine for sure. I would draw that.
Okay, I'm gonna just strike through it here and I'll take it out later. So contracts, I think I'll leave it in because partly you argued in your closing, this is what a contract is. Our contract is the lease. I don't know that there's a contract that was formed by someone saying, we'll not move your stuff till 4 o'clock, but you argued that, you're free to argue it. But I plan on leaving the contracts, that first one that you see on the screen in. Any objection to that, Mr. Williams?
No, Your Honor.
All right, I'll unhighlight it. Oh, don't do that. So the duty of good faith performance, I poked at you all about that a little bit, but we we were holding up the jurors. I don't think that fits because it's not that kind of contract. So I don't know who asked for it.
Yeah, I agree, Your Honor.
Okay, it will be withdrawn or removed. Modification by course of conduct. I think we've agreed that needs to be in there. I will unhighlight it and I will wordsmith a little bit the next couple paragraphs, but that's the language from 16.000, whatever it was that Mr. Brickman was trying to forward and that Ms. Niles lightning fast got it to me. I have not wordsmithed it yet. It's bulky, but I won't remove the essence of it. I try to make the charges more plain language. And so I'll do that, but the thrust of it will remain in.
And we're fine with that, Your Honor. Mr. Brickman did also email some additional, just one additional email reciting the case law around that. So that might help in your wordsmithing as well.
Okay, I've got the email. I'll look at that. And you all, we'll have a final version that you can look at in the morning.
We're fine with that, Your Honor.
Breach of contract. I don't think that's appropriate. There's not a breach of contract claim. There's a conversion claim and a theft by taking claim.
I agree, Your
I
Honor.
think that's out. So is contract damages. The damages here would flow from the tort of either conversion or theft by taking or both. Any objection to those coming out, Mr.
No, Your
Williams?
Honor, we agree.
Okay. Landlord-tenant relationship. I think that's basic law that they ought to hear. Just explaining sort of how this relationship was formed contractually. Elements of a valid lease make sense. The next two that you'll see at the top of the page on my right, the duty of landlord generally and duty of landlord at time of rental. Those are not incorrect statements of law, but we've got a lease here and no suggestion that anything that occurred through course of conduct would have modified the terms of the lease that I think are what the jury ought to turn to know what the landlord's duty was to keep the premises in repair and what the landlord is liable for and the state of the unit. Because I mean, you had that slide that said as is 4 times on it.
Yes.
And it was an as is lease. So I think those two paragraphs should come out. Mr. Williams?
I think they should come out. There's no claim for default of the lease by the landlords. There's no claim for damages for wrongful repair, incorrect repair, any of that. It's only the stuff.
Right. I think which we'll get to, there is what I need to include is the ability to withhold rent if there was a defect notice given, defect may be the wrong word, a need for repair and that repair wasn't done. That's not what these two charges say.
I agree, Your Honor. I'm
Okay.
fine with that, Judge.
All right. That gets us to duty of landlord during rental. I think it is correct. I don't know. This would be, seems to me more one Mr. Williams would want. I can share it with the jury that there's not a duty to inspect.
Well, I like the last line, Judge.
You do like it or you don't?
He does.
I mean, I'm fine with it, Your Honor, but
Okay.
I do like the
I
last
can be
line.
fine with it.
We'll leave it in. I hadn't highlighted it. I just thought now that we've shifted the litigation a little bit, we talk about it. Liability of landlord generally. I don't think it's relevant anymore because again, damages are not being sought against the landlord because of any illegal or negligent use of the premises by the tenants. You agree, Mr. Sterling?
Yes, Your Honor.
Okay. Any issue if I take that out, Mr.
No, it
Williams?
needs to come out. It refers to defective construction and we don't have a claim for that.
Okay. I wish it would just say defective construction, but it's all these words. Liability of landlord during rental, partial possession. I sort of understood it. It doesn't seem like it fits. Again, it's defective condition of building, liability therefore. No one's suing about that.
I think it should come out, Your Honor.
Okay.
Yeah, I think we covered it, Judge, and I think we covered it in talking about the lease, the negotiated leases, so.
Yep. Okay. Maybe the same result for the next one, liability of landlord for repairs. Again, none of this is by removing it. Am I intending to undercut arguments that landlord was or wasn't on notice about the problem with the wet line over the electrical box? I mean, those are all, that evidence is out there, but your claim is the wrongful, it wasn't a default, and so it was a wrongful termination. I don't think this language speaks to that.
I think, yes, that's fair, Your Honor.
Okay. The jurors won't know it, but they should be thanking you guys for streamlining this. The next one, duty of tenant to notify landlord.
I do think that one should stay in.
Yeah, this is the, well, it's sort of the next two
Next two.
that are getting us,
Because I think, Judge, especially the second one, I think there's a jury question on, and they'll have to, wrestle with it as to whose fault it was. Like, was it the negligence of the tenants or the landlords? I think the jury will have to make that determination in order to get to even the second option for them to consider.
I think that's right, but I think what I ought to give out of the two charges, duty of tenant to notify and landlord's duty to repair, I think I ought to give just what I put in green there.
Yeah, I'm fine with that.
Because the preceding paragraphs are about the ability to pursue damages, and if it's unsafe, they should only occupy the part that's safe. And I didn't hear that was a scenario that arose. It's really this ability to claim a set off, and if they make repairs, recover. And so I think those are what I've highlighted, not that yellow sentence, because there was agreement to the contrary about keeping the premises in repair, other than the envelope, as you put it.
Yes, but Your Honor, the agreement specifies which repairs are whose responsibilities. This paragraph just says repairs. If the tenant makes repairs, I do think it is a nuance that should be recognized in the instruction that the lease does divvy up who's responsible for what and who's responsible for what repairs. This makes a much broader category in terms of repairs in general. I think this is a much more applicable jury charge as it's written for residential lease and how the residential law in the state is versus how commercial law is.
Well, what if it said if the landlord is obligated under the terms of the lease to make repairs, comma, and the repairs are necessary, and then the rest of that?
I'm fine with that.
Okay, I mean, I think that's the issue here.
Yes, Your Honor. I
Okay.
agree. I agree.
So we're not, just so that my notes are clear, we're striking the one that the duty of tenant to notify landlord.
And I think so, but let me just. All right, so I think that struck through. I promise this will look nicer when you get a final one. So let me make this part green too. So everything is, I think that all I need to give from both charges combined, duty of tenant to notify and landlord's duty to repair and set off, would be what's green.
The only phrase that I continue to have a little heartburn about is the premises are in disrepair.
Where I'm not seeing,
Then if, comma, after notice that the premises are in disrepair.
right?
I think I could be okay if we just strike the premises. Then if after notice, comma, and then strike. Yes.
That's it. Yeah, I think that's.
Okay,
fine.
that's fine. Yeah, and disrepair is a weird word anyway,
It
so this makes it more accessible. So basically saying if the landlord had an obligation under the lease, jury decides what that obligation was. Landlord's been notified.
Right.
That's really what that first charge, duty of tenant to notify. And it wasn't the tenants who caused the problem because they were shooting guns through the wall and that's why the wall's leaking. Then if they've been notified and they don't fix it, the tenant has some options here. They can repair it. They can call Mr. Rooter, Mr. Electric. And if they do that, then there's the set off. Okay,
I'm good with that, Your Honor. Thank you.
excellent. Me too. All right. The dispossessory warrant, I don't think that fits.
Agreed, Judge.
All right. Whoops, come back.
You know, I'm used to criminal cases, Judge. We go overboard with the.
Again, better to overcharge it. The harder part is when people are sliding things in and like, wait, I don't have that language. So theft by taking, that's the right language. I'm just going to note for you, I don't want you to be surprised. You left the word unlawfully off your slide. It was appropriates. But of course, it has to be an unlawful appropriation for it to be a theft. Otherwise, there's no crime because there's no unlawful. It was your slide. I'm not going to call it out, but the word unlawfully is going to be in there. Abusive litigation, I think, is the only other thing I had questions about. I wasn't sure who.
That's definitely not mine.
Okay.
Probably, we both at one time had claims for attorney's fees and we've both withdrawn.
Okay,
I
so
think
that's out.
Should be out.
All right.
I did try an abusive litigation case in front of Judge Krause.
How did that go?
It was a bench trial with a pro se defendant.
The quotient verdict I will clean up. It was complicated because at first there was the possibility that there could be a number going in either direction. But I will fix that. I guess punitive damages are still in the mix because you prayed for them.
Yes, Your Honor.
Okay. All right. That's all I had. Did you have things that were in that you wanted out or out that you wanted in, Mr. Sterling?
No, Your Honor, everything's been covered, I believe.
Okay. Mr. Williams?
So,
I wouldn't say, but I'm good with what you're saying.
Mr. Brickman says we're good.
We're good. Excellent. If he says so, we must be. Excellent.
He
I will.
asked you that so he can hold you accountable.
It's all on me now.
I will clean this up. So you know how it works in here. The jurors, of course, will get a copy of this for their deliberations. While I'm reading it to them, the words will be on a big screen. So I found they stay awake longer because I just create a PowerPoint out of the text. So I'll be reading from what you'll have a copy of, the final charge, but kind of paragraph by paragraph. There's no bouncing ball. It'll be on that screen as well. And some of the jurors process that better, or at least keep their eyes open longer if there's something on the screen.
Yeah, I think it works.
They won't have a basis to compare. They'll be their one and only jury charge. Mr. Sterling, anything else on behalf of plaintiffs before we wrap up for today?
No, Your Honor. Thank you, Judge.
All right, Mr. Williams?
No, Your Honor. Thank you.
All right, thank you both for having your witnesses ready. I know things took a little bit longer, but it wasn't because we were waiting around for things. It's just, it is a contested set of facts and there were a bunch of witnesses. Oh, I know one thing. I don't want you to leave till you do it. I want you all to agree what exhibits are in. I'm happy to go down the list of what I think was admitted. And I have a specific request that we use defense one. We need to put your label on it because it was actually admitted as, I think, plaintiff's A, whatever the lease is. But the defense copy is a lot easier to read. And so we should use their version, but we'll just label it plaintiff's, whatever the letter is.
And with the notebook, can we just take out of the notebook what wasn't tendered and then just that notebook go back? That seems like maybe the easiest for them to flip.
Then they'll have the tabs. That's fine. Just leave empty the tabs that were not admitted or remove those.
I'll
But
remove those.
I've got no problem with that. And we'll also make clear defense exhibits are in the binder and things not in the binder are plaintiff's exhibits.
Except for that first plaintiff's exhibit A, which will be the lease.
Right. But I think you need to take it out of the binder and we're going to because they're not going to look for D1. They're going to look for plaintiff's A. And so my request was just to
Take it out.
take it out and we'll get a exhibit sticker and it'll be plaintiff's A.
I do, if the court would allow, I think it would be helpful to make sure that we've all got the same.
You should. Let me tell you what I have as admitted, and then you guys can compare and make sure they're all there because pages were flying. For plaintiffs, I have, let me know when you're ready. A, C, E through I, K, and M through R.
That's what we have, Your Honor.
Excellent. And I didn't see anything in there that shouldn't go back. Some of them are videos. We should send them back so that they know they're videos. They obviously can't play them back there, but I'll let them know if they want to see the videos or hear them again. They tell us they come out here. On defendant's side, I've got 2, 5, 9 through 17, 19, big letdown, no audio, 21, 28, 32, 33, 35, 36, and 37. I'm not hearing the same acclamation. Did you think there were others that were admitted, Mr. Williams? Actually, you were trying to admit things like 4 times in a row. Mr. Brickman, did I track with you?
I didn't catch, did you say 19?
I did. I badmouthed 19 because the audio didn't work on it.
I know that
Yeah,
was.
but it's in, and maybe they'll figure out a way to hear the audio. But yes, 19 is in.
All right.
So otherwise, we're good?
Yes.
Okay. So please, before you leave, try to make a pile of all that. And if you need a sticker, I think they actually exhibit stickers. Well, our court reporter may have one. She's pointing to a little satchel that I thought was a first aid kit. But we just need a plaintiff's exhibit and you can call it A, just pull out of your binder. What was 1? All right, we'll go off the record. I'll see everyone a little before 9 tomorrow. Thank you.
Thank you.